criminal trespass, intimidation, threats, and possible breach of public peace. Threat, trespass, and allegations of
ಅಮೆಝಾನ್ ಡೆಲಿವರಿ ಸರ್.
ಎಲ್ಲಿದ್ದೀರಾ?
ಇಲ್ಲಿ ಗೇಟ್ ಹತ್ರ ಇದೀನಿ ಸರ್.
ಹಾಂ, ಬರ್ತಾರೆ, ನನ್ನ ಮಗ ಬರ್ತಾರೆ. ಎಷ್ಟಾಗುತ್ತೆ ಅಮೌಂಟು?
2006 ರೂಪಾಯಿ ಸರ್.
ಹಾಂ, ಸರಿ ಸರಿ, ಬರ್ತಾರೆ. హలో, అమెజాన్లో చిన్న ఎన్సెటిల్ ఫోన్స్ అయినా అర్జెంట్ వెళ్తే ఫోన్ ఎత్తలేదు మీరు.
సన్నగా పెట్టింటారు.
ఏమన్నా చెప్తా ఉన్నా, అమెజాన్లో వచ్చిన 2000 రూపాయలు తెచ్చుకోవాలి కెమెరాది.
2006 గిరి రారా.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೆಗೆ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್, ಇವತ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ 74 ಮೇಡಮ್ ಸೋಮವಾರಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗ್ಲಿ ಅಂತ ಹೇಳಿದ್ರು ನಿನ್ನೆ ಸಾಹೇಬ್ರು.
ಅಲ್ಲ, ನಿನ್ನೆ ಒಂದಿತ್ತಲ್ವಾ?
ಹೌದು, ನಿನ್ನೆ 96 ಇತ್ತು.
ನಿನ್ನೆ ಒಂದ್ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರು, ಇದಕ್ಕೆ ಕನೆಕ್ಟ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ, ಅದೇ ಹೌದೌದು, ನಿನ್ನೆ ನಾನೇ ಮೂವ್ ಮಾಡಿದ್ದು ಮೇಡಮ್.
ಇದು ಅದ್ರ ಜೊತೆ
ಹೌದೌದು, ಇದೇ ಅದಕ್ಕೆ ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು.
31st ಗೆ.
ಹೌದೌದು, ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ ಮೇಡಮ್? ನೀವೇ ಹಾಕ್ಸ್ತಿರೋದು?
ಅಲ್ಲ, ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನೇ ಆ ಡೇಟ್ ಹಾಕ್ತೀನಿ.
ಬೇಡ ಮೇಡಮ್, ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡಿ.
ಆಯ್ತು. ಸರಿ, ಒಂದ್ಸತಿ ಹಂಗೆ ಕಡ್ಲಾಯಿಸಿ ಆ ಕಡೆ ಯಾರು ನಿಂತ್ಕೊಂತಾರೆ. ನಿಂದಿಲ್ವಾ ಸತಿಂಗು? ಗೊತ್ತಿಲ್ಲ, ಏನು ಹೇಳಲಿಲ್ಲ ನನಗೆ, ಏನು ಹೇಳಲಿಲ್ಲ.
Calendar. Yes.
Fresh matter, my lord. But it may be listed tomorrow because they are threatening to debit money from my account when my seller who has purchased goods from me through a valid GST invoice, he's caught in a cyber crime. So all transactions they've just even taken money.
How does that come before us? What is the classification?
There's a case in the Assam court, my lord, and they have sent us a notice to the.
Do we have jurisdiction over Assam court directing them not to do anything?
But the bank is, my branch is here, my lord.
Go to the cyber command there. That is what has been set up.
We've sent a notice there.
Yes,
Tomorrow,
Mr.
my lord.
Nagmangla election matter not getting listed, Malad. Two memos.
Today again it was moved. Today we said
It's not
2:30.
listed. Could the Lordship take it tomorrow for being spoken to? My only concern is this, Malad. There is one deadline in your Lordship's order.
ಅದು ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಬೇಕು ಅಂತ ಆಗಿತ್ತು. ಯಾಕೆ ಕರೀರಿ ಅವ್ರನ್ನ? ಎರಡು ಸತಿ ಏನಿದು?
So one deadline, Malad.
Inform the others, we'll take it up at 2:30.
2:30, Malad. Great.
Twice they have done.
Or your Lordships could take it up tomorrow morning also because informing them and just to be safe tomorrow morning. Great.
Tomorrow morning ಇಲ್ಲ ಅಂದ್ರೆ ಮೆಮೊ ಇವತ್ತೇ ಮೆಮೊ ಇಶ್ಯೂ ಮಾಡಿ.
There's one matter, Your Lordship, regarding the issuance of the rowdy list to Your Lordship. Rowdy list to Your Lordship.
What is it? Come in the regular course.
That's already.
Yes.
Tomorrow, Your Lordship.
Every third day it will come, Mr. Bhandari.
Listed on Monday for preliminary hearing, but due to my inconvenience, I had a medical emergency. I requested for the next day. And was listed in April. My lords are not worthy of April prayer. I'm requesting for consideration of April prayer or preliminary hearing in the matter.
Notice has been issued.
AGA, but I'm not adding the matter. Proxy counsel was present for us. He only sought by
Monday thoroughly preliminary hearing.
APSC gazetted Probatus matter. Identical matter to yesterday's matter for issuance of.
We don't have time to pass out. Third, 2:30 third. ಒಂದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಕೊಟ್ರೆ ಎಲ್ಲ ಎಸ್ ಕೊಡಿ 2:30.
The foreigners matter, I am in detention. I have no objection to be deported. Your Holiness had asked this matter to be.
Fresh matter, pending matter.
Pending matter, my lord.
Pending matter will come in seniority, please.
Not kindly, my lord. Says in detention for 2 months.
We can't make any distinction between everybody. Everybody wants.
With my lord. Memo, I could.
With my lord's permission, my lord, one matter, there is urgency to, it may be taken at 1:30.
Fresh matter, pending matter.
Fresh matter, my lord.
What is the urgency?
Yes, my lord. My lord, the government is celebrating the Jayanti of Narayan Guruji, my lord. And the Pranavananda Swamiji is made as a guest, my lord. And they have removed the name of the Pranavananda Swamiji, my lord. Today the celebration is at 5 o'clock.
It is their choice who they want to invite. How do we ask them who to invite?
But it is the government machinery.
Can we tell them who to invite, Mr. Counsel?
Oh, yes, that only regarding.
Oh, yes, Allah. Oh, no, adu. Kodi.
Yes.
Yes. Kodi, Bharat. Yes. Position tomorrow. Pending matter will come in seniority, madam. Yes. It was directed to be listed today. Dated. It can't come up like that. If it's a dated matter, it's a pending matter. So other side will not know. Monday. Election to be Monday, tomorrow.
My lord.
Yes.
My lords, the pending matter, my lords, the challenge to timber. My lords, the only difficulty is, my lords, interim order has been granted in 2024, pursuant to which nothing has come, my lords.
You can wait for some more.
My lords, my only difficulty, my lords, timber, my lords, this is a timber license granted. Petitioners have been excavating timber, my lords, without a valid license. They're sitting on an interim order since 2 years, my lord. Have it on Monday, my lords.
Thank you for letting us know the facts. You want us to know the law also at
No,
mentioning.
my lords, I know, my
Please
lords.
give. Come in the seniority.
Title deeds holding the the respondent police authority. All I'm seeking the matter is to consider my representation.
Pending matter will come in seniority. Same thing will apply for everyone.
Fresh matter for tomorrow, Malad.
Hmm?
Fresh matter, Malad.
What is that?
Seeking mandamus to consider representation for allotment, Malad.
It will come in the regular.
Fresh matter, my lord.
Yes.
Fresh matter, externment.
Externment. 3 days will Bharat. Kodi.
Having old experience, my lord.
Yes.
Lords, I have filed an IF for extension of parole, my lord, general parole, my lords. ನಾಳೆ surrender ಆಗಬೇಕಾಯ್ತು. Agriculture purpose ಗೆ 60 days.
ನಿಮ್ದಾದ್ಮೇಲೆ 6 months cooling off period ಆಗ್ಬೇಕು. ಇವಾಗ extension ಆಗಲ್ಲ.
My lord, fresh matter, my lord. Use of loudspeaker as license has been cancelled, my lord. Azan, my lord.
Kodi. Tomorrow, Monday. You're challenging 17. Monday.
Also, fresh matter. So mandamus for direction. The registrar birth and death is refusing to exercise jurisdiction to effect a correction in the death certificate.
Monday.
Because of it. May it have a Monday minutes.
Editor been denied a membership of journalist union, my lord. Media editor, press media editor. He denied a membership of journalist.
He will suit. It's a society.
My lord, kind.
Yes.
My lords, the passport
Tomorrow.
matter, my lord. And the
Two-
petitioner for
my
the
lord,
child,
2:30
my lord.
Fresh matter.
Yes, my lord.
Monday.
My lord, kindly have it tomorrow, my lord.
It will come up, madam. Don't worry. Serve it on Mr. Aditya Singh or Ms. Reshma Ketty. Yes.
Grateful, my lord. Great. Adjournments. List number 1, page number 6, serial number 32. Page number 7, serial number 33 to 36.
34. Serial. Fourth. In week's time.
New Year.
I'm petitioner.
Respondent also.
Respondent, my lord.
Non-filing of details of maintenance amounts.
Filed your, yesterday only served the car. All the better part.
We'll have a look at it, please. We are not adjourning it now. Once it reaches.
130.
Page number 8, serial number 37 to 41.
Yaudama?
Serial number 37, my lord.
37. You're for? Respond number 6 to 8. You have informed everybody? At the request of council for respond number 6 to 8, relist on 24th September.
Page number 9, serial number 42 to 44. 42 to 44. Page number 10, serial number 45 to 49.
49, my lord. And for respondent, my lord.
Respond number?
I'm
Mr.
back talking
Ravindra.
I'm back talking about the petition in this matter.
Yes, Mr. Kirti, any objection?
My lord, kindly, short date may be granted, the date may be fixed.
Short date is 24th September.
My request to lordship to grant, kind of next week or.
Respond number 1, delete BL Sanjeev as that appearing for respond number 1 at the request of council. Council for respond number 1 seeks for and is granted 2 weeks time finally to file a statement of objection. Objections, if any, to be filed on or before 11 September, failing which it will be taken as not filed and matter proceeded with. Relist on 17 September.
Much of it.
Page number 11, serial number 50 to 55. Page number 12, serial number 56 to 59.
59, my lord. For the petitioner, some inconvenience. I have informed the respondent also.
You informed all of them?
58.
You informed all the councils for the respond. 59.
58.
Interim order, my lord.
At the request of
58.
special order. Process fee has to be paid.
My lord, second time it has to be paid. I will take today, sir.
So second time kodalva.
ಕೊಡ್ತೀವಿ ಇವತ್ತೇ.
59.1 learned counsel for the petitioner seeks fund is granted 2 days time to make payment of process fee. If needful is done by 1st September. Registry is directed to issue notice to the unserved respondent returnable by 14th October. If needful is not done by 1st September, relist on 7th September for dismissal.
Serial number 58, my lord.
Interim order of the petition.
Interim order 58.
58, my lord.
At the request of the counsel for the petitioner, 24th September.
Interim order.
Interim order.
Page number 13, serial number 60 to 63. Page number 14.
My lord.
serial num-
Seal number 64, my lord. I am for the respondent number 2. I
Yes.
inform the other side, my lord, petitioner.
At the request of counsel for respond 24 September.
Oblige, my lord.
Page number 15, serial number 67 to 73. Page number 16, serial number 74 to 80.
My lord, serial number 74.
Yes, really.
Item number 89, my lord. I
89.
informed to the other side. I'm the petitioner in this case, my lord. I'm not keeping well.
What is this? Is defreezing matter?
No, my lord.
Not defreezing. 89 at the request of counsel for the petitioner released on 24th September.
My lord, serial number 74, my lord.
Serial number?
74.
For the respondent number 7 and 8 in this matter, Lord. Serial number 74.
74.
Yes,
Yes.
my lord. That Ramakrishna Pillai matter, my lords. Yesterday's matter, my lords, has posted to Monday.
We'll take it up at 2:30.
Monday, my lords.
Monday, na? Adi inna one number ಏನದು?
My lords,
It was yesterday listed, Lord. It was
24841 of 2026.
74 connect with so and so and released on 31st at 2:30 p.m.
Much obliged, my lords.
Most I was.
Lordship's kind permission.
27. At the request of counsel for the petitioner released on 17th September.
Serial number 92, my lord.
92.
Forest matter, my lord.
Yes, madam, 92.
Similar matters are coming up in Court Hall 4, my lord. It is tagged along with that.
IA 1 of 26 is allowed connect with so and so.
Please.
This is that HMT.
Writ appeal number 185.
Writ appeal ge writ petition ಹೆಂಗ್ connect ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಮಾಡಿದ್ದಾರೆ. They have done it.
They can do it, we cannot do it. Our jurisdiction is single judge, single matters. You move it before the DB, if they feel it fit to connect it, they can do it. Not us. Serial number?
99, 101 and 102. Memo for withdrawal.
99, 101, 102 memo for withdrawal. Dismissed as withdrawn. Yes.
List number 1, spoken to, serial number 1. Naveen Kesi, party in person.
Yes. Yes, madam.
My lord, I am for petitioner. Para number 4, my lord.
Para 4.
Ah. 1976 ಅಂತ ಆಗಿದೆ. It should be 1972.
72. Matter has been moved for being spoken to.
Likewise, para number 6 also.
The learned counsel for the petitioner submit that there is a mistake in the year of the enactment which has been typed. The said submission is accepted. Registry is directed to correct the year 1976 to 1972 in the last line of para 4 and in the fourth line of para 6 and reissue a fresh certified copy.
My lord, one more submission. Lordship has directed us to keep all the 672 owners present. Respondent number 2 may be directed to make provisions for uploading of documents of all the 672.
They will have to do.
But without Lordship's direction, they will not.
You know, by the direction beka. Learned counsel for the petitioner expresses an apprehension that since there are more than 600 residents who would be approaching the respondent for registration of the association, the respondent are unlikely to upload all the 600 documents pertaining to all the 600 people, 600 or more people. Whenever any person were to appear before the registrar, sub-registrar for registration, and he is a signatory or a executant to the said document to be registered, it is but required for the respondents to consider the document and upload the relevant documents. The apprehension on part of the counsel for the petitioner, though unfounded, respondents are directed to comply with the applicable provisions and upload all the documents. Peacefully registered. 600 people are coming, they'll have to wait. In all of them are going, power of attorneys are going, how do you?
Adu ಮಾಡ್ತೀವಿ.
There is a trust deficit.
My lord, one more.
If we give a power of attorney, what will they do? All those issues will be there. Or do one thing, Can you depute, because 600 people is going to be impossible in your office. What usually happens is they get it. One or two people. Here there is a trust deficit. Nobody will give them a GPA. One person doesn't trust the other.
I'll verify what can be done.
If it is required, we will nearby one camp there.
At their expense.
At their
Yes,
expense.
yes, my lord, we will bear it.
Otherwise, this will trouble your entire functioning. One officer can go and do it full day rather than here. You expose that.
Lordship, one more prayer.
Hmm.
Annexure G may be returned.
600 Allah, from what was submitted the other day by somebody, madam from BDA, 1,300 and odd apartments in Allah.
No, my lord, only 670.
All of them have to be there, otherwise it won't go through.
Yes, my lord, yes, my lord. My lord, one submission. Annexure G may be returned, my lord. Documents.
Annexure G another.
DOD bylaws.
Originally you have produced. Registry is directed to return any original and or certified copy produced by following the due process. Due procedure.
Fresh matter, serial number 2. Babu Dia.
Mr. Babu. Parola. Mr. Babu DR.
They have sought for mandamus, my lord.
Complaint.
Violation of injunction.
Is there any direction by the trial?
No, my lord. If my lords may kindly see page 32, 31, my lord.
Pass over.
Serial number 3. Prajwal P.
I appear for petition, my lord. My lord, this is a matter, my lord, in which a 22-year-old boy, my lord, was kept in custody for committing no offense. Lordship may kindly see, my lord.
Not before
After
bench. This bench, your lordship
Lord,
said.
this comes
previous-
before the, my lord, single bench, my lord, because this is not a preventive detention order. Earlier, my lord, my colleague made a submission that it is a preventive detention order. But, my lord, that is not the case.
What is this? This is...
My lord, this, my lord, order passed by the executive magistrate, my lord, under section 136 of the BNSS.
BNSS.
Jamin. My lord, it has to go before.
This
criminal,
is
please, criminal
preventive
petition.
detention.
Not a preventive detention order, my lord. Your lordship may kindly see, my lord.
They have to apply for bail, my lord. Your lordships kindly peruse annexure A.
My lord, I am challenging the entire proceedings itself. Because, my lord, only based on a suspicion that I might commit some offense.
Whatever it is, if it's a preventive detention or a preventive this one, it has to go before the division bench.
Your lordship may kindly peruse, my lord, section 128 for a moment.
What is 128?
Proceedings are initiated, my lord, under section 128 and orders are passed under section 136.
The security for...
Please, my lord.
It's not
It's not
preventive detention. 128, 130, all those.
Annexure A, my lord. ಈ ರೀತಿ ದುರ್ವರ್ತನೆ ತೋರುವ ಸ್ವಾಧೀನ ಇರುವುದರಿಂದ
Is not under the Gunda
ಒಂದು
Act,
ವರ್ಷದ ಅವಧಿ 1 ಲಕ್ಷ ಮೊತ್ತದ ವೈಯಕ್ತಿಕ ಮುಚ್ಚಳಿಕೆ ಹಾಗೂ 1 ಲಕ್ಷದ ಒಬ್ಬ ವ್ಯಕ್ತಿಯ ಜಾಮೀನ್ದಾರರ ಮುಚ್ಚಳಿಕೆ.
Security under 130 and you have to pass that order under 130. Earlier 112 and
109 of
109.
In this case, my lord, your lordship may kindly see, my lord, annexure E for a moment, my lord. Page number 30. The police, my lord, apprehend me, my lord, only based on a suspicion that I might commit some offense.
And AGA accepts notice for respond number.
I'm in custody, my lord. That is the urgency, my lord.
1, 2, 3. She seeks for and is granted 2 days time to obtain instruction, make a submission. Pre-list on 31st September.
He's already in custody, my lord.
I'm in custody.
You get the instruction. If he's required to be in custody, he'll continue in custody. If your grounds do not make out any this one, we'll have to get him released.
My lord, may I make one submission, my lord? Section 128 itself says, my lord, if I am concealing my identity, then I can be kept in custody. My lord, I provide all the information to the police.
Counsel, can we release you now without hearing them?
Please, my lord. That is...
Opportunity badwa.
Please, my lord. Hold on.
Serial number 4. Channabasappa SA.
for the petitioners in this case. That's, there are batch of identical matters, my lords. The COVID-19, my lords, the respondents had granted us a rebate. From the impugned notification, my lords, they are seeking us to repay back the rebate amount.
ಯಾರು respondent ಗೆ? BMTC.
BL Sanjeev.
The BL Sanjeev is directed to accept notice for respondent 1 to 3, connect to so and so. When is it posted?
Interim order is there.
Interim order.
Yes, sir. That they will not take any coercive steps to.
Coercive steps for recovery.
Yes, sir.
Same order is that, connect so and so. Date to same.
Great.
Serial number 5.
Mr. Manohar. Anything?
External
External.
opportunity was given.
Yeah.
Petitioner counsel, my lord.
Yes.
Page
My
20.
lord, order of externment, my lord.
Were you given a notice and were you heard before the executive
Yes,
magistrate?
Yes,
You had
yes,
to
my
file an
lord.
appeal.
Yes, please, my lord.
And AGA for respond number 1 to 4, petitioner is before this court seeking for the following relief. Essentially, what has been challenged is an order of externment. Before the said order of externment was passed, the petitioner had been served with a notice and was heard. In that view of the matter, the petitioner is required to avail the statutory appellate remedy rather than writ remedy. Reserving liberty to the petitioner to avail such statutory appellate remedy, the petition stands disposed. Respondents are directed not to take any coercive steps until the appeal is taken up for hearing.
Obliged, my lord.
Number 6. Sudhindra SCF.
For petitioners in this matter, my lords.
Yes.
The direction to issue renewal of passport, my lords. I am no way involved in this, my lords. I am already married and with my husband's house. There was some internal problems with
From the central government. So and so accepts notice for the respondent. Counsel for
only
the
a
petitioner.
direction, my lords. I am only seeking a direction to issue a passport, renew my passport, my lords. Already this honorable court has already stayed the criminal proceedings also, my lords.
You want a ex parte order without even hearing what they have to say.
Please, Monday.
McDonald's fast food is somewhere else.
Only issue is, my lords, she's carrying now. She wants to have a photo shoot in Maldives because she's coming 7th month now. Another 2 months, I think. That for that reason, my lords, kindly have it on Monday.
You want us to have it after 3 months or when do you want it?
No, my lords, kindly have it on Monday, my lords.
Monday.
Highly obliged. I shall.
Serial number 7.
Yes, the petitioner is seeking the relief of writ of mandamus, seeking direction to the respondent to delete an entry in the Kaveri online portal. What has happened is there was an injunction order passed in the MA proceedings, and which ultimately was set aside by this honorable court, and the interim order was
You
vacated.
asked for registration of the setting aside order.
Pardon?
You asked for setting aside the registration order.
Registration, they're not,
setting aside the vacating the interim order.
Order has been vacated.
So you asked for registration of that, not for deletion of the earlier order.
No, they are showing there is an injunction order.
There was an injunction order which will always have to be there on the register. Any aspect which has been registered cannot be deleted like that.
Well, I have given representation to add this also. They are not been doing that.
Consider-
And they are raising objections.
And AG accepts notice for respond number 1 to 3. Petitioner is before this court seeking for the following reliefs. An entry as regards the injunction order passed in OS number 32 of 2018 has been entered in the encumbrance.
Injunction order was passed in MA proceedings.
That we are not allowing. Where was the order passed? MA or OSL?
MA.
MA number?
MA number 40 of 2022.
By third additional senior civil judge, Bangalore Rural District, has been entered in the encumbrance certificate. The petitioner claiming that the injunction order has been vacated may submitted a representation for deletion of the said entry. The said representation not having been considered, the petitioner is before this court seeking for the opposite relief. The encumbrance certificate maintained by sub-registrar is required to indicate all the transactions which have taken place in respect to the said property. An injunction order being one such transaction is required to be part of the register, even if the injunction order were to be vacated. At the most, what the petitioner can claim for is the registration of the order of vacating the interim order and not for deletion of the earlier order of injunction. In that view of the matter, the relief sought for are molded. Respondents are directed to consider the representation of the petitioner, verify the orders passed, and if indeed the order of injunction has been vacated, to cause entry in the register about the vacating of the interim order passed in MA number 40 of 2022 in the register.
The second, them to register, seamlessly register the document, because every time when I present the document, they raise objection with regard to the injunction order.
That is not something that we can consider here. You present it and then you within a period of 30 days from the date of receipt of a copy of this order.
Serial number 8, Somashekar Angadi.
In this case, appear for petitioner sought for writ of mandamus, directing third respondent to initiate disciplinary action against respondent number 1. Since there is a dereliction of power.
And AGA for respondent 2 and 3 issue notice to respondent number 1, returnable by 5th October.
Serial number 9.
Petitioners are the directors of the cooperative societies, my lordship.
Cooperative society.
My lordship, consumer forum has passed a judgment against the petitioner for without fixing the liability, my lordship. There is one judgment of Honorable High Court of Bombay, my lordship. My lordship, for a moment, peruse through this. Liability fix mandilla, Swami. 64 inquiry pending ಇದೆ, CID inquiry pending ಇದೆ. Without fixing the liability, consumer forum directly passed an order.
Consumer order that's fixing the liability is in a surcharge proceedings.
My lordship, consumer, it is a petition.
Jointly and severally.
Jointly and severally, my lordship.
Enough.
My lordship, for a moment, this judgment may be kindly perused. Page number 39, my lordship. Paragraph number 17. Page number 38, paragraph number 17. May I read it, my lordship? If my lordship permits me, I will read it.
Page number?
Page number 38, my lordship.
38.
Paragraph number 17. May I read it, my lordship?
Yes.
Thus, on perusal of the provisions of Maharashtra Cooperative Societies Act 1960, it is clear that a scheme is provided for conducting inquiry and for holding the directors members of the managing committee responsible for any act done by them, which is detrimental to the society. On conducting inquiry under section 88 of 88, the registrar is empowered to access the damages against the delinquent and fix the liability. During the course of the inquiry under section 88, if the registrar comes to the conclusion that the person has become liable for payment of money or the property, or in respect of the restoration of the property or any part thereof, he is empowered to pass an appropriate order on such determination of the amount. The registrar may direct such person by way of compensation in regard to the misapplication, retention, misfeasance, or the breach of trust. As he may determine the amount so arrived, it can also be directed to recovered under section 155 of the areas of the land revenue. Thus, it is clear that Maharashtra Cooperative Societies Act provides a scheme for holding an inquiry.
As regards the inquiry by the Registrar of Corporate Society.
Lordship,
in surcharge proceedings there. Lordship, it could be here. It is a order passed by the consumer court.
Lordship, this judgment ಅಲ್ಲಿ ಏನು ಹೇಳುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸರ್ಚಾರ್ಜ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಲಯಬಿಲಿಟಿ ಫಿಕ್ಸ್ ಆಗದೆ ಕನ್ಸ್ಯೂಮರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೇರವಾಗಿ ಜಾಯಿಂಟ್ ಲಯಬಿಲಿಟಿ ಮಾಡಬಾರ್ದು ಅಂತ.
ಕನ್ಸ್ಯೂಮರ್ ಫೋರಂ ಯಾರು ಹೋಗಂಗಿಲ್ಲ, ಸರ್ಚಾರ್ಜ್ ಪ್ರೊಸೀಡಿಂಗ್ ಮಾಡಬೇಕಾ?
ಮೈ ಲಾರ್ಡ್ಶಿಪ್,
ದಟ್ಸ್ ನಾಟ್ ವಾಟ್ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸೇಸ್.
ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ಇನ್ ದಿಸ್ ಕೇಸ್
issue was different.
No, my lordship, the fact of the case, the scenario, everything is similar, my lordship. Swami, ಸರ್ಚಾರ್ಜ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಪೆಂಡಿಂಗ್ ಇರುತ್ತೆ, CID ಎಂಕ್ವೈರಿ ಆಗ್ತಾ ಇರುತ್ತೆ, ಕೆಲವರು ಕನ್ಸ್ಯೂಮರ್ ಕೋರ್ಟಿಗೆ ಹೋಗಿ FD ಅಮೌಂಟ್ ರಿಕವರಿಗೆ ಅಂತ ಹೇಳ್ಕೊಂಡು ಪೆಟಿಷನ್ ಹಾಕ್ತಾರೆ. ಕನ್ಸ್ಯೂಮರ್ ಕೋರ್ಟ್ ಜಾಯಿಂಟ್ ಲೈಬಿಲಿಟಿಯನ್ನು ಫಿಕ್ಸ್ ಮಾಡಿ ಪೆಟಿಷನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡುತ್ತೆ. ದಿಸ್ ಜಜ್ಮೆಂಟ್ ಈಸ್ ಕ್ಲಿಯರ್ಲಿ ಸೇಸ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಅಥಾರಿಟಿಯಿಂದ ಎಂಕ್ವೈರಿ ಆಗಿ ಲೈಬಿಲಿಟಿ ಫಿಕ್ಸ್ ಆಗದೆ ಕನ್ಸ್ಯೂಮರ್ ಕೋರ್ಟ್ ಕ್ಯಾನಾಟ್ ಜಂಪ್ ಇನ್ ಟು, ಯಾಕಂದ್ರೆ ಕನ್ಸ್ಯೂಮರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಮರಿ ಟ್ರಯಲ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. My lordship, in page number 40, it is clearly explained, my lordship, why the consumer court cannot jump and fix the liability, my lordship. Page number 40.
What is the matter before that court?
Fifth
What is the
paragraph.
issue?
In my view, the Consumer Protection Act does not prescribe modalities for holding inquiries against the directors in respect of the acts or omission committed by them. Unless the members of the managing committee are held responsible for any act detrimental to the interest of the society or inaction on their part which caused wrongful loss to the society, they cannot be held responsible to contribute the loss in respect of the liability, which is required to be borne by the society. The forum created under the Consumer Protection Act does not provide for an audit, inquiry, or inspection as laid down under Section 81, 83, and 84 of the Maharashtra Cooperative Societies Act, nor provides for any methodology for assessing the damages against the members of the managing committee as contemplated by the Section 88 of the Act. The members of the managing committee or the directors cannot be held responsible in their individual capacity. The complaint can be instituted against the society before the consumer forum by depositor or member of the society and can be also be granted as against the society. However, so far as the members of the managing committee are concerned, they stand on a different footing, and unless the procedure prescribed under the special enactment Maharashtra Cooperative Societies Act is followed, and unless the liability is fixed against them, they cannot be held responsible in respect of the payment of any dues recoverable from the society. My lordship, even National Commission also upheld this judgment, my lordship, in the recent judgment, my lordship.
That's a different issue altogether, Mr. Counsel. This is a different issue. This is where the complainant had invested in a fixed deposit, the amount was not refunded. That is why he went to the consumer forum for refund. For that, the person doesn't need to know who is the person responsible in your board of directors. The cooperative society is a legal entity who is required to do it. You want to pay the entire thing, you can pay and recover it from others, but you can't say that you have to distribute among the directors. That is not something which will apply to you.
For a moment, my lordship, facts of this judgment may be pursued, yes, my lordship. Similar case, my lordship.
Yes.
Page number 23, my lordship. The complaints in all these matters, respondents herein are the depositors of the cooperative credit societies, banks who have not been refunded the amount of deposit by the concerned credit societies. After completion of the term, along with the directors of the cooperative societies, the complaints have impleaded the concerned credit societies, banks in the complaints presented to the consumer forum, and the district consumer forum has issued uniform direction all these cooperative societies as well as the directors to refund the amount along with the interest as well as damages. The petitioners have objected to the orders passed by the consumer forum, raising two principal grounds. Either the first ground they have disputed the jurisdiction, my lordship. That ground is not nullified,
rejected.
Second ground is highlighted by this said Bombay High Court, my lordship. It is
we are not in agreement with this.
Lordship. ಯಾಕಂದ್ರೆ CID inquiry pending ಇದೆ, my lordship. For a moment, annexure
ಆಗ್ಲಿ ದುಡ್ಡು ಕೊಡಿ.
Liability fix ಆಗದೆ.
Person who is you have taken the money and you are not paid, you don't.
One humble submission. Petitioner is the one who filed complaint, my lordship.
Issue notice to respond number 1, returnable by 5th October.
Interim order may be granted.
Interim relief which have been sought for is rejected.
My lordship.
For the reason that the interim order has been sought for on the ground that without fixing the liability on the directors, a joint and several finding could not have been rendered by the consumer forum. The respondent having approached the consumer forum with a complaint, consumer forum having a jurisdiction to decide on the same, it is not required for the consumer forum to await any orders passed in a surcharge proceedings to determine the liability of each of the directors before passing any orders. Hence, the contention of the learned counsel for the petitioner.
May I make one more submission?
The order dated. The order dated 22nd December 2010 in WP number 5223 of 2009 by the High Court of Judicature of Bombay at Aurangabad is rejected.
So one humble submission, lordship. Petitioner, in fact, he is the one who highlighted this mismanagement.
Good that he highlighted.
Well, on the other hand,
at least somebody highlighted your defaults. Yes.
Serial number 10, Ankit Jain.
This matter would have to go before Honorable Justice Shyam Prasad, my lords. This is the ART age relaxation matter. The coordinate bench
Pending consideration. Ms.
Pending-
Sadhana Desai accepts notice for respondent number 1 and AGA for respondent number 2, 3. Connect with WP number so and so.
My lords, my lords, rather than connecting it, my lords, the difficulty is that is reserved. If it may be only listed next week before that court.
We can't say listed before that. That court can say that, not us. We can only say connect.
Submissions that to be made in that. If this could be listed in that.
We can say connect. We can't say
Very well, my lords.
listed
It has to be
before.
connected with 14671, but that's reserved, my lords. That's the. My lords, could I make one request, my lords? On Monday, there is the surrogacy single woman, my lords, brain tumor matter listed that their lordship had ordered for Mrs. Desai to take instructions. It's coming in the B group and not getting, it's not reaching, my lords, before your lordships. That could be at 2:30 or in the fresh matters on Monday. It's already listed for
What is
Monday.
your submission?
My lords, there is another case where a single woman, my lords, age relaxation under the Surrogacy Act. And there, my lords, it is not connected with that batch. It's listed for Monday before your lordships. If that could be taken up at 2:30 or.
Let us see when it is listed on Monday. You are moving today.
That's coming in the B group, my lords. It's not reached from the last 2 dates. That's the. As per their instruction.
Serial number 11, Joseph Anil Kumar.
Petitioner's lordship. Seeking for short adjournment in this case, your lordship. Seeking adjournment, your lordship.
Adjournment. At the request of counsel for the petitioner, relist
Next
on
week, your lordship. Any day.
17th September.
Not sure.
12.
Petitioner in this case. The petitioner is aged about 77 years. The petitioner executed the gift deed as per annexure A to his son. He is a third respondent. And the third respondent, my lord, the neglected to petitioner to maintain his parent. Hence, my lord, the petitioner has filed the application before the second respondent for cancellation of the gift deed. My lord, the second respondent, my lord, passed the order on 16/10/23, my lord, the direct the third respondent to pay the 5,000 rupees per month. And my lord, cancellation of the sale
AGA
deed.
for respondent number 1 and 2 issue notice to respondent number 3 returnable by 6th October. Respondent number 3 he is restrained from any manner alienating, dealing with, encumbering or changing character of the subject property till the next date of hearing. Process fee and copies to be furnished by end of day 29th August, failing which the interim order will stand automatically vacated.
The interim order?
Restrained from alienating.
13. Harshavardhan B. Sharma.
Maintainability anything?
Petitioner is a resident of Bellary.
ಪಾಸ್ಟ್ ಟೈಟಲ್ ನಲ್ಲಿ ಅಡ್ರೆಸ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ಐ ವಿಲ್ ಚೇಂಜ್ ದ ಅಡ್ರೆಸ್ ಯುವರ್ ಆನರ್. ಬೆಂಗಳೂರಲ್ಲಿ ಆಫೀಸ್ ಇದೆ ಅವರು.
Counsel for the petitioner seeks for and is granted a week's time to file amendment application. Relist on 7th September.
14. Harish Srivastava.
Harish Srivatsa. Mr. Murli.
Petitioner.
Yes.
As a writ of mandamus, the short facts are like this, my lord. The petitioners are all purchasers of commercial space developed by the second respondent company claiming to be a developer. The cause. Fourth respondent. The fourth respondent, this company called Vikram Structures Private Limited.
Any conflict? Vikram Structures. Who is
The name is one Mr. Prabhakar is the developer, is the promoter. Lordship is.
Somehow it seems familiar, but not sure. Please, sir.
But what I'm, of course, there are allegations of fraud and multiple sale. The whole thing is come out. The facts are like this, my lord. So this company has gone into liquidation now, based on a petition brought by the creditor, who later we find are in collusion with the company itself, my lord. What has happened is these the petitioners are victims of this multiple sale. I mean, the company had about 82,216 saleable area. They claim to have sold 3 times about 2,43,000. Same units have allegedly been sold to multiple people.
Same.
Yes, same units, multiple people. So out of 82,216 square feet, which was the available area for sale with this company, They are claimed to have executed 164 sale deals, registered, selling 2,43,037 square
1
feet.
and 2 to conduct investigation.
So what happened, my lord, when the matter came before the NCLT, they admitted this, and finally they even ordered liquidation. So what has happened, my lord, the same promoter of this company has come back and said he has become the highest bidder. He claims to be the bidder. There's a lot of conspiracy
Five
going
bidders.
on. In the course of all this, the petitioners also filed an application before the NCLT under section 213 of the Companies Act. Any stakeholder can come and say,
SFIO.
I want an investigation done, which was ordered, my lord, way back in December 2023, my lord. Now 2.5 years have passed. Nothing is forthcoming.
I'll take instructions.
2.5 years.
The difficulty, my lords, is that they have served it through online, the petition papers. It's only in part. There are 6 parts
Give one
is
more
what we are
point.
told. It is not there. The complete set is
Once accepts notice for respond number 1 to 3.
1 to 3, my lords.
Notice to respond number 4 and 5 is deferred for now. Counsel for respond number 1 to 3 seeks for and is granted a week's time to obtain instruction and make his submission as regards the status of the inquiry by the respond number 2. SFIO ಯಾರು?
SFIO ಇನ್ನೂ ಆಗಿಲ್ಲ. They have only, the NCLT
the-
said, now our prayer is if you can't do it, refer it to SFIO.
By respond number 1 and 2. By status of the investigation. By who? By status of the investigation.
What is
They
happening?
they may be directed to serve the papers, my lords. I don't.
ಈಗಲೇ ಕೊಡ್ತೀನಿ. ಅಲ್ಲೇ ತಗೊಳ್ಳಿ. With marking and all that.
Thank you.
It'll make it easier for you to
You
understand
can,
what is the
what
important.
are my relevant?
Realist on third.
Online, my lords, comes with certain difficulties. That's the reason.
What
They've only sent 2 parts of their big petition. The other 4 parts are missing.
4 parts.
I think
6 parts is what I'm told.
ಇದೆಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ. I think everything.
Don't send it by, we have had classes on this also. You don't need to send it by email. There is sendfile.com. Adella ide. You can upload a 1 GB file and send a link. They'll download it.
Like a zip they can send.
Not even a zip. Usendit.com, sendfile.com. There are some
Third-party
they
websites.
had
which
made
support-
identification of some 10-15 of them. You just upload the entire file as a PDF. They'll get a link. They'll download it from there as it is in the same quality. Kodi pen drive kodi. One free pen drive at each service cell.
Necessary, we'll give that also.
Then problem is what to do with all those pen drives.
Third, the interim order we have sought is at least let the liquidator not continue to dissipate the assets, my lord, because the NCLT is saying if whatever the liquidator does is subject to the outcome of their investigation. That is not coming. Subject to tomorrow, it
Let us
may
get
become a
1 week there.
All right, all right.
Great. Also make your submission as regards the protection of the property.
Please,
Because in effect, if the property gets disputed, then there's nothing which remains.
Tomorrow is nothing left.
You can't do anything.
Yes. Grateful.
Grateful.
My lord, one submission, serial number 13. Should
Yeah.
I file a application or can I rectify it in the registry?
You have to file an amendment. It all entered now.
ಇನ್ನು notice ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ.
Notice agilla, and then if there's only an objection raised, you can rectify. Once it is cleared, the entry is made in CIS. Unless the amendment order is passed, it can't be done.
15, Vijeta Nayak.
Yes.
It's a writ of mandamus, please, Millets, for a direction to release the pending bill in respect of construction work, please, Millets.
KREI, Chris Yarrow,
Pura.
and AGA for respond number 1, so and so for respond 2 and 3. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the work having been allotted to the petitioner and a work order having been issued in pursuance of a tender invited by respond number 2 and 3, the petitioner has allegedly completed the work and raised as invoices which have not been paid, in pursuance of which the petitioner had submitted representation on 13/3/2024 at annexure N, which has not been acted upon, and the performance bank guarantees have also not been released. A representation having been submitted by the petitioner for payment of money it was required, payment of dues, alleged dues on a bill raised, It was required for respondent number 2 and 3 to have considered the said representation and either paid the money or refused to make payment of the money, but in both cases accompanied by reasons. Refused paid the money or indicate that no money is due and liable to be paid. In both cases accompanied by reason. Neither of them having been done, this court passes the following order. Writ petition allowed, a mandamus is issued directing respondent number 2 and 3 to consider the representation of the petitioner dated 13/3/24 at Annexure N and pass necessary orders within 30 days of the receipt of a copy of this order. It's made clear that this court has not expressed any opinion on the entitlement of the petitioner. Same would have to be considered on the basis of the contractual documents and the bills submitted and certified by the concerned authorities.
Recent representation at annexure Q and R, please.
Till bari N hakidira. N as also
Q and R.
Q and R in date N.
Recently we have given.
Recently and the date ilwala.
Ide 2/7/2026.
Q.
Page number 47. 45, page number 45, 29/6/2026.
Where is the date, Mr. Counsel?
Ide. 29/6.
26/26 at annexure Q. Last till bardira date.
Please.
And
R. Annexure R.
Respectively.
Serial number 16, Aditya SK.
Petition for premature release, my lords. Advisory board has recommended, my lords.
I'll seek instruction, ma'am. Kindly have to.
26 is allowed and AGA for respondent released on
Third, my lord.
third.
Please, ma'am.
17, Sharath S. Gowda.
Appear for the petitioner.
The petitioner is owner of a plot. The authorities of Karnataka Slum Development Board, my lords, on the premise that this falls within survey number 11 of Lagere village, lords are constantly interfering with the petitioner's construction over the property. If your lordship sees annexure A, this is wholly without jurisdiction, my lord. They go and give a complaint to the police. But these Karnataka Slum Development, they are concerned with development of the slum area and rehabilitation of the slum. They cannot.
If the property belongs to them,
No,
they
no,
can
no,
always
lord.
do
That is, there is no, they are not backed by any prior documents. There is no prior survey.
Learned AGA for respondent number 1. Slum Development Board here.
HL Pradeep Kumar.
HL Pradeep Kumar for 2 and 3. AGA for 1 and 4. Counsel for the petitioner to furnish 2 sets of the petition along with annexes on said counsel. Pre-list on 7th September.
18, HC Shivramu.
May request in preliminary hearing, my lords.
Preliminary hearing, yes.
For the petitioner, your lordship.
Compassionate.
Compassionate.
Rejection 77.
Thanks, sir.
And AGA for respondent number 1 to 3. Petitioner is before this court seeking for the following leaves. The petitioner father was issued an authorization to run a fair price depot at Satyavara village comprising of Mutsandra and Sanhalipura in the year 1987-88, which has been renewed from time to time and is in currency until 31/12/2030. Unfortunately, the petitioner's father expired on 25/26, leaving behind his wife and 3 children, one of whom is the petitioner herein. The petitioner, with the no objection of his mother and other siblings, had made an application for transfer of the authorization issued in the name of his father on compassionate basis, which came to be rejected by the respondents on the ground that the father of the petitioner was aged more than 65 years as on the date of his expiry, and as such, the authorization could not be transferred. This court, in a catena of decisions, has held that it is the age of the transferee which is required to be considered, not the age of the deceased authorization holder. The petitioner is 37 years old as on the date of the filing of the application, which is within the permissible limit. In that view of the matter, this court passes the following order. Writ petition allowed, a certiorari is issued. The endorsement dated 7/8/26 issued by respondent number 2, bearing number so and so at annexure B is quashed. A mandamus is issued directing respondent number 2 to consider the application of the petitioner in terms of the observation made here and above as per the age of the petitioner and process the same within a period of 30 days on date of receipt of a copy of this.
My lord, let him submit the no objection from other legal as.
Needless to say, the petitioner would have to comply with all applicable procedure, including submission of such no objection and or indemnity deed from the other members of the family.
Grateful.
The
19,
period of 30 days will be calculated from the date on which the said documents are submitted.
Mahesh Kiran.
Appearing for the petitioner in this matter pertaining to renewal of passport, my lord, on the ground that, my lord,
This passport. Central government care. One of you can always stand up. Mahesh Arkulgud accepts notice for respond number 1 and 2, 1, 2, 3. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel. Released on 7th September.
obliged.
20, M. Venkat Reddy.
Yes.
Legality and arbitration.
Tender
notification issued by the government. Annexure C.
Yes.
So the entire notification has issued against the principles of natural justice on the basis of the
Tender notification is against natural justice.
Yes, on the against the KTPP Act. Section 6 of the KTPP Act, procurement entities to follow the procedure.
What is not been followed?
So kindly see the annexure E may kindly see.
Page number?
Page number 71, section 6. Procurement entities to follow procedure. No tender shall be invited. In page 71. No tender shall be invited, proceeded, or accepted by a procurement entity after the commencement of this act, except in accordance with the procedure laid down in this act or the rules made thereunder. So the read with rule 21, 24, and 27. So kindly see the notification issued at annexure C may kindly simulate. So what the class, firstly class 3 made performance capability. So
page number now
page number 28 start agate. The bidder should have manufactured, supplied and commissioned satisfactorily items such as 2-tier carts to the extent of minimum 80%. Within bracket 40% with respect to micro and small enterprises of the quantity or value of the bid amount put to tender to state or the central government organizations in Karnataka in any one of the preceding 3 financial years. Then 4 may kindly simulate manufacturing capacity. The bidder should have their own manufacturing unit in India for manufacturing. See, this notification is issued for favoring a particular person, so not for the entire bidders.
Whole of India is not restricted, Mr. Counsel.
So kindly see the
have their own manufacturing unit in India for manufacturing of steel furniture.
So particularly kindly see the class 10(3) minute ink page 30 starts. So particularly the bidder under no circumstances will be allowed to update, amend, or furnish additional documents in support of eligibility criteria, specification, etc. after opening of the technical bidders. Only the documents submitted through Karnataka Public Procurement Portal will be considered for the evaluation of the bids. Particularly, however, the tender inviting authority reserves the right to seek clarifications, additional information document from the bidder for cross verification during the course of evaluation if necessary. So therefore, my lord, the totality of the bidders cannot participate because of this reason. Particularly a person so who is colluding with the authority have published this. Then kindly see the class 16 ink page 25 16(5) may kindly see. The procedure may page 29 minute
29
29 class 16.5 minute. The purchaser may waive
29 ಅಲ್ಲಿ 16.5 ಯಾವುದು ಇಲ್ಲ
16 20 Oh, sorry, my lord, 35.
16.5 is at page 35.
35.
Yes.
Clause 16.5 may kindly speak. The purchaser may waive any minor informality or non-conformity or irregularity in a supporting document being submitted against meeting the eligibility criteria under clause 9, which does not constitute a material deviation from the eligibility criteria and technical specification requirement prescribed, provided such a waiver does not prejudice or affect the relative ranking of any tenderer. For this provision, the tender inviting authority or the tender accepting authority or the tender scrutiny committee may seek bona fide clarification from tenderers during the evaluation of tender under Rule 23(3) of the Karnataka Transparency. Then may not. So
Mr.
kindly
Reddy,
see
what
the-
is your submission? You are reading the clauses. How are those clauses attracted to this case?
So kindly see the regarding regarding the financial capacity and the manufacturing capacity for submitting the tender, and then evaluation section of the technical bids. So for which I have already given representation under Rule 15 of the at Annexure D. So they have not taken any steps so far made. The technical bid will be opened on Monday, 31st minute. Today is the last date. So, they have particularly the tender process will be made only within Karnataka. It does not apply the Act under Section 6 of the KTPP Act. So there, for which there are so many judgments also I have quoted, Miller. Tender condition cannot create artificial and disproportionate barriers. Vanishma Technology Private Limited or State of Chhattisgarh, Supreme Court. Then Reliance Energy Limited. So that is regarding a public procurement must preserve a level playing field, legal entertainty and arbitrariness. So then Michigan Rubber Limited was State of Karnataka. Tender authority has latitude, but judicial review lies where the action is arbitrary, discriminatory, malapplied, and unreasonable, subject to fair, equal, and non-discriminatory treatment. So then Union of India versus Bharat Forge Limited, the equal opportunity and a level playing field remain relevant in public procurement. So therefore, unless and until they review the notification, it cannot publish.
You have not been able to hear any ground which can come to your rescue.
So on the KTPP Act,
and AGI accepts notice for respond number.
It is arbitrary
One,
and
two,
unilateral.
three.
So subject to, my lord, the prevention
One
of
to six.
publishing the tender, technical tender and the financial
You
tender.
ಹೇಳಿರೋದು 80%.
Yes, ma'am.
They can do that. Next ಇರೋದು that they have to have a manufacturing
There is no
facility across India. There is
Fair
no
and
restriction.
arbitrariness cannot.
What is arbitrary?
So that is the KTPP Act under the.
KTTP Act is arbitrary.
Under Section 6.
ಏನ್ arbitrary ಅಂತ
The
ಹೇಳಿ.
arbitrary while issuing the notification.
What is arbitrary? What clause is arbitrary?
Class 10(3) and 23(3), my lord. So particularly the 10(3),
Shall not be able to update. How is it arbitrary?
So particularly 10(3), however,
They can seek for clarification. That is their entitlement.
we have already submitted a representation, my lord. 10(8) itself, so far they have not taken.
You
steps
can give any
at Annexure
representation.
D, my lord. I have already.
Interim order sought for is refused.
So I have already.
List on
So
24th September.
31st, the open.
The respond, it's made clear that the respondent will be free to go ahead with the tender process as fixed.
So subject to
Not
decision
subject.
of the.
There's no ground that you have made out.
So subject to decision of the.
Not at all.
Consideration of the.
21.
Writ petition.
Appear for the petitioner's counsel.
Kindly
Hello.
kindly have it on first or second minute.
They'll file their objections after 4 weeks. There's no other.
Pertains to banking regulation.
Next matter ತಗೊಂಡಾಯ್ತು Mr. Reddy, you are not, ನಿಮ್ಗೆ ಇಷ್ಟ time ಕೊಟ್ಟನು, you are not able to make out any ground. We give a long rope, but if you are not able to make out a ground, we can't help you.
Actually, particularly the notification issued is very arbitrary.
We are looking at if we can, if the petitioner deserves an order, we'll look at it. But if there's no ground made out, we can't grant you an order for just because you asked for it. Agala. Yes, Mr. Patil?
It's under the Banking Regulation Act 10A.
I'll accept notice, my lords.
You'll accept notice? Ms. Nayantara BG accepts notice for respond number 1, 2, 3. Manik BT for respond number 4. AGA for respond number 5, 6. Chikmagaluru District Cooperative Bank, yarida DCC Bank.
That's, I take notice, your lordship, direct emergent notice and hands.
Issue emergent notice to respond number 7. Yavatida adu?
17-9.
Written up by 17-9. Counsel for the petitioner is also permitted to take out hand summons on respond number 7. Sorry, idhak munche, since the virus of the amendment to section 10 capital A bracket 2A1 or the Banking Regulation Act 1949 and the amendment directions dated 25/5/26 has been challenged. Issue notice to the learned Attorney General. Ms. Nayantara BG accepts notice on behalf of the learned Attorney
Please, my
General.
lord.
She also accepts notice for respond number 1, 2 and 3. Baki ella same irutte. Idi order copy idea. Same order. Connect to so and so.
Please.
I'm grateful.
A1 of 26 is allowed.
22. Sandhya Yu Prabhu.
Yes, madam.
Annexure F is H is challenge, my lord. Annexure H, ink page 29, my lord. But matter, my lord.
In page 39.
29.
29.
I sought for the opportunity of cross-examining the PW and further cross-examination. Application was filed, my lord, which was the application.
Where is the order sheet, madam?
Order sheet, my lord, itself is not provided. That is what, that, my lord, I am before the court for that.
Produce the order sheet, madam. And AGA accepts notice for respond number 1. Notice to respond number 2 is deferred for now. And AGA is direct secure the order sheet of the concerned file by next date, released on 3rd September.
Interim order, my lord.
No interim order, madam.
Lord, the reason is endorsement notice.
We'll see the order sheet and then decide what to do.
Please.
Because you have not produced it. It's available online. You can always
Order sheet,
take it.
ಅದಕ್ಕೆ ರೀಸನ್ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. ಆರ್ಡರ್ ಶೀಟ್ ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇಂಕ್ ಪೇಜ್ 29, my lord. ನಾನು ಕೇಳಿರೋ
Online
document
order sheet ಇದೆ, ಪ್ರಿಂಟ್ಔಟ್ ತಗೊಂಡ್ಬೋದು, ಪ್ರಿಂಟ್ಔಟ್ ತಗೊಂಡು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ. ಅದು ಆರ್ಡರ್
ಇಲ್ಲ
ಶೀಟ್
ಅಂದ್ರಲ್ಲ.
ಅಲ್ಲ, ಇದು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇರೋದು ತಂದಿದ್ದೇನೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ
ತೋರ್ಸಿ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ.
ಪ್ಲೀಸ್
ಕೊಡಿ. Where's the order sheet page number?
ಇಂಕ್ ಪೇಜ್ 33, my lord. Annexure J. ವಿಚಾರಣೆ, my lord, ಬಿಫೋರ್ ದಟ್ ಆಕ್ಷೇಪ ಸಲ್ಲಿಸಲು ಅವಕಾಶ ನೀಡಿ ವಿಚಾರಣೆಯನ್ನು ಒಂದು ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಬಟ್ ಒನ್ ದಟ್ ಇಸ್ 29/8, my lord.
36/22, 26/9, 16/1, 13/2, 25/9. You've been doing this for last 4 years.
ಇಲ್ಲ, ನಾವು ಅಪ್ಲಿಕೆಂಟ್ ಅಲ್ಲ.
Just posted for argument. Then you filed an application.
Lord, I had sought for, I have the documents, my lord. I'm the hereditary object, my lord.
Then you
And
keep
the
the
person
document
who's
with
claiming,
yourself.
my lord.
Madam, you have kept this matter pending for 5 years now for no reason at all.
I got impleaded, my lord. I'm the respondent.
When did you get impleaded? When did you get impleaded?
Lord, I got impleaded, my lord, 2022, my lord.
That is 4 years.
Please, my lord. Evidence affidavit was filed on, my lord, 23.
notice to respond number 2 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the application filed by the petitioner to further cross-examine the applicant's witness has not been has been rejected. A peril of the order sheet would indicate that the matter was posted for
18/10/25 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ ಸ್ವಾಮಿ ನಾನು
18
10/25 ಇನ್ ಪೇಜ್ 27
18/10
25
18/10 ಇಲ್ಲಿದೆ. Had been posted for argument way back on 16/1/2023, and thereafter the matter had been adjourned on several occasions. It is only on 18/10/25 that the petitioner filed an application for reopening the evidence and for cross-examination. Thereafter also, the petitioner took multiple adjournments. The application having been filed during the, after the matter was posted for arguments, the petitioner having been impleaded in the proceedings in the year 2022, reopening application having been filed on 18/10/25 after nearly 3 years, has kept the matter, has resulted in the matter being kept pending for the last several years. No
Endorsement.
grounds being made out, the petition stands dismissed.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕಾಪೀಸ್ ಕೊಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಕಾಪೀಸೇ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನ್ ಕಾಪೀಸ್ ಕೊಡ್ಲಿ?
ಅದೇ ಯಾವುದೇ ಕಾಪಿ ಅದೇ ಈಗ ನಾನು
ನೀವು ಇಂಪ್ಲೀಡ್ ಆದ್ಮೇಲೆ 3 ವರ್ಷ ಆದ್ಮೇಲೆ ಎದ್ಬಿಟ್ಟು ನಮ್ ಕಾಪೀಸ್ ಬೇಕು ಅಂದ್ರೆ
ಇಲ್ಲ ನಾವು ಯಾವುದೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೇಳಿದ್ರು ಕೊಡೋದಿಲ್ಲ ಸ್ವಾಮಿ. ದಟ್ ಇಸ್ ವಾಟ್ ಇಸ್ ದ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಗಿವನ್.
yes next
ಪ್ಲೀಸ್
53 Purnima HS.
yes madam.
Well, this is a matter seeking masking of my name from the search engines of respondent number 2 and 3. This annexure D and E displays my name, my lord. That is the screenshot.
Respondent number 2, you have to change the name, madam. It is Google LLC who has to be made a party.
I'll do the needful, my lord, if there is a mistake.
ಅದ್ರಲ್ಲಿ ಯಾರು ಅಲ್ಲ ಹೈಕೋರ್ಟ್ ಯಾರು ಅಪೀರ್ ಆಗ್ತಿರೋದು? Kritika Raghavan for respondent number 1. In other matters, it had been brought to the notice of this court that it is Google LLC which maintains the servers and not Google India Private Limited. Hence, Google LLC is brought on record as respondent number 3. Shri Manu Kulkarni is directed to accept notice for respondent number 3. Case mine Garo?
No, I'm not aware.
You should tell us. This basic, if we issue notice, it will go for 3 months.
Apologies, ma'am. I'll serve the council.
Issue emergent notice
Find
to
out
respondent number 3, returnable by 29 September. Council, the house is there?
22nd.
22nd September.
on the main matter.
Counsel for the petitioner is also permitted to serve the standing counsel, if any, of respondent number 3 by next date of hearing, as also take out hand summons on respondent number 3.
Please, my lord. My lord, in this petition, there's an additional prayer, my lord. We are also seeking for general masking of names for all the appeals arising out of matrimonial cases, along with masking of the petitioner's name. That can be considered, my lord.
This is also the balancing which has to be done is as regards the information to be made available to the general public and your own privacy. It will be only limited to privacy. As long as the matter is pending, it will have to be known to everybody.
Not only
Cannot be.
for the disposed appeals, my lord.
Disposed appeals, we'll consider it after they come on record.
Please, my lord. Grateful.
24 CM Venkat Reddy.
Yes.
Appearing on behalf of the petitioner, Your Lordship.
Yes.
This is with respect to a tender of mattresses and cover for the pillow mattresses, wherein in this particular, the notification issued at annexure C, Your Lordship, with respect to calling for tender. In this particular thing, it is unilaterally arbitrary because it is like previous thing, it has stated that 80% Karnataka only, wherein when it's subject to 80%
Which clause
Karnataka.
are you referring to, Mr. Counsel?
With respect to past performance at page number 40, Your Lordship, with respect to mattresses.
Page number 40, ಯಾವ clause?
Clause number 4, past performance.
Yes.
Here,
Along
they
with
even
that
mention small and micro enterprises in this.
50% they
Yes,
get, yes.
wherein this, when it comes to MSME, which is of micro, the micro usually operates and below 5 crores turnover. Those kind of bidders cannot be accepted in this because their turnover would not match
There's
the.
an act which says so, that they have to make a provision. If they
Yeah,
can
yes,
come
sir.
under
So
it, they
that
can
is
come
there.
under.
That is there. But specifically 80% Karnataka, because only very few competitors are there wherein they usually go for higher.
It is not to benefit the tenderer, it is to see that it is properly done. 80% of the requirement is a reasonable one. Even 100% has been held to be reasonable. Yes, next. What is the other?
Next is clause 6, Your Lordship, ISO 901 and 1401, wherein in this particular tender, actually it is on the quality of the mattresses as well as the pillows.
Even the
Wherein
process is
these two
process
ISOs are general, they do not arbitrarily tell
There are
what
there are
whether
process
the
required.
quality of the mattress cover should be in certain GSM or.
There are process requirement, anything preventing you from getting it? Nothing
Lordship,
preventing
that
you
is
from
generally, but they are not specifically telling because we'll have to give a sample first to the evaluator, and based on that, we'll be considered for the second cover. This has two covers. First cover for technical, and then the
You're
comes.
saying the ISO requirement cannot be entertained. They should not have imposed on you.
Yes.
Any difficulty in getting ISO requirement by you?
No, but that is there, Your Lordship. But specifically stating for the material should be.
Right, next.
Lordship, with respect to manufacturing unit, they have again specifically told that. One second.
Within India.
Yes, Your Lordship.
That is what Mr.
Wherein,
Reddy just argued.
when it comes to 80% only within India, people would not be eligible for if their manufacturing unit is only in Karnataka, even though if they are exporters, so most of them would be out of it. So it is.
How does it affect you?
My Lordship,
Where do
here-
you have your manufacturing unit?
I have within India, India itself. But the thing is,
how
my
does it
supplies in previous better tenders, I have not participated in Karnataka, but I have participated outside Karnataka. So my eligibility would not be.
We told Mr. Reddy earlier in the other matter. How does it affect you? You have to make out your case, not on a ipsy dixie on assumption and presumption and
No.
hypothetical argument.
Yes.
What is it that is affecting you is what private list that we can consider here. So far, we haven't heard anything.
No, we have given a representation with respect to what are all the clause which have been
It's
not.
for them to do it. When you issue a tender, you include your tender qualifications. And AGA for respond number 1 to 6. The grounds on which interim order has been sought for is that there is a high requirement of 80% of past performance, ISO certification requirement, and that the manufacturing unit has to be, it can be located anywhere in India when the supply is being made only in Karnataka. None of these grounds would require this court to exercise its discretionary relief to grant any interim order at this stage. And AGA is granted 4 weeks time to file a statement of which so and so. I1 of 26 is allowed. As earlier in on
petitioner is challenging
connect with 20. Yes.
petitioner is challenging the order passed in Lok Adalat, my lord. The petitioner challenging the award passed by the Lok Adalat. Now, the petitioner making the allegation against the counsel who are appearing before the trial court. The advocate who appear before the trial court colluded with the defendants, get the signature of the
advocate colluded.
Please.
Have you taken any action against the
File-
advocate before the bar council?
File the entire bar council. I filed a complaint. The petitioner will file a complaint before the bar
ನೀವು
council.
ಅಲ್ಲಿ ಇಟ್ಕೊಂಡ್ರೆ ಅಲ್ಲಲ್ಲಪ್ಪ ಇಲ್ಲಿ ಕೊಡ್ಬೇಕು
I
ನಮ್ಗೆ
will file it, counter.
ಇಲ್ಲಿ ಕೊಟ್ರೆ ತಾನೇ ನಮ್ಗೆ ಗೊತ್ತಾಗೋದು ಅದ್ ನಮ್ ರೆಕಾರ್ಡ್ಗೆ ನಿಮ್ ರೆಕಾರ್ಡ್ ಅದು
ಇಲ್ಲ sir, court record.
ಕೋರ್ಟಿಗೆ ಕೊಡಿ.
The complaint was filed on 28/7 of 2026.
So what has happened to this complaint?
Notice orders.
Notice ಆಗಿದೆ.
Please.
Issue notice to the respondents returnable by 6th October. The submission of learned counsel for the petitioner is that the petitioner was misled, who is a senior citizen who has been misled by the counsel who appeared for him. And it is for that reason that necessary disciplinary proceedings have been taken up by the Bar Council of Karnataka State Bar Council on a complaint filed by the petitioner. Notice having been issued, the said proceedings are pending. There being serious allegations which have been made against the counsel who had appeared for the petitioner. The operation of the award dated 27/9/22 passed in OS number 91 of 22 by a senior civil judge in JMC Kanakpura during Lok Adalat. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 29th August.
Serial number 26, Vinay N, connected matters.
This got very equal fisheries and minority tax. Laws directed to file a affidavit.
Yes.
In the internal laws directed that this is a minor litigation and fisheries file after file.
Kodi. At least in respect of these lakes and tanks, what are they?
Minor, my lord, so far 26.2 is concerned, my lord, it is within the BBMP limit. I verified, my lord, the list of all the tanks, my lord, throughout the state. My tanks are not there. It can be disposed of.
ಒಂದು then can we dispose of ಅಂದ್ರೆ ಏನು withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Withdraw ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, ನನ್ನ ಟ್ಯಾಂಕ್ಸ್ ಇಲ್ವಲ್ಲ, ಯಾಕೆ?
Recent order ಮಾಡೋದು ಬೇಡ. Only immediate disposal would be withdrawn. Nothing else. Everything else has to be recent. All this has been web hosted now?
Let us be complied.
Either at least whatever is now compiled, it's been web hosted?
But there is a problem.
They'll do.
There is a time to work with. Today we have to find this.
Government.
The other one was require some more time to.
As long as the material for these matters are available, that is fine. We'll go ahead with rest. You can take time.
Serial number 26.3, 4 and 5. I am the impleading applicant proposed respondent. That I am the successive bidder in the tender. Now the season for fish breeding.
ಅದಕ್ಕೆನಪ್ಪ ಆರ್ಗ್ಯುಮೆಂಟ್ ತಗೊಂತಾ ಇರೋದು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸೀಸನ್ ಅಂತ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡಬೇಕು? You argue the matter on merits, we'll consider your submission. So all the details are for this are now. Okay, we will continue. Manmohan Elli.
In 26 and 26.1 for Manmohan PN, we require some time for read this affidavit. We received the affidavit yesterday evening.
Yesterday evening. An affidavit of Secretary Minor Irrigation and Groundwater Development, as also an affidavit of the Secretary Animal Husbandry and Fisheries Department have been filed. Same are taken and record. Copies thereof have been furnished to the respective counsels for the petitioner and the impleading applicants. Counsel for the petitioner seek for and are granted. ಎಷ್ಟು ದಿನ ಬೇಕು ನೋಡಕ್ಕೆ?
4 or 5 days time.
A week's time to go through the same and make their submission. The submission of learned Additional Advocate General is that a partial compliance of the order dated the general directions dated 10/8/26 has been done. The rest of them would be, the rest of the compliance would be completed by
1 month.
by 4 weeks from now. And as and when partial compliances are made, they'll be web hosted on the website of the respective department so as to enable the petitioners or anyone interested in obtaining the necessary information could view the website to obtain such information. Relist on 3rd September.
My lords, one submission in where we are, the impleading applicants here in my lords. My lords, where the lakes which has been, where the successful bidders, the third party rights has been created, my lords. The unknown persons are coming to the lakes and they are catching the fishes. This, the direction is given to,
Who is the unknown person?
we don't know who are the two of my class. That is the instructions. When we lodge,
Mithun,
when we went to, when we requested the department, my lords,
while three of you are fighting with each other, somebody else is coming and taking the fish.
it's in Rajan Kunte police station, we have lodged a complaint also, but there is no action as Singanayak Mahalli Lake.
Some unauthorized person and
Unauthorized
coming,
person
taking
are
away the
coming
fish.
and catching of the fish. So if the direction is given to the government, my lords, to protect those lakes, it would be helpful for us.
The official response are directed to ensure that there is no unauthorized fishing which take place in any of the lakes or tanks during the pendency of the above matter.
Minor.
Interim order wherever granted is extended till next.
Rajan Kunte police. Much obliged. Yes, I'll do it. Yes.
Serial number 27 adjourned, serial number 28. L. Venkatrama Reddy.
Yes, Mr. Reddy.
To consider representation H, annexure, page 44, on the ground that the fifth respondent is running petrol bunk without the license and.
To terminate the relation. Mandamus to terminate. ಏನಕ್ಕೆ?
To consider representation.
Why do you want them to terminate?
Annexure H, page
Where is your
44.
representation page number?
44, my lord.
44.
Respondent 2 and 3 should notice. Since they is running without no objection and license, we have should to consider that representation and even there is no renewal of license also.
Correct. You have to file a proceedings under rule 150.
150 I have mentioned in.
Representation ಆಗಲ್ಲ.
150.
Representation ನಮ್ಗೆ ಒಂದು ಲೆಟರ್ ಕೊಟ್ಟಂಗೆ ಆಗುತ್ತೆ. 150 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬೇಕು. File an application, they will direct them to consider it. But ಯಾರು IOC ಅಲ್ಲ.
Aishwarya Hegde.
Hello?
Aishwarya Hegde.
Aishwarya Hegde for respond number 1, 2,
1, 2, 3, 4.
3. ಇದು Chief Controller of Explosives. So,
CGC.
so and so for respond number 4, notice. CGC. Mahesh Arkalgud. Mahesh, Chief Controller of Explosives. Accepts notice for respond number 4. Notice to respond number 5 is dispensed with the new of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the representation of the petitioner, who is the landowner on which respond number 5 is running a petrol bunk, has not been considered. The contention taken in the representation is that there is no right with the respond number 5 to run the said petrol bunk, since the petitioner has objected, petitioner landowner has objected to such use of the land after the expiry of the license. If that be so, it is for the, even if that be so, a representation of this nature cannot be considered. The Act provides under section 1, the rules provide under rule 150 for a particular application to be filed. If such an application is filed by the petitioner before the deputy commissioner is directed to consider the same and pass necessary orders. It is the deputy commissioner who has the authority, not them.
Please.
No, the 150L.
Within 4 weeks or 2 months.
ಅದು ನೋಟಿಸ್ ಕೊಡಬೇಕು, ಎಲ್ಲ ಮಾಡಬೇಕಾಗುತ್ತೆ. First you file it.
I will file it on the expeditious, at least, let them consider expeditious.
ಹಂಗ್ ಮಾಡಕ್ಕೆ. It will be done as per the proceeding.
29, Chaitanya.
I appear for the petitioner in this case. Matter pertaining to Malad challenging the award passed in the Lok Adalat Malad. The petitioner is the Malad daughter of one Sitaramaya. Respondents are the wife and children of Sitaramappa Malad. During the lifetime of Sitaramappa, he has acquired 4 items of scheduled properties. Out of which Malad, the vast land is item number 4, 1 acre 8 guntas Malad.
You are the plaintiff in the suit.
Plaintiff number 1 Malad.
Yes.
Plaintiff number 2 is the respondent number 3 before this honorable court. Malad.
Yes.
But on 5/7/2024, Malad, the parties have decided to divide the scheduled properties left by Sitaramappa.
Yes.
Thereafterwards, Malad, the respondent number 2, that is the brother of the petitioner, he has took the initiative, Malad, in creating the partition deed. On the same date, Malad, he has obtained a release deed. Partition deed was executed.
You have signed the order sheet. You have signed the
Order sheet, I have signed the order sheet, Malad.
You are the plaintiff in the suit.
I am the plaintiff in the suit, Malad. Your worship may kindly have a page number.
What are your grounds of challenge to the?
Malad, in respect of item number 4, the plaintiff number 2, initially she has assailed along with me in filing the suit, Malad. Thereafterwards, she colludes with the respondent number 2, and she herself obtains entire share in the item number 4 of the scheduled property. That is a vast land, Malad.
But you have signed the compromise.
But that information was not disclosed by the plaintiff number 2.
ನಿಮ್ಗೆ English ಬರುತ್ತೆ ತಾನೆ?
Please, Malad.
ಮತ್ತೆ? It's not that you don't know the language, you are forced to, nobody is cheated or whatever. You know the language, you are the plaintiff. You have signed it.
Item number 1 to 4, Malad, item number 1, 2 and 3, Malad, she has received the monetary relief, Malad, the petitioner. In respect of item number 4, that is a vast extent, Malad, measuring 1 acre 8 guntas. That is the only property, Malad, that is situated in the main area. Plaintiff number 2, Malad, that is the respondent number 3. She colludes with the respondent number 2 and obtained the entire extent of land.
You may obtain whatever. What you are required, you have signed.
Please, that
So you are concerned with what she gets. You are concerned with what you get. You have signed your order. The compromise
was informed by the parties, Malad, they being the sister and brother, Malad. It was informed by the parties that she would receive her share in the item number 4.
You are challenging what she has got, or you are challenging what you have got?
But I have not received any share in the item number 4 is concerned, Malad.
You have signed it.
Initially, soon after presenting the declaration suit, Malad, for cancellation of registered release deed is concerned, the respondent number 2, that is the brother, on the same date of receipt of summons, Malad, he comes.
You have made an allegation that the council has colluded.
Council also has not informed.
Have you taken action against the council?
Please, Malad.
Have you filed a complaint?
No,
to the council?
petitioner has not taken any action against the
action and then come. You make allegation against a council who is not before.
On instructions, Malad, it was informed that even the council has not informed regarding the allotment of share in item number 4 is concerned.
ನಾಳೆ ನಿಮ್ಮೇಲೂ ಹಂಗೆ allegation ಮಾಡ್ತಾರೆ. Don't make allegation against a brother or sister lawyer without on some ipsy dixie. If they have taken any action, then you can make your submission. Otherwise, it will become very easy for everybody to make allegation, every lawyer. Not fair.
Please.
A lawyer has represented your client during that time.
On instructions, Malad, it was told that in respect of her share has been deceived by the parties.
We'll give you 2 weeks time to test whether it is true. If you take action against the council, then we'll consider.
Great.
We'll dismiss it. The notice to the respondent is deferred for now. A perusal of the papers indicates that the petitioner was a plaintiff in OS number 34 of 24. Has signed the plaint and subsequently has signed the compromise petition, the order sheet, on which basis the compromise was recorded by the Lok Adalat. A vague allegation has been made that the counsel appearing for the petitioner had not guided the petitioner properly, had colluded with the other side, resulting in the compromise being executed without the petitioner having knowledge of the said contents. On inquiry as to whether any action has been taken by the petitioner against the counsel who had appeared in the said proceedings, counsel for the petitioner seeks for and is granted 2 weeks' time to obtain instruction and place the said action on record. It is made clear that Mayor Ipsy Dixie allegation against Beda, Ramelvo Gudniwat, released on 15th September. Grateful.
Yes.
GMRES file ಇದೆ ಅವ್ರಿಗೆ ಬಿಡಿ ಪಾಪ
ಯಾವ ತರ? 28ಗೆ IOCLಗೆ ಐಶ್ವರ್ಯ ಹೆಗ್ಡೆ.
ರೀಚ್ ಆಗೋದು ಕಾಣಿಸ್ತಾ ಇದೆ.
ಹೆಗ್ಡೆ. ಹಾ, AI.
ಇನ್ನು 18 ಅಲ್ಲಿ 8th ಮೆಟರ್ ಇದೆ.
ಐಶ್ವರ್ಯ ಹೆಗ್ಡೆ. ಆಮೇಲೆ R5 ಡಿಸ್ಪೆನ್ಸ್ ಬಿತ್ತು. ಹಾ. CGC ಬಂದು ಮಹೇಶ್ ಅರ್ಕಲ್ಗೂಡು. ಮಹೇಶ್ ಅರ್ಕಲ್ ಇಲ್ಲಿದೆ ನೋಡಿ. 31 ಅಲ್ಲಿ ಇದೆ ಸೇಮ್ ಹೆಸರು. 2 minutes ಅಷ್ಟೇ.
ಮುಂದೆ ಇರ್ಬೋದು ನಾವು
ಓಕೆ ಆರ್ಡರ್ಸ್ ಇದು ಫಸ್ಟ್ ಇದೆಯಲ್ಲ
ಎರಡು ಡೇಟ್ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಯಾವ ಡೇಟ್ ಬಂದಿದೆ? ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್. ಕನ್ನಡದಲ್ಲಿ ಬರ್ತೀಯಾ? ಅಂದೆ ಲಾಗಿನ್ ಮಾಡ್ಕೊಂಡು ಯು ಆರ್ ಪ್ರವೀಣ್ ಕುಮಾರ್ ಆಯ್ತು. ನೀವಾ ಸರ್ ಅದು? ಅದೇ ಪ್ಯಾರಾ ಒಲಿಂಪಿಕ್. ಹೌದು. ಪ್ರವೀಣ್ ಕುಮಾರ್ ರಾಯ್ಕೋಟೆ. However he is there. However he is appeared. ಇದೇನಮ್ಮ ಇದು? ಅದು ಮೋದಿನಿ 1 2 3. ಯಾವುದು ಡೇಟು? 24/8 ಮೇಡಮ್ 25 ಸೀರಿಯಲ್ ನಂಬರು? ಸೀರಿಯಲ್ ನಂಬರ್ 70 ಯಾವ್ದ್ರದ್ದು ಇದು? 70 ನಿಮ್ದು. 70 ನನಗ ಆದ್ರೆ ನಾನು 22/9 ಅಂತಾನೆ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಮೇಡಮ್. 22/9 ಹೌದು. ಮತ್ತೆ 16/9 ಮಾಡಿದಾರ ಯಾರು ಅಪ್ಡೇಟ್ ಆಗಿದೆ. ಇದು ನೋಡಿ 16/9 ಆಗಿದೆ, ಉಲ್ಟಾ ಪಲ್ಟಾ ಆಗಿದೆ. ಇಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ನಾನು ಬರ್ಕೊಂಡಿರ್ತೀನಿ ಡ್ಯೂಟಿ ಮಾಡೋ ಬರೀತೀನಿ ಅಂತ ಅಂದ್ರೆ ಇಲ್ಲ ಅಡ್ಜರ್ನ್ ಆದಾಗ ಬರೆಯೋದೇ. ಇವಾಗ ಇದು ಯಾರಿಗಾಗಿದೆ? 71 ನಾವೇ ಬರೆಯೋದು. ಫೈಲ್ ನನ್ನ ಹತ್ರ ಇದೆ, ನಾನು ಆರ್ಡರ್ನು ಮಾಡಿದ್ದೀನಿ, ಸೈನು ಆಗಿದೆ. ಅದೇ ಅಟ್ ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಸೋ ಅಂಡ್ ಸೋ ಏನಾಗಿರೋದು ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ದೀನಿ. ಇದನ್ನ ಇವಾಗ 16/9 ಮಾಡ್ಲಾ? ಇದ್ರದ್ದೇ ಆರ್ಡರ್ 16/9 ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡೋದು ಮಾಡ್ತೀನಿ. ಮತ್ತೆ ಅದು ಇದ್ರಲ್ಲಿ ಅಪ್ಡೇಟ್ ಆಗ್ಬೇಕು ಅನ್ಸುತ್ತೆ. ಆಮೇಲೆ ಡೇಟ್ ಇಲ್ಲ ಅಪ್ಡೇಟ್ ಆದ್ರೆ ಆಮೇಲೆ ನಾನು 22 ಅಲ್ಲ ನೀವು ಮಾಡೋದೇ ಹೈಲೈಟ್ ಆಗೋದು. ಸರಿ ಹಾಗಿದ್ರೆ ನಾನು ಇದೇ ಡೇಟ್ ಈ ಫೈಲ್ ನನ್ನ ಹತ್ರ ಇಲ್ಲ. ಈ ಫೈಲ್ ನನ್ನ ಹತ್ರ ಇದೆ. ಇಲ್ಲ ಮೇಡಮ್ ಈ ಫೈಲ್ ನನ್ನ ಹತ್ರ ಬಂದ್ರೆ ಈ ಫೈಲ್ ಯಾವ ಕೊಡ್ತೀನಿ ಇಲ್ಲಿ ನೋಡಿ. ಫೈಲ್ ಇಸ್ ವಿತ್ ಮೀ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ನೋಡಿ. 25/9 ಅಡ್ವೊಕೇಟ್ ಏನು 6 ಅಲ್ಲಿ ಬರ್ಕೊಂಡಿಲ್ಲ. ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಸದ್ಯಕ್ಕಿಲ್ಲ ಅವರು. ಯಾವ್ದ್ರಲ್ಲಿ ಬಿಟ್ರ ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಬರುತ್ತಂತ ಹಾಕಿ ಇದ್ರೆ ಹಾಕಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಬೇಡ. ಸೌಡ್ ಅಂತಾನೆ ಬರೀರಿ. ಬರೆಯಕ್ಕೆ ಹೋಗ್ಬೇಡಿ.
ಬ್ಯಾಗ್
19% ವರೆಗೆ ರೀಚ್ ಆಗಲ್ಲ.
number 1, serial number 30.
Yes, Amma.
This is yesterday's LOC matter, my lords. May kindly see the dates and some.
You want to go to Delhi and get back?
But I want an LOC to be quashed, my lords. My lords, may kindly now see, my name was not in the FIR.
Investigation is pending. They have filed an application.
Once the investigation is concluded, charge sheet has been filed. I have
Permission
been
has
left out of the charge sheet. Investigation can continue at any point until they continue, but not against me as such. Now that the charge sheet has been filed and cognizance
For
has been
now,
taken.
we can't be considering the matter on merits. We'll have to give them
It's not
time.
on merits, but I'm not an accused in the matter.
You
Where is the
want-
question of LOC being there against?
You want
me?
to go for a day or two and come back? Yes, we'll permit you now. If
No,
you want to
but
be
that's-
going there, then we'll have to give them time to file objections.
I'm okay. I've already traveled to Delhi. He's returned to his native, he's there. He's already there. Now they have no reason to call me back to Bangalore. I'm
That
not
is
an
left to
accused
them.
as such. My only concern is the LOC. My submission is, the moment the investigating officer who has raised an LOC concludes that this person is not an accused against whom he had raised an LOC,
Next time when you appear on this side, we'll not give you time to file objections.
let them, I'm only on this
That,
issue.
that will do that. But
Will the
not,
cognizance
we
will
can
hold that-
deprive them of filing their objections.
Please, but I'm filing the charge sheet and.
Counsel
cognizance
for the
order.
petitioner has filed a memo enclosing a charge sheet. Charge sheet and?
Charge sheet and cognizance order, my lords.
And cognizance order, the same is
35
taken on
copies.
record. Copy thereof has been furnished to the counsels for respondent. The respective counsels for respondent seek fund are granted 2 weeks.
Monday or
Next time.
Tuesday.
We'll remember that. 2
I'm
weeks
sorry.
time to file the respective statement of objection. Objections, if any, by 11th September, relist on 15th September.
Please. Bye.
31, sitting DS.
Yes, Bipin.
For Sai Sports Authority, my lords, D. Basaraj.
Sai Elanim, who is the person who is recommended? Paralympic, no?
My lords, TTF, Table Tennis Federation, my lords, now they are suspended, my lords.
Now, who is the person who is to recommend you?
Table Tennis Federation.
Federation, my lords. Now their recognition has been suspended, my lords.
Ad hoc committee is there.
ಅವ್ರನ್ನ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲಲ್ಲಪ್ಪ.
My lords, they have suspended, my lords. Their recognition is suspended.
The committee might have been suspended, but there must be some administrator or somebody who is.
Sub committee is there, I am told.
There must be somebody.
They are under the Paralympic.
No, they are not under us, they are independent body.
No, my lords.
They are under the able body federation. The last date for sending entries is on 31st July.
31st July.
Last date is over, sending entries.
But they have not released it, my lords. Other para is they have released, my lords, but other sports they have released the list, my lords.
Who is the authority who is to consider your candidature?
My lords, PCI, my lords.
Mr. Raikot is saying it is TTF who is not even a party in this.
TTF will have to send it to us, recommend it to us.
My lords, today I got this notification, my lords.
ಹುಷಾರಾಗಿರ್ಬೇಕಪ್ಪ ಇದು.
They have committed, an ad hoc committee is been.
So IOA in consultation with ITTF. IOA who is appearing?
Indian
IOA
Olympic
is
Association.
respond number 3.
Yes.
3 to 6 ನೀವೇನಾ? You are appearing for IOA?
4. I don't appear for IOA.
IOA ಗೆ ಯಾರು appear ಆಗಿದ್ದು? ಮನೆ ಸ್ನೇಹಿಲ್
Indian Olympic Association, I don't appear.
ಸ್ನೇಹಿಲ್ ಬೆಲಾನಿ ಅಲ್ಲ? ನೆನ್ನೆ ಅದೇ ಹೇಳಿದ್ದು. Mr. Snail Belani, ಏನು ಅವ್ರ ಹೆಸರು?
ಅದೇ ಸೇಲ್ಸ್ ಸ್ಪೆಲ್ಲಿಂಗ್ ಚೆಕ್.
We should find out when urgency is there, who is the council who appears for the concerned authorities,
Police.
and we can direct them to take notice. If you don't tell us who is the council, if we'll have to issue notice, it will take 4 weeks.
Apologies. It may be passed over, I'll serve the copy.
That is why we are finding out the name and giving it to you.
Apologies.
ಯಾರಮ್ಮ?
ಸ್ನೇಹಿಲ್ ಬಾಲನ್.
ಅವ್ರದ್ದು ಫೋನ್ ನಂಬರ್ ಏನಾರು ಇದೆಯಾ?
ಇದೆ ಸರ್ 9589.
ಬರ್ದು ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. Pass over, serve it on him, get instruction, because who is the authority, then only they can answer.
Yes.
However, the entries are closed from our end 31st July itself. We cannot forward any names now.
We are not going to hold anything infructuous and dismiss it. When in TTFI already there are so many allegations, it gets superseded by the MYAS. Then there seems to be a lot more.
That is true.
And if
Because it is
athletes are
superseded
going
only
to
for
be
reasons.
discriminated, they are going to suffer on account of these administrators, we will take action. As we have said in the other matter also, there has to be, the federations are for the athletes. Athletes cannot be replaced.
Please.
Federation can be replaced.
Correct.
Management, there are enough and more number of people. Athletes our country doesn't have. So the few
IOA
athletes
accepts
that we have to nurture them, not discriminate them. We are not going to, you will also have to assist us. If action has to be taken, already you have taken action against this federation.
As of 12th of this month, my lord, it has been suspended, and there's an ad hoc committee, my lord, which is in place.
How do you safeguard the athlete?
But which list was confirmed by the Table Tennis Federation, that was sent to the Table Tennis Federation, the list which was confirmed, my lords. That list only they have considered, my lords. They have not reselected or.
Who has selected? Who has sent it?
My lords.
IOA or Paralympic Association?
Paralympic.
The able body federation is there. Able body federation for badminton, table tennis and lawn tennis. The able body federation. Able body federation recommends it to us. First, my lord, table tennis federation has to recommend to the able body federation, under which the table tennis federation is working. The able body federation should in turn recommend it to us. We will forward it as it is. We don't select.
Fair enough. You don't do anything. Upstream upstream or downstream denial of responsibility is there. That we have seen in all the matters which come up: hockey, surfing, now table tennis, everywhere, and some other 2 or 3 things also had come up. That denial, you can live in denial, there's no problem. But when TTFI has been suspended, how do you take the same recommendation issued by TTFI?
That was
and forward
earlier
it?
to its suspension. All entries earlier to its suspension, my lord, we have forwarded.
When were they suspended?
12th,
12th of this month.
31st July was the last date.
And you kept quiet till that time?
You know, there were allegations, my lord, which was made, quite a few allegations, and then eventually they were suspended.
Please take action. Otherwise, we'll never win the gold medal that we would want to win. Gold, silver, bronze, whatever. We'll still be wherever if we don't nurture the athletes. If we need them to win the medals, we need to give all the facilities to enable that to happen. That includes mental stability, not like this. Pass over again.
Much obliged.
B group matters, serial number 32. Shilpa Rani from connected matters.
office, I took time to produce the list of authorities.
ಕೊಡಿ. ನೆನ್ನೆದಲ್ಲ.
These are the three authorities which we have cited before. The Commissioner also.
You want to rely on these judgments?
Yes.
Yes, please.
But first I will take the Supreme Court judgment which has been followed by this court in ILR. Page 95, my lord.
90.
78, 3 SCC, page 236.
Yes, please.
Lordship may come to paragraph 8 at page 99.
Yes.
Serious controversy centered, however, around the question whether the right to worship by turn is immovable property, gift of which can only be made by registered instrument. Hindu law recognizes gift of property to an idol in respect of the possession and management of the property which belongs to the Devasthanam or temple. The responsibility would be in the manager who is described by Hindu law as Shabashiv. The devolution of the office of Shabash depends on the terms of the deed or will be by which it is created, and in the absence of a provision to the contrary, the settler himself becomes a Shabash and the office devolves according to the line of inheritance from the founder and passes to his heirs. This led to an arrangement among various heirs equally entitled to inherit the office for the due execution of the functions belonging to the office, discharging the duty in turn. This turn of worship is styled as Pala in West Bengal and Asra in Rajasthan, Shabaiti being held to be the property. In Angurbala Sonso, this court recognized the right of a family to succeed to the religious office of Shabashik. This hereditary office of Shabashik is traceable to old Hindu law text and is a recognized concept of traditional Hindu law. It appears to be heritable and partiable in the strict sense, and that it is enjoyed by heirs of equal degree by turn and transferable by gift, subject to the limitation that it may not pass on to non-Hindus. On principles of morality and propriety, the sale of the office of Shabaship is not favored. The position of a Shabaship is not merely that of a Pujari, he is a human miscreant of the deity. By virtue of the office, a Shabaship is an administrator of the property attached to the temple of which he is Shabite. Both the elements of office and property of duties and personal interest are blended together in the conception of Shabaship, and neither can be detached from the other. The question then is whether the hereditary office of Shabash is immovable property. Much before the enactment of the Transfer of Property Act, a question arose in the context of the Limitation Act, then in force, whether a suit for a share in the worship and the emolument of incidental to the same would be a suit for recovery of immovable property or interest in the immovable property. In Krishna Bhai Sonso, after referring to the various texts of Hindu law and the commentaries of English commentators thereon, a division bench of the Bombay High Court held as under. Although therefore the office of priest in the temple, when it is not annexed to the worship of any land or held by virtue of such ownership, may not in the ordinary sense of the term be immovable property, but is an incorporeal hereditament of a personal nature, yet being by the custom of Hindus classified with immovable property and so regarded in the law. The privileges and the precedent attached to a hereditary office were termed in the Hindu law as Nibandha, and the text of Yajnavalkya treated Vibandha, loosely translated as Karodi as immovable property. Soon thereafter, the question again arose in so-and-so, where in view of the conflict in decision between Krishna Bhatt and Bajimanar, the matter was referred to the full bench of 5 judges. The question arose in the context of Limitation Act in a suit to recover fees payable to the incumbent of hereditary office, that of a village Joshi. The contention was that such a hereditary office of village Joshi is immovable property. After exhaustively referring to the text of Yagnavalkya and the commentators thereon, Westrope CJ observed, the word Karodi is not a happy translation of a term Nibandha. It was held that Hindu law has always treated hereditary office as immovable property. These two decisions are affirmed by the Judicial Committee of the Privy Council in Maharana so case. The principle that emerges from this decision is that when the question concerns the rights of Hindus, it must be taken to include whatever the Hindu law classes as immovable, although not so in ordinary acceptation of the word, and to the application of this rule within the appropriate limits, the Judicial Committee sees no objection. In Raghu Pandey so the Calcutta High Court held that the right to officiate as a priest at funeral ceremonies of Hindus is in the nature of immovable property. A full bench of the Calcutta High Court in so held that the office of Shabat is hereditary and is regarded as Hindu law as immovable property. This court took note of these decisions with an approval of so-and-so. And then paragraph 68 and 69, ink page. $52 minutes. This same judgment has been followed by this court. Page in ILR 2008, page 4878. But I just wanted to read paragraph 69, Andhra Pradesh.
Andhrana ILR, Karnataka.
Karnataka ILR.
Page number?
4878 minute. That is the first judgment. Justice Jagannath.
Para 65, ink page yadu.
Ink page 52 minute. I'm sorry. Para 68.
68.
This present Supreme Court judgment, what I read, Millard, is followed here.
Extracted.
But 69, 57, Andhra Pradesh is also clear. I will read paragraph 69. In another decision, the Andhra Pradesh High Court in case of so-and-so held that office of an archak when the emoluments are attached to it is hereditable and purchasable property. In another decision, the very same High Court in case of Narayan so-and-so held thus, hereditary archaka office is regarded as a species of property which devolves like any other property according to the ordinary law of inheritance. The law recognizes hereditary succession to the office and emoluments of archaks as being is conscious with the presumed intention of the grantor or the founder. In the absence of a proof of custom or usage of a different nature, it is purchasable and heritable according to Hindu law of succession. The office of archak with its emolument has come to be regarded as a species of property, hereditable and partiable like any other private property. In such circumstances, there is no reason why courts should refuse to recognize transfers by archak of the right to the office and the emolument to the remaining archaks or to those standing in the line of heirs, so long as the transfers are gratuitous and not made for the pecuniary benefit of the transferors. The learned author made in his commentary Hindu Law and Usage, 14th edition, at page so-and-so dealing with the office of Pujari, Archak, has this to say, where hereditary Pujari is appointed for a public temple and elements are attached to that office, the right to such office is a right to property and his removal from the office is only by civil suit, not by Shabbat. It is hereditable and purchasable. The hereditary Pujari's Harchak office is a property and devolves like any other property according to the ordinary law of inheritance. When it's sold, the transfer is illegal. It is therefore clear from the aforesaid propositions of law laid down by the apex court as well as by the order of the High Court and the observation in Main's Hindu law and usage that the right to hereditary Archak office is a right to property where emoluments are attached to the office of hereditary Pujari and such an Archak can be removed only by the civil suit. Normally, in the present case, under section 27A of 97 Act, the deputy commissioner is empowered to decide the right of worship, which he has held that all the sons of the Avale deceased propositors, by rotation, they can perform the puja. That order was confirmed by the commissioner. Then, my lord, meanwhile, the assistant commissioner virtually granted an injunction, like a civil court. When we challenged it, it was set aside and the matter has been sent back. Now, the commissioner, my lords, the deputy commissioner.
Deputy Commissioner was in your favor.
Yes.
Commissioner set it aside.
Yes. The question of remand, my lord, I need not make a submission.
Yes.
When the order of remand is required, it is only when the insufficiency of substantial evidence. Remand after remand is not permitted. That's the position. Now, the question of remand would not arise at all when a person goes in appeal and appellate authority confirms in an appeal. And again, my lord, the deputy commissioner said in accordance with the roster as per the 2001 order, the puja can be performed. Again, that order was set aside and matter has been remitted back. Therefore, this remittal is bad is the submission.
Third round of litigation.
Yes. The government has to take a decision so that the order of the commissioner, which is, in fact, there is one judgment in 2010, but I could not lay my hands immediately, where the apex court said the of course, my lord, so far as the review powers are concerned, either the courts or quasi-judicial authority, unless the statute confers a power, the question of review would not arise at all. But there is one 2010, my lord, para 30, but I did not remember the volume. But it says, apex court, even an administrative authority is bound by the earlier decision. The question of review would not arise at all, unless there is a fraud is.
If there is a remand which has been made and it is being reconsidered, it won't be bound by the earlier.
Yes.
Earlier order is set aside.
Yes.
Earlier order is no longer in existence.
Yes.
If the remittal authority is bound by what it had passed earlier, then there would not be any purpose in remanding at all.
Yes. Now there are no strong or a good grounds to send it back.
Yes.
That's the position.
It was all available. He should have decided it then and there rather than doing that. That is your contention.
Because he is bound by the earlier appellate authority order. That's the position.
Earlier appellate authority, how will he be?
15/9/2001, my lord, he has already taken.
He has taken a decision. That came up on a writ petition. Writ petition set it aside and remanded it.
No, it is not set aside, my lord. There is no setting aside. What was set aside? Only the assistant commissioner order. If it is set aside, my lord, there is no case. What has been set aside by this court is page 93 of the documents, my lord. Paragraph 9.
Yes.
The assistant commissioner himself has stated that he has no jurisdiction. Matter requires to be decided before a civil court. At the same time, he has granted interim order of maintaining the status quo till the dispute is resolved before the civil court. Once the Assistant Commissioner has admitted that he has no jurisdiction, consequently ordering to maintain the status quo among the parties till dispute is resolved by the civil court is without jurisdiction in terms of Section 51 of the Karnataka Hindu Religious Institutions and Charitable Endowments Act of 97. Earlier dispute is stated to have been resolved in view of the order of the Deputy Commissioner dated 11/9/2001 and 2011, and it was confirmed by the Commissioner on 15/10, it should be 2001. The Deputy Commissioner is of the view that the puja in the aforesaid temple is required to be carried out on rotation basis. Therefore, Annexure L dated 15/5/2014 passed by the Assistant Commissioner is hereby set aside. The Commissioner and the Deputy Commissioner are hereby directed to exercise whether the Commissioner or the Deputy Commissioner can decide the disputed issue among the petitioner and contesting the respondent to perform the puja in the aforesaid temple or not. Both petitioner and the contesting respondents are permitted to place their say in the matter before the Commissioner or Deputy Commissioner. In this regard, a speaking order shall be passed and communicated to the respective parties within a period of so. Then, my lord, document number 1 is an order that is 5/9/2023, page 14, my lord, of the same document.
Page 42.
Page 14, my lords, document 1. He refers to this petition.
Yes.
If your lordships kindly come to page 17, my lord, the last paragraph.
Yes.
ಮೇಲ್ಕಂಡ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಬೇಲೂರು ತಾಲೂಕು ಅಗರೆ ಗ್ರಾಮದ ಶ್ರೀ ದೇವಿರಮ್ಮ ದೇವಸ್ಥಾನದಲ್ಲಿ ಈ ಹಿಂದೆ ಆನುವಂಶಿಕ ಅರ್ಚಕರಾಗಿದ್ದ ಅವಳೇಗೌಡರು ಮರಣ ಹೊಂದಿದ ನಂತರ ಅವರ ಮಕ್ಕಳ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳಿಗೆ ಸಮಾನ ಹಕ್ಕು ನೀಡಿ ಶ್ರೀ ದೇವಾಲಯದಲ್ಲಿ ಅರ್ಚಕ ವ್ಯಕ್ತಿಯನ್ನು ನೀಡಬೇಕೆಂದು ವಾದಿಗಳು ಕೋರಿದ್ದು, ಪ್ರಸ್ತುತ ವಾದಿಯವರೇ ಅವಳೇಗೌಡರವರ ಮರಣದ ನಂತರ ಪೂಜಾ ಕಾರ್ಯವನ್ನು ಮಾಡಿಕೊಂಡು ಬಂದಿದ್ದು, ತಹಲ್ರವರೆಗೂ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಪೂಜಾ ಕೈಕಂಡ್ಯ ನಡೆಸಲು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಇಂದಿನ ಅರ್ಚಕರಾದ ಅವಳೇಗೌಡ ಮಕ್ಕಳಾಗಿರುವುದು ದಾಖಲೆಗಳಿಂದ ರುಜುವಾತು ಆಗಿರುವುದರಿಂದ ಮತ್ತು ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವ ಪ್ರವರ್ಗ ಸಿ ವರ್ಗದ ಅಧಿಸೂಚಿತ ಸಂಸ್ಥೆಗಳಲ್ಲಿನ ಅರ್ಚಕರ ನಿಧನ ನಂತರ ಮಕ್ಕಳನ್ನು ನೇಮಕಾತಿ ಮಾಡುವ ಬಗ್ಗೆ ಸರ್ಕಾರದ ಆದೇಶ ನಂಬರಂತೆ ಕ್ರಮವಹಿಸಲು ಅವಕಾಶ ಇರುವುದರಿಂದ ಈ ಕೆಳಗಂಡಂತೆ ಆದೇಶಿಸಿದೆ. ಹಾಸನ ಜಿಲ್ಲಾ ಬೇಲೂರು ತಾಲೂಕು ಮಾದಿಹಳ್ಳಿ ಹೋಬಳಿ ಅಗರೆ ಗ್ರಾಮದ ಶ್ರೀ ದೇವಿರಮ್ಮ ದೇವಸ್ಥಾನ ಅರ್ಚಕ ವೃತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಿಂದೂ ಧಾರ್ಮಿಕ ದತ್ತಿ ದಾರ್ಯ ಸೋನ್ಸೋ ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಉಪಯೋಗಿಸಿಕೊಂಡು ಅವಳೇಗೌಡರ ಬರಾಬರದ ಅರ್ಚಕ ವ್ಯಕ್ತಿಯಲ್ಲಿರುವ ಸರದಿಯನ್ನು ಅವಳೇಗೌಡ ಶ್ರೀ ಅವಳೇಗೌಡರ ಮಕ್ಕಳೆಲ್ಲರಿಗೂ ಸರದಿ ಪ್ರಕಾರ ದೇವಿರಮ್ಮ ದೇವಸ್ಥಾನದ ಪೂಜಾ ಕೈಂಕರ್ಯ ಕೈಗೊಳ್ಳಲು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದೆ. Well, this is earlier order is the Deputy Commissioner settled it. Your Lordship would get at page 41 minutes.
Yes.
Para 2. ಸದರಿ 3 ಜನ ಅರ್ಚಕರು ದೇವಿರಮ್ಮ ದೇವರ ಪೂಜೆಯನ್ನು ಸರದಿ ಪ್ರಕಾರ ಪೂಜೆಯನ್ನು ಮಾಡಿಕೊಂಡು ಹೋಗುತ್ತಗೆಂದು ಆದೇಶಿಸಿದೆ. ಬರಾಬರದ ಅರ್ಚಕರ ವಂಶಸ್ಥರಿಗೆ ಸೇರದೆ ಹಾಗೂ ಸರ್ಕಾರಿ ನಿವೃತ್ತ ನೌಕರರಾದ ವಾದಿ ಅಳಸೇಗೌಡ ಬಿನ್ ಅಜ್ಜೇಗೌಡ ಅಗರೆ ಗ್ರಾಮ ಇವರನ್ನು ಹಾಗೂ 4ನೇ ಪ್ರತಿವಾದಿ ಸ್ವಾಮಿಗೌಡ ಸೋನ್ಸು ಇವರುಗಳು ಬರಾಬರದ ಅರ್ಚಕರ ವಂಶಜರಾಗಿಲ್ಲದ ಕಾರಣ ಈ ಇಬ್ಬರನ್ನು ಅಗರೆ ಗ್ರಾಮದ ದೇವಿರಮ್ಮ ದೇವರ ಅರ್ಚಕರ ಹಕ್ಕುದಾರಿಕೆ ಹಾಗೂ ವೃತ್ತಿಗೆ ಅರ್ಹರಾಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಇವರಿಗೆ ಯಾವುದೇ ರೀತಿಯಾದ ಅರ್ಚಕ ವೃತ್ತಿಯ ಹಕ್ಕುದಾರಗಳು ಇರುವುದಿಲ್ಲವೆಂದು ಆದೇಶಿಸಲಾಗಿದೆ ಹಾಗೂ ಇವರ ಹಕ್ಕುದಾರಿಕೆ ಅರ್ಜಿಗಳನ್ನು ತಿರಸ್ಕರಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. This order of the Deputy Commissioner 11/9/2001 is confirmed at page 67, 63 by the Commissioner.
Yes.
Operative portion is at page 67. This is at the instance of one of the Karigowda.
Karigowda, son of Havlegowda.
Yes, the man who goes now before the Commissioner.
Yes.
Page 67, ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಸಕಲೇಶ್ಪುರ ಉಪವಿಭಾಗದ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸು ರದ್ದುಪಡಿಸಿದೆ. ಹಾಸನ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಸಂಖ್ಯೆ 11/9/2001 ರಲ್ಲಿ ಆದೇಶವಾಗಿರುವಂತೆ ಅರ್ಚನಾ ವೃತ್ತಿಯನ್ನು ಸಂಬಂಧಿಸಿದವರಿಗೆ ಸರದಿಯಂತೆ ವಹಿಸಲು ತಹಸೀಲ್ದಾರ್ ಅವರಿಗೆ ಸೂಚಿಸಲಾಗಿದೆ. ಆದರೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು 24ರಂದು ಆದೇಶದಲ್ಲಿ ತಿಳಿಸಿದ ದೂರುಗಳ ಬಗ್ಗೆ ಸ್ಥಳೀಯ ಅಧಿಕಾರಿಗಳು ವಿಚಾರಣೆ ನಡೆಸಿ ಕಾನೂನು ರೀತಿ ಕ್ರಮಗೊಳ್ಳಲು ಸೋನ್ಸೋ. Now, my lord, the turn basis which is placed on record along with the writ petition where the Tahsildar has
Produce the
fixed-
genealogical tree of Havlegowda. Who are the successors? Because there seems to be some.
Havlegowda has got, my lord, the 6 children. And page 20, my lord, is the turn.
If you come to page 32 of your
Yes, ma'am.
compilation, Vadi Havlegowda,
Yes,
ಪ್ರತಿವಾದಿ ಅವಳೇಗೌಡ. ಇಲ್ಲಿ ಬಿನ್ ಅಂತ ಹಾಕಿಲ್ಲ ವಾದಿಗೆ, ಪ್ರತಿವಾದಿಗೆ ಅವಳೇಗೌಡ,
ಇಲ್ಲಿ ಅವರು
ದೇವೇಗೌಡ.
ಕರಿಗೌಡ ಅಂತ
32 ನೋಡಿ.
ಎಸ್ my lord.
ಅವಳೇಗೌಡ ವರ್ಸಸ್ ಅವಳೇಗೌಡ.
That is filed by Karigowda, my lords. Your lordship will get it.
Okay, that may be explained that way, but look at Prativadi.
Yes.
Havlegowda bin Devegowda, Sonnegowda bin Rangegowda, Doddegowda bin Veerabhadragowda, Swami Gowda bin Iregowda. They are not all children of Havlegowda.
Yes, all the children of Havlegowda. My lord, what the commissioner,
Devegowda bin Rangegowda, Veerabhadragowda antide nodi. They are not children. How are they related?
my lord, their right has been negatived by the commissioner because they are not entitled ಅಂತ ಹೇಳ್ತಾರೆ. Page 67. Oh, sorry, page 41. Swami Gowda, Alase Gowda, Sanne Gowda.
Sadri ಮೂರು ಜನ ಅರ್ಜಿದಾರರು ಶ್ರೀ.
My lord, the turn is page 20, my lord, of the writ petition. Tahsildar has fixed the term. Lokesh, Karigowda, Puttegowda, Huligowda, Somegowda, Shankaregowda. These are the
Page?
page 20 of the writ petition. Writ petition.
20 ಅಲ್ಲಿ ಏನಿದೆ ಮಿಸ್ಟರ್ ಕಿರಣ್?
Tahsildar passed.
20 ಅಲ್ಲಿ 20 is the petition itself. Tahsildar order.
Page 19.
Senior referring page number 70.
ಸ್ವಲ್ಪ
Page 70 of writ petition.
Page?
Page 70 of the writ petition.
70.
70.
70. Yes, Tahsildar.
Yes, my lord. That is 11/9/2023. After the deputy commissioner order.
Lokesh ಮೊಮ್ಮಗ. H.H. ಕರಿಗೌಡ ಮಗ.
ಅವಳೇಗೌಡರ ವಂಶಸ್ಥರ ಹೆಸರು ಅಂತ.
ಇಲ್ಲೆಲ್ಲ ಅವಳೇಗೌಡ ಅಂತ ಬಂದಿದೆ. ಆಲಿಗೌಡ.
There is no dispute so far as
No,
this.
but the names are different. from the claimants before the deputy commissioner and the commissioner, Illi Lokesh, Karigowda, Kuttegowda, Uligowda, Somegowda, Shankaregowda. These are all different names.
Yes, my lord, this heirship certificate is here.
The persons who were there before the deputy commissioner earlier were different. The persons who were there before the commissioners were different. Now, Karigowda, who is
Karigowda is a person,
Avlegowda's son.
Karigowda is a person continuously, my lord, institute all litigation. Because he has obtained unregistered power of attorney, he says, all brothers I want to perform. That was not accepted. Unregistered power of attorney, we have issued a legal notice, cancelled it. Vamsha Riksha, my lord, that is page 20, the documents.
Lakshman, first time that the matter went before the deputy commissioner in 2001,
1996.
the Avlegowda had filed against his brothers probably.
Brothers.
Brothers Allah, his cousins ansate.
Please, they are the other families, my lordship. There are three families.
Avlegowda bin Devegowda, Sonnegowda bin Veerabhadregowda, Hiregowda. They're not sons of the same father. They seem to be sons of other brothers or something like that.
Not so far as the Avlegowda, my lord, is the propositors is not disputed. His children, my lord, whoever comes on a turn basis, let the deputy commissioner even now decides, or the commissioner, whatever, my lord, your lordships directs.
And there are two Avlegowdas.
Only one. ಅವರು ತಾತನ ಹೆಸರು ಅಷ್ಟೇ, ಮಗನ ಹೆಸರುನು ಹಂಗಾಗಿದೆ.
ಅದೇ ಅದಕ್ಕೆ ಪೇಜ್ 32 ನೋಡಿದ್ರೆ
ಹೌದೌದು,
ಅವಳೇಗೌಡ ವರ್ಸಸ್ ಅವಳೇಗೌಡ ಇದೆ. ಇಲ್ಲಿ ಬಿನ್ ಅಂತ ಹಾಕಿಲ್ಲ.
ಅವಳೇಗೌಡ, ಅಜ್ಜಿಗೌಡ,
ಅಜ್ಜೇಗೌಡ,
ಅಜ್ಜೇಗೌಡ, ಅವಳೇಗೌಡ ಬಿನ್ ದೇವೇಗೌಡ,
ಅಜ್ಜಿಗೌಡ, ದೇವೇಗೌಡ. So how are they all related ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ.
They are the brothers of, they are the brothers of the original Havlegowda. Lordship, kindly come to page 20.
ಅದೂನು ಆಗಿಲ್ವಲ್ಲಪ್ಪ, ಅವಳೇಗೌಡ, ಅಜ್ಜಿಗೌಡ.
All these documents produced by me before the commissioner. Kindly see page 19, Lordship. Vamsha Vriksha.
Page
19 of the documents produced by me.
They produced it. ವಂಶ
ಕೊಟ್ಟಿದೆ ಪೇಜ್ 20.
20 ಇಲ್ಲಿದೆ ಅಲ್ಲ. ಅಜ್ಜೇಗೌಡ ಎಲ್ಲಿ ಬರ್ತಾನೆ?
ಅಜ್ಜೇಗೌಡ, Lordship, the Havlegowda brother ಅವರು. Original Havlegowda brother. Starting ಅಲ್ಲಿ ಕಮ್ಮಿ ಕಾಣಿಸುತ್ತೆ Havlegowda.
ಅವಳೇಗೌಡ.
ಅವ್ರಿಗೆ 4 ಜನ ಮಕ್ಕಳು, ದೊಡ್ಡೇಗೌಡ, ದೇವೇಗೌಡ. ಫ್ರಮ್ ದೇವೇಗೌಡ ಫ್ಯಾಮಿಲಿ ಒನ್ ಮೋರ್ Havlegowda ಬರುತ್ತೆ. ಸೆಕೆಂಡ್, ಆ Havlegowda ಮಕ್ಕಳು ಇವರೆಲ್ಲ ಪಿಟಿಷನರ್ ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. ನಾವು ಲೋರ್ಶಿಪ್ ದೇವೇಗೌಡ, ವೀರೇಗೌಡ, H.H. ಕರಿಗೌಡ, ಮಲ್ಲೇಗೌಡ, ಕುಟ್ಟೇಗೌಡ and ಹುಲಿಗೌಡ. Now we are the children of Havlegowda. ಆ ಮಧ್ಯದಲ್ಲಿ ಕಾಣಿಸುತ್ತೆ ನಮಗೆ.
ಕರಿಗೌಡ ನೀವು ಇಲ್ಲಿದೆ ನೋಡಿ. ಹೌದು,
ಯಾವ ಅವಳೇಗೌಡನಪ್ಪ ನೀವು? ಇವರ್ ದೊಡ್ಡೇಗೌಡ ಸನ್ ಅವಳೇಗೌಡ.
ದೇವೇಗೌಡ ಸನ್ Havlegowda.
ದೇವೇಗೌಡ ಎಲ್ಲಿದ್ದಾರಪ್ಪ?
ದೇವೇಗೌಡ ಸೆಕೆಂಡ್, Havlegowda
in the middle your lordships would get.
So every grandson became Avlegowda in each family. So Doddegowda's son also became one of them. Devegowda's son is also Avlegowda. Papa Karigowda ಮಾಡ್ಲಿಲ್ಲ ಹಂಗೆ.
That those who are employed, my lord, have been excluded as per the government orders. Rest of them have been allowed to perform the puja. That is what as per the deputy commissioner order.
So all these people will have entitlement.
Now all these people, Devegowda, Veeragowda, Karigowda, and they are before the court, lordship, claiming the right through Havlegowda. ಒಂದು ವರ್ಷದ ಸರದಿ. There are 3 ಸರದಿ, lordship. Insofar as one Saradi is concerned, we are fighting.
So one Saradi
As per 2001 order.
between Doddegowda, Devegowda, Karigowda and ಇದು ಯಾರಿದು?
Mallegowda, Puttegowda and Puligowda. Devegowda, Biregowda, Mallegowda, Puttegowda and Puligowda are the petitioners, and Karigowda, Your Lordship, respond number 5. Devegowda, now Your Lordship, he died. My learned friend appearing for Devegowda. Respond number 6. Devegowda ಎಲ್ಲ ಸರ್.
First Sardi was divided between Doddegowda.
Doddegowda from different family, Your Lordship. It is not my family.
ಅವಳೇಗೌಡ ಮಗನಲ್ಲಪ್ಪ.
Doddegowda ಅಲ್ಲ ಸರ್. Your Lordship, kindly see the father name ಅಲ್ಲಿ Doddegowda. ಅದು ಟೈಪ್ ಕಾಪಿಯಲ್ಲಿ ವೀರಭದ್ರೇಗೌಡ ಅಂತ ಇದೆ. Respondent, Your Lordship. Page 32 ನಲ್ಲಿ
Veerabhadragowda is Karigowda's son.
No, Your Lordship.
This page 20, that is what it says.
Please, Your Lordship.
Page 20,
Please.
Veerabhadragowda is Karigowda's son.
ಅಲ್ಲ ದೊಡ್ಡೇಗೌಡ ಮತ್ತು
Veerabhadragowda was Kallegowda's son. The third son of
Kallegowda's son. Karigowda ಈ ಕಡೆ ಬರ್ತಾರೆ. Kallegowda's son.
The third son of
Kallegowda is son of Avlegowda.
Avlegowda. First share ಆಗಿದ್ದು ಒಂದು
ಒರಿಜಿನಲ್
ಇನ್ನೇನು ಒರಿಜಿನಲ್ ಇದೆ, ಇದರಿಂದ ಒರಿಜಿನಲ್ ಏನು ಹೋಗ್ಬೇಕು?
Not whoever is available so far as the heirship is concerned, according to the assistant, 6 people.
Are you all admitting this Vamshoksha, the genealogical tree? All of you admitting. So what is the division now?
Now
The first division was Sardi of 1 year
1 year.
each.
Please.
So first Sardi could have been Doddegowda 1 year, Devegowda 1 year, Kallegowda 1 year.
No, my lord.
No, no.
But it is not 1 year. It is 3 months, my lord, assistant commissioner. May I take your lordship, my lord, page 71.
71.
The Tahsildar has fixed it. ಮೂರ್ ತಿಂಗಳು ಒಬ್ಬೊಬ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ. Page 71 of the writ petition.
Writ petition.
Yes, my lord.
ಇದು ಇವಾಗ ಆಗಿದ್ದು.
11/9/2023, Belur Taluk Tahsildar Office.
No, this is coming further down the line, Mr. Friend. We are still at Avlegowda.
That's the very
ನೀವು second
ಇಲ್ಲಿ
generation
12/9/2023 to 11/11 ಒಂದು ವರ್ಷದಲ್ಲಿ ಇರೋದನ್ನ ಡಿವೈಡ್ ಮಾಡಿದ್ದಾರೆ 6 ಜನಕ್ಕೂ.
Now there is no dispute as regards the other family members.
There is no dispute, my lords.
So now the issue is between.
Page 71 is admitted for both sides.
The whole issue is between Devegowda's children.
Lordship,
Devegowda, Avlegowda's children.
Devegowda, Avlegowda.
You are for?
Lordship, I am the son of Avlegowda, the third son, Lordship, Karigowda.
Karigowda. You are for?
I am for Devegowda, my lord.
First son.
Devegowda. Yes. So the first division, there is no dispute. The second division, also there is no dispute. The third division is where the dispute is arisen now.
The only dispute, Karigowda wants to perform on behalf of all the heirs. That is his contention. That is not permitted is the only short question. Whatever the terms which he gets, my lord, we have no objection.
I challenge the order dated 5/9/2023 on 3 grounds. Lordship, I produced certain documents to the commissioner as per the directions of this honorable court in matter on the meeting, specifically directed whether the parties have the inheriting right or not. It has to be decided by the district of the commission as per 25B63 of the 1997 Act. Lordship, 25B63 Lordship, provides specific power to the deputy commissioner.
To decide. Yes, here.
Specific power to the deputy commissioner to decide hereditary rights insofar as this in between the family if there is a dispute. Section 9 is the appropriate provision to appoint the Archakas of the temple under 1997 Act.
Yes.
Now, Lordship, kindly see all these documents produced by my senior friend. I produced the commissioner challenging the 59/2023 order. Lordship, under 25(b)(7. Lordship, it is a specific power given to the commissioner. It is appellate authority, Lordship.
For the act.
25(b)(7. Kindly see, Lordship, page number 1.
25(b)(7).
25(b)(7. There is
B6.
B7. Any person accused by any
One
order.
nimsham.
Page 74.
25(b)(7). Any person aggrieved by any order.
Any order passed by the deputy commissioner under any of the foregoing provision shall appeal within 1 month from the date of receipt of the order to the commissioner. Now, Lordship, the commissioner may, after hearing aggrieved by the person and other contending parties, pass appropriate order in accordance with law.
Yes.
This is the provision challenging the any order passed under the 25(b). Lordship, the order passed under 25(b)(6)(3). Therefore, I file appeal under 25(b)(7).
Yes.
Now, Lordship, kindly see, I produced all these documents before the commissioner to show that how I am entitled to the hereditary
How
right.
you alone are entitled.
Please.
How show us what documents.
Before that, Lordship, I'll just clarify the family tree or the dispute. Lordship, dispute insofar as Avale Gowda's family only, Lordship. Other two families are, Lordship, there is no dispute. It is now kindly come to page.
The initial dispute in 2001 was there.
Lordship, it is started from 1996-97. Kindly see the page. Kindly see page number 25. That is the order dated 11/9/2001. Page
Yes.
25. It started on 1990. CR number 1/9697. So at that point of time, Lordship, my father was alive. Avale Gowda was alive. Lordship, he died on 29/5/1996.
Yes.
Just at that point of time, Lordship, kindly come to document number 3. That is the inspection conducted by the Grama Lekkadhikari, village accountant, Lordship, page 21. I'll just read this document, Lordship. I am relying on these documents. Why I got the right. Belur Taluku Tahsildar Avara Ruguru, Ito Taluku Madihalli Hobli Agre Gramada Vasi Avale Gowdara Hendati Gangama, wife of Gangama, my mother. Gangama Agu Makkalu Ondu Javegowda, Veeregowda Hendati Bhagyamma, Malligowda, Puttegowda, Huligowda, Somegowda, Shankregowda are the Navugalu Edi Barayisida Erike. This is the statement given before the village accountant when he came to the village during the pendency of the matter before the deputy commissioner. Now, E Divasa Gramakke given by the petitioner's unit. ಈ ದಿವಸ ಗ್ರಾಮಕ್ಕೆ ಹೋಬಳಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಹಾಗೂ ವೃತ್ತದ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳು ತನಿಖೆಗೆ ಬಂದಾಗ ನಾವುಗಳು ಹಾಜರಿದ್ದು ನಮ್ಮ ವಂಶಸ್ಥರಾದ 3ನೇ ಮಗನಾದ H.H. ಕರಿಗೌಡ ಬಿನ್ ಅವಳೇಗೌಡರು ಶ್ರೀ ದೇವಿರಮ್ಮ ದೇವರ ಅರ್ಚಕ ವೃತ್ತಿಯ ಚಾರ್ಜ್ ವಿಚಾರ ಕುರಿತು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿ ಅಂಶವನ್ನು ತಿಳಿದುಕೊಂಡಿರುತ್ತೇನೆ. I contested the matter before the deputy commissioner after the death of my father. Therefore, Lordship, they came to the village. Now, ಸದರಿ ವಿಚಾರದಲ್ಲಿ ಈ ಮೇಲ್ಕಂಡ ದೇವರ ಪೂಜೆಯ ಸರದಿಯ ಮೇಲೆ ಒಂದು ಶ್ರೀ ಅವಳೇಗೌಡ ಬಿನ್ ದೇವೇಗೌಡ ಪೌತಿ ದಿನಾಂಕ 29/5/1996 ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ಸಣ್ಣೇಗೌಡ ಬಿನ್ ರಂಗೇಗೌಡ ಇವರು ಹಾಲಿ ಇರುತ್ತಾರೆ. 3ನೇ ದೊಡ್ಡೇಗೌಡ ಬಿನ್ ವೀರಭದ್ರೇಗೌಡ ಇವರುಗಳಿಗೆ ಸರದಿ ಮೇಲೆ ಪೂಜೆಯನ್ನು ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ಶ್ರೀ ಅವಳೇಗೌಡ ಬಿನ್ ದೇವೇಗೌಡರು ದಿನಾಂಕ 29/5/1996 ಮರಣ ಹೊಂದಿದ್ದು ಅಂದಿನ ದಿವಸದಿಂದ ಈವರೆಗೂ ಸಹ ಅರ್ಜಿದಾರರಾದ H.H. ಕರಿಗೌಡ ಬಿನ್ ಅವಳೇಗೌಡ ಅವರೇ ಈ ಮೇಲ್ಕಂಡ ದೇವರ ಪೂಜೆಯನ್ನು ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುತ್ತಾರೆ. ನಮ್ಮ ಚಾರ್ಜ್ ಅನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ವಹಿಸಿಕೊಟ್ಟಿದ್ದು ಅವರೇ ನಮ್ಮ ತಂದೆಯ ಸರದಿಯಂತೆ ಕರಿಗೌಡರೇ ವಹಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ಈ ದೇವರ ಪೂಜೆಯನ್ನು ಮಾಡುತ್ತಿದ್ದಾರೆ ಹಾಗೂ ಈ ದೇವರ ತಸ್ತಿಕ್ ಬಾಕಿ ಇರುವ 3 ವರ್ಷಗಳ ಮೊಬಲಗನ್ನು ಅರ್ಜಿದಾರರೇ ತಸ್ತಿಕ್ ಹಣವನ್ನು ಕೊಡಬಹುದೆಂದು ಹೇಳಿ ಒಪ್ಪಿ ಬರೆದಿದ್ದ ಹೇಳಿಕೆ. This is the statement they given before the village accountant.
Where do they give up their rights? They are only saying this was a claim.
Yes, sir.
That is why we asked you what were the claims when, because you are mixing up all the matters.
This is the statement given.
Now this was in 99.
It is in the year 99.
99, the dispute was between Avlegowda, Ajjegoda. Then your father Avlegowda, Devegowda. Then his brothers, Sonnegowda, Doddegowda and Swamigowda. That was the dispute at that time. So all of you brothers got together saying that everything is being done by you, they don't have any right, so it stays in your family. Now, after having that dispute, you have a dispute among your family.
Now, that is true.
So when you have a dispute among your family, where have they given up their right on hereditary rights?
Now kindly see this. After this inspection, let's kindly see the last portion. They themselves signed.
Yes.
And the charge has been handed over to me at page 20.
At the most, it would be a charge. The hereditary rights should have to be divided amongst all of you.
That is the finding given by the commissioner also now. Now I'll just point out these aspects and I'll come to that. Now after this inspection, the deputy commissioner passed order at page 25, document number 4.
Yes.
The type copy starts from page 32, Lordship. And page 40 is the operative portion.
Yes.
Last, Belur Taluku Madihalli, Agre Gramada Devirama Devara, Puja Madwa Salwagi, ಒಂದನೇ ಪ್ರತಿವಾದಿ ಪವತಿ ಮಗ ಪ್ರತಿವಾದಿಯ ಪವತಿ ಮಗ H.H. ಕರಿಗೌಡ ಬಿನ್ ಲೇಟ್ ಹವಳೇಗೌಡ, ಎರಡನೇ ಪ್ರತಿವಾದಿ ಶ್ರೀ ಸಂಜೇಗೌಡ ಬಿನ್ ರಂಗೇಗೌಡ ಮತ್ತು ಮೂರನೇ ಪ್ರತಿವಾದಿ ದೊಡ್ಡೇಗೌಡ ಬಿನ್ ವೀರಭದ್ರೇಗೌಡ ಇವರುಗಳು ಬರಾಬರ್ದು ಅರ್ಚಕರ ಹಕ್ಕುಳ್ಳವರಾಗಿ ಕಾರಣ ಇವರುಗಳೇ ಅರ್ಚಕರೆಂದು ಆದೇಶಿಸಿದೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಸದರಿ 3 ಜನ ಅರ್ಚಕರು ಶ್ರೀ ದೇವಿರಮ್ಮ ದೇವರ ಪೂಜೆಯನ್ನು ಸರದಿ ಪ್ರಕಾರ ಪೂಜೆ ಮಾಡಿಕೊಂಡು ಹೋಗತಕ್ಕದ್ದು. This is the order passed by the deputy commissioner. Till the date, it is not challenged. Nobody is challenged this order.
Correct.
Please,
It doesn't need to be challenged. At least not by them.
Please, that is what they are saying. Now, Lordship, kindly see next document number 5. Lordship, from 2001, 2007, they kept quiet. 2007, they submitted a representation to the deputy commissioner. Lordship, the deputy commissioner. Once again, they submitted representation. Deputy commissioner stated that last tamma anta shuru agutte. Tamma ನ್ಯಾಯಾಲಯದ ಸಂಖ್ಯೆ ಅಂತ that is order passed by the
Page number?
Page number 42. Document number 5. This is the letter submitted by the Tahsildar to the deputy commissioner.
Yes.
Tahsildar says that ತಮ್ಮ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಸಂಖ್ಯೆ so and so ದಿನಾಂಕ 11/9/2001ರಲ್ಲಿ ತೀರ್ಮಾನವಾದಂತೆ ಬೇಲೂರು ತಾಲೂಕು ಮಾದಿಹಳ್ಳಿ ಹೋಬಳಿ ಹಗರೆ ಗ್ರಾಮದ ಶ್ರೀ ದೇವಿರಮ್ಮ ದೇವರ ಪೂಜೆಯನ್ನು ಸರದಿ ಪ್ರಕಾರ ಒಂದನೇ H.H. ಕರಿಗೌಡ ಬಿನ್ ಹವಳೇಗೌಡ, ಎರಡನೇ ಸಣ್ಣೇಗೌಡ ಬಿನ್ ರಂಗೇಗೌಡ, ಮೂರನೇ ದೊಡ್ಡೇಗೌಡ ಬಿನ್ ವೀರಭದ್ರೇಗೌಡ ಇವರುಗಳು ಅರ್ಚಕರೆಂದು ತೀರ್ಮಾನಿಸಿ ಪೂಜಾ ಕಾರ್ಯವನ್ನು ನೆರವೇರಿಸಲು ಆದೇಶವಾಗಿರುತ್ತದೆ. ಆದರೆ ಸದರಿ ಆದೇಶದಂತೆ ಹುಲಿಗೌಡ ಬಿನ್ ಹವಳೇಗೌಡವೇ ಈ ಆದೇಶದಲ್ಲಿ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಈ ಕಚೇರಿಯಲ್ಲಿ ಗೌಡರಿಂದ ಇವತ್ತಿನ ಇವರ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಲು ಸಹಾಯವಿರುವುದಿಲ್ಲ. Subsequently, after the order, they would have challenged this order. They kept quiet and just.
Who is Urigowda now?
Please, Lordship.
Urigowda ಎಲ್ಲಿ ಬರ್ತಾರೆ?
Urigowda is my brother. Avlegowda, I mean, the Karigowda's brother. Last brother.
Urigowda, yes.
Now, Lordship, Deputy Commissioner issued endorsement at document number 43, I mean, page 43, document number 6.
Yes.
Lordship, and 44 is the endorsement given by the Tahsildar to the Urigowda. Page 44, Lordship, document number 7. It is on 16/8/2007, Lordship.
Urigowda is also given term.
Lordship, this is the endorsement given. Specifically stated that this is the order 2001 order. May I read you, Lordship?
Yes.
Lordship, ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೇಲೂರು ತಾಲೂಕು ಅಗ್ರೆ ಗ್ರಾಮದ ಹುಲಿಗೌಡ ಬಿನ್ ಹವಳೇಗೌಡ ಅವರಿಗೆ ಈ ಮೂಲಕ ತಿಳಿಸುವುದೇನೆಂದರೆ, ನೀವು ಅಗ್ರೆ ಗ್ರಾಮದ ದೇವಿರಮ್ಮ ಪೂಜೆ ಹಕ್ಕಿನ ಬಗ್ಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಈ ಬಗ್ಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಸಂಖ್ಯೆ ಸ್ವಯಂಸೋ ದಿನಾಂಕ 11/9/2001 ಆದ ತೀರ್ಮಾನದಂತೆ ಮಾದಿಹಳ್ಳಿ ಹೋಬಳಿ ಅಗರೆ ಗ್ರಾಮದ ಶ್ರೀ ದೇವಿರಮ್ಮ ದೇವರ ಪೂಜೆಯನ್ನು ಸರದಿ ಪ್ರಕಾರ 1ನೇ ಎಚ್ ಕರಿಗೌಡ ಪಿನ್ ಹವಳೇಗೌಡ, 2ನೇ ಸನ್ನೇಗೌಡ ಪಿನ್ ರಂಗೇಗೌಡ, 3ನೇ ದೊಡ್ಡೇಗೌಡ ಬಿನ್ ವೀರಭದ್ರೇಗೌಡ ಇವರುಗಳ ಅರ್ಚಕರನ್ನು ತೀರ್ಮಾನಿಸಿ ಪೂಜಾ ಕೈಂಕರ್ಯ ನೆರವೇರಿಸಲು ಆದೇಶವಾಗಿರುತ್ತದೆ. ಈ ಕಚೇರಿಯಲ್ಲಿ ತಮ್ಮ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಲು ಅರ್ಹವಿರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವನ್ನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಉಲ್ಲೇಖ ಪತ್ರದಂತೆ ನಿರ್ದೇಶನಕ್ಕೆ ತಿಳಿಯಪಡಿಸಿರುತ್ತದೆ. It is addressed to the Huligauda. Now, what Huligauda does, again one more representation, kindly come to page 45.
Yes.
This is the representation, document number 8 to the Tahsildar. All the petitioners here in Worship seeking the very same right, hereditary right.
Yes.
It is in the year 2007. 7. After the endorsement, one more representation has been given. Now, on the basis of representation, document number 9, Worship, the Tahsildar issues a notice saying that you come. Tahsildar is the subordinate authority.
To the
He cannot
deputy.
issue notice. Therefore, I filed a petition. Worship, kindly come to page 748.
Yes.
Document number 10. This honorable court specifically held Tahsildar does not have any right, but the ultimately Worship at page 53, accordingly repetition is allowed. Annexure that the notice issued by the Tahsildar is passed, while making it clear that insofar as the complaint of the respondent is concerned, it would be open for the authority vested with the jurisdiction to initiate appropriate proceedings while accepting the contentions of the petitioner, that such power cannot be delegated.
Yes.
There is no delegation now. Now, Lordship, kindly come to next page, that is page 55. Once again, Lordship, the assistant commissioner, even though Lordship, I have a right as per the 2001 order, ದೊಡ್ಡೇಗೌಡರಿಗೆ ಕೊಡ್ತಾರೆ ಸರದಿನ. ನನ್ನ ಸರದಿನ 2008 ಅಲ್ಲಿ ದೊಡ್ಡೇಗೌಡರಿಗೆ ಕೊಡ್ತಾರೆ. I filed appeal before the commissioner. It is my right. Lordship, kindly come to page 56, document number 12.
Yes.
Lordship, kindly come to document number document number 12. Interim order has been granted by the commissioner on the basis of 2001 order. Lordship, document number 13, page 57. Lordship, the deputy commissioner handed over me charge on 2008. Lordship, during the pendency of the matter before the commissioner, Lordship, the petitioner hearing filed impleading application. Document number 14, page 58. Lord. They filed impleading application. Lordship, kindly come to page 63. That is the order dated 15/10/2011, passed by the commissioner. On the basis of my petition, my appeal, Lordship. Now kindly come to page 64.
Challenging Doddegowda's.
Please, Lordship.
Challenging Doddegowda.
Please, Lordship. Challenging Doddegowda. Now kindly come to page 2, Lordship. Paragraph 2 in the second, page 64. Lordship, I'll read the four, 5 lines from that paragraph. ಅರ್ಜಿದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳಿಗೆ ನೋಟಿಸ್ ನೀಡಿ ಅಧೀನ ಕಚೇರಿಯಿಂದ ಕಡತಗಳನ್ನು ತರಿಸಲಾಯಿತು ಹಾಗೂ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಲಾಯಿತು. ಪ್ರಕರಣವು ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿದ್ದಾಗ ದೊಡ್ಡೇಗೌಡ ಬಿನ್ ವೀರಭದ್ರಗೌಡ ಮತ್ತು ಇತರ 6 ಜನ ತಮ್ಮನ್ನು ಪಕ್ಷಗಾರರನ್ನಾಗಿ ಸೇರಿಸಿಕೊಳ್ಳಲು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದರು. ಆದರೆ ತದನಂತರ ವಿಚಾರಣೆಗೆ ಸದರಿ ಅರ್ಜಿದಾರರು ಗೈರು ಹಾಜರಾಗಿರುವುದರಿಂದ ಅವರ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ.
ಇಲ್ಲಿ ಇದು ವೀರಭದ್ರೇಗೌಡ ಎಲ್ಲಿಂದ ಬಂದ?
ವೀರಭದ್ರೇಗೌಡ ಆಲ್ ದೀಸ್ ಇವ್ರೇನ್ ಎಲ್ಲರನ್ನ ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ನನ್ಗಿರೋ ರೈಟ್ ಪ್ರತಿ ಸಲ ನನ್ಗೆ ಸದ್ದಿ ಬರುತ್ತೆ ಅವಾಗ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು ನನ್ಗೆ ತೊಂದರೆ ಕೊಡುತ್ತೆ.
ದೊಡ್ಡೇಗೌಡ ಬಿನ್ ವೀರಭದ್ರೇಗೌಡ ಮತ್ತು ಇತರರು ಅಂದ್ರು. That is not the application which has been filed is not that.
No,
that is
kindly see that the entry page document number 11 ನಲ್ಲಿ ದೊಡ್ಡೇಗೌಡ ವೀರಭದ್ರೇಗೌಡಗೆ ನನ್ನ ಸರದಿನ ಕೊಡ್ತಾರೆ ಬೇರೆ ಇನ್ನೊಂದು ಫ್ಯಾಮಿಲಿ.
The problem that all of you are doing is each of you is doing one litigation without making the entire family a party. The entire family needs to be made a party and the disputes have to be sorted out in terms of page 20. That is not, he is also not clear. Again, it will be the same litigation.
We said that ಎಲ್ಲ ಸಂಸ್ಥರಿಗೆ notice ಜಾರಿ ಮಾಡಿ.
ನೀವು ಪೂಜೆ ಮಾಡೋದು ಬಿಟ್ಟು you want litigation ಮಾಡಿ.
Now, Lordship, kindly, I want to show two more documents, three more documents. Lordship, kindly come to page 67.
Yes.
That is the operative portion of the commissioner's order. Lordship, commissioner allowed the revision petition. ಸಕಲೇಶ್ಪುರ revision ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಸಕಲೇಶ್ಪುರ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಆದೇಶ ಸಂಖ್ಯೆ 19/3/2018. That is the Lordship, the notice issued by the document number 11. Lordship, ರದ್ದುಪಡಿಸಿದೆ. ಹಾಸನ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ದಿನಾಂಕ 11/9/2011ರಲ್ಲಿ ಆದೇಶವಾದಂತೆ ಅರ್ಚನಾ ವೃತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸರದಿಯಂತೆ ವಹಿಸಲು ತಹಶೀಲ್ದಾರ್ಗೆ ಸೂಚಿಸಿದೆ. Lordship, from the original order, I have to get the saradi. Now, next, Lordship, the document number 16, I got the saradi. Again, Lordship, kindly see document number 70, one more representation from the petition. Lordship, instead of challenging the 2001 order, keep on they submitted the representation to the authority. Now, this is the representation to the.
Harish, there are more than 20 people here.
Please, Lord.
Out of them, how many are employed, we don't know. Even if there are 12 who are employed, you will get only 1 month.
Now, Lordship, kindly see this document. This is very interesting.
ಎಲ್ಲ ನೀವು ಇಟ್ಕೊಂಡು don't get too greedy with everything. Your client seems to be the one who is.
Like 10 years, he was continuously doing the puja without us.
The only thing that we can direct now is to make all of you a party. Everybody, your cousins, once removed, twice removed, thrice removed, ಎಲ್ಲರೂ ಬರ್ತಾರೆ.
Page 95 ನಲ್ಲಿ. They know about the other.
ಅದೇ ಮಾಡಬೇಕಾಗುತ್ತೆ because otherwise this litigation will go on. Next, ಇನ್ನು ಅವ್ರು ಬರ್ತಾರೆ.
I produced one of the judgment documents for a court in division bench. The division bench specifically says that if there is a hereditary dispute under 25(b)(63), deputy commissioner has to look into the matter.
He has to look into it. There's no doubt about it.
Now, Lordship,
The issue is who are to be heard.
Lordship, everyone has to be. When hereditary right is.
None of you had made that statement till now. When you went before the deputy commissioner first time, only 4 of you fought amongst each other. When you went again the second time, only 2 of you fought against each other. Then 6 people intervened. That you objected. Third time, only those 6 people were there. Rest of them have been ignored.
The annexed.
Everybody has been whatever that they wanted to be.
Whenever hereditary dispute is arising, every family member has to be present. Because
There's no dispute. Your family tree is accepted. Only thing that has to be done is the entitlement palu of each of them under the sadri has to be given.
Now,
That's all.
may I make one last submission?
Really.
Lordship, before the commissioner now, they came before the commissioner and they objected the no objection certificate. That is the first case. And other thing they have, Lordship, therefore commissioner also observed that it is first time came before this court. You have to establish before the deputy commissioner. Therefore, it is remanded. And second thing, Lordship, the commissioner specifically says that 2001 order is not challenged before any of the authority. Lordship, from 2001, they kept quiet. They submitted representation, and instead of they challenging that order, if they challenge that order, obviously, Lordship, it is my order.
At the most, you are holding it for your family.
Please, Lordship, I have.
Ashte, you can't have exclusive right.
Lordship, I'm not saying that I have exclusive right, but ನನಗೆ ಕೊಟ್ಟಿರೋ ರೈಟ್ ನ ಇವರು ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡದೇ ಇದ್ದಾಗ, I have a valid order as in the.
That is not your individual right. That's not your individual right.
But they have not approached appropriate authority in a proper manner.
All of you are suppressed material. So now, if everybody comes, you'll get 15 days.
Now the senior submitted that there is a GPA. There is no such GPA. Our statement here all these documents are produced by me. They are not produced, none of the document. Our GPA is
ಅದಕ್ಕೆ each branch is coming up one by one. ನೀವು ಯಾವ branch ರೀ?
For Devegowda.
ನೀವು ದೊಡ್ಡ
The only person who could have claimed.
brother.
Let's.
You are the eldest brother.
Yes, please.
Heard, reserved.
My request is, matter may be remanded to the deputy commissioner, plus one more submission.
We'll remind by directing what exactly the Vamsha will be obtained by the deputy commissioner from the Tahsildar's office. Each of this one will be ascertained. All of them will be made parties and their entitlement and Havle Gowda will be divided equally, stage by stage.
Plus, may I ask for remand of the, remand order issued by the commissioner. Now, the deputy commissioner taken up the proceedings and it is listed on 3rd of 9.
The further proceedings, if any, pending before the deputy commissioner, is stayed till further orders.
Status quo between the parties.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ
Further proceedings we are staying.
ಪ್ಲಸ್ ಅದು ಕ್ಲೋಸ್ ಆಗಿತ್ತು ಐ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ರೀಕಾಲಿಂಗ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಟು
We are sending it back to the deputy commissioner, clearly detailing out what are the steps to be followed. Havle Gowda 5 ಜನ, ನೆಕ್ಸ್ಟ್ ಅವ್ರ ಮಧ್ಯದಲ್ಲಿ ಯಾರ್ಯಾರು ಬಂದ್ರು, ಅವ್ರದ್ದು ನೆಕ್ಸ್ಟ್ ಅದರಲ್ಲಿ ನೀವು ಬರೋದು ಇವಾಗ. ಸೊ ಫಸ್ಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ 1 year will be divided among 6. So it will become 2 months.
That is the case.
Second stage, 2 months will get divided among the 4.
What I am saying is,
Third stage, whatever is remaining will be divided among 6 of you.
what I am submitting, all these exercise has to be done by the deputy commissioner.
That is what we are directing the deputy commissioner. He'll get the genealogical tree from the Tahsildar and make everybody a party and divide it, including the stages also we'll mention. ನಿಮ್ದೇನಮ್ಮ? ನೀವು ಉಳಿಗೌಡ. You are the youngest brother. Youngest brother, Uligauda.
Youngest is always
That will be considered independently. Until your matter is there, you won't get a right. After that matter you can bring it to the notice of the deputy commissioner.
Now, commissioner, till the decision taken by the PC, the earlier, whatever
Arrangement.
it has to be continued ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. Let it be, otherwise ಈಗ ನಮ್ಮ ಸರದಿ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ 9ನೇ ತಾರೀಕಿಂದ ನಮ್ಮ ಸರದಿ.
ಇಲ್ಲ ಅವರೇ 10 ವರ್ಷ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ 10 ವರ್ಷ ಮಾಡಿದ್ರೆ
ಈಗ ಯಾರು ಮಾಡ್ತಿದ್ದಾರ ಅವರು till your lordships takes a decision.
Pass that order soon. Yes.
But the Tahsildar has given a roster that will be continued.
Whatever we have
comes.
not, only we have stayed the deputy commissioner proceedings,
Yes.
because deputy commissioner, if he passes some order, again, that will be another revision or appeal. So once we give the direction properly, he'll pass the order.
Serial number 33, Rachita Rajshekar. Connected by the Matrona senior.
Yes. 3 ಸತಿ ಆಗಿದೆ.
Last date of the they will, last date they should have copied. 7, 8.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ objection?
10 days.
That counsel for respondent number 1 to 6 point is granted. 2 weeks time final to file a statement of objection. Objections, if any, to be filed on or before 11th September, failing which it will be taken as not filed and matter proceeded with, relist on 17th September.
Interim order may be
Interim order earlier granted is expected.
Great.
34, M. Ramachandrappa.
Petitioner, we complied the.
Respondent number 1.
We're regularly paying the maintenance through the demand draft.
Yeah.
ಅಲ್ಲ. They received your, they received my lord. If,
ಅಲ್ರಿ ಒರಿಜಿನಲ್ ಡಿ ಡಿ ಇಲ್ಲೇ ಇದೆಯಲ್ರಿ?
no, no, that is a color print, my lord. Color print, we send through the years, they received and
11/11/24.
if they furnish account details, they have not. Last,
You produce the account statement of this account from which you took the DD. Whether it has been encashed or not.
Okay.
And in future, ನಿಮ್ಮ account number ಏನು?
Account number ಕೊಟ್ರೆ ನಾನು I will.
ಅಕೌಂಟೇ ಇಲ್ಲ ಅಂದ್ರೆ ಒಂದು ಅಕೌಂಟ್ ಓಪನ್ ಮಾಡಿ, ಜನ್ಧನ್ ಅಕೌಂಟು ಇಲ್ವಾ? ಅಂದ್ರೆ you don't exist ಅಂತ ಆಗುತ್ತೆ.
We are not
You open an account. You open an account, give us the account number, we'll direct them to transfer into that.
Please, my
account.
lord. We will,
So this
we
issue
will
is
deposit.
not there. Lord Counsel for the, our statement kodak Monday lagala, we'll direct them to
Please.
produce the bank statement. Lord Counsel for the petitioner has filed a memo enclosing letters,
Copies of demand drafts.
copies of the office copies of the letters sent by the petitioner to the respondent enclosing the demand drafts. Along with the said letters, color photocopies of the demand drafts have also been enclosed. The submission of learned counsel for respondent number 1 is, however, that those letters have not been received by the respondent and the demand drafts have not been encashed by the respondent, since the respondent does not even have an account, bank account. In that view of the matter, the learned counsel for the petitioner is directed to place on record the acknowledgement cards in respect of
One produced last in page number 8, 9 euro, 9 minutes. That is the first was sent.
The one ಮಾತ್ರ ಕೊಟ್ಟು ಬಾಕಿ
The one ಇದೆ, the rest of the things we are going to pass.
Though one of the acknowledgement cards has been produced, raised post acknowledgement cards has been produced at page 9 of the memo, the acknowledgement cards in respect of the other letters have not been produced. Hence, the counsel for the petitioner is direct place on record the raised post acknowledgement cards in respect to the other letters sent by raised post. He is also directed to place on record the bank statement of the account from which the bank demand drafts were received, as also a letter from the concerned bank that the demand, as regard the status of the demand drafts, whether they have been encashed or not. If so, by whom and to which account is the amounts transferred to. Since the counsel for respondent number 1 has stated that he does not have an account, he is directed to open a bank account and furnish the details thereof, so as to enable a direction to be issued to the petitioner to transfer the amounts to that particular bank account month on month as directed by this court earlier. Released on 10th September. ಅಷ್ಟೊಳಗೆ ಅಕೌಂಟ್ಸ್ ಎಲ್ಲ ತಗೊಂಡ್ ಬನ್ನಿ.
15th onwards, because of your
15th September.
35, Kalyana.
For the petitioner, my lord. Yesterday we filed no objection vakalat. Senior.
34 interim order earlier granted is extended. Yes, madam.
Senior B.M. Arun sir name is not reflecting in the cause title, madam. Kindly have it on.
B.M. Arun has filed wakalatnama for whom?
Petitioner.
Petitioner. Submitted that Shri B.M. Arun has filed wakalatnama for the petitioner. Registry is directed to print, verify and print his name as that appearing for the petitioner. If such wakalatnama is filed, registry is direct delete the name of Shri Kalyanar as that appearing for the petitioner. Respond number 6 is this.
Objections are ready, my lord. I'll file it today.
You are filing your
Yes,
objections. Who is R6? Why is it dispensed with? R6 serve ಆಗಿಲ್ಲಲ್ಲಮ್ಮ. There is no order of dispensary.
It's a temple.
The RC matter. The private
Committee, secretary,
Was it right?
represented by secretary. Notice has to.
issue notice to respond number 6, returnable by 7th October.
Serial number 36, Kavita Damodaran. Connected matter.
For the petitioners in these matters, Your Lordship. The order dated 18/4 seems 7/11 seems to have complied with. I've been just served with a copy of the.
To create charge. Charge has been created.
This is insofar as the first writ petition is concerned, Your Lordship. The second writ petition is only a writ of mandamus
So
to execute
just
the
a moment.
orders.
To enter the order of attachment. 36, petitioner is before this court seeking for the following reliefs. The AG has filed a memo enclosing certain documents indicating that a charge in respect of the subject property has been created as per the order dated 18/4/24. In that view of the matter, the reliefs which have been sought for in the above petition have been rendered already complied with, rendering the above petition infructuous. The petition stands disposed as such.
36.1, Your Lordship, my prayer is to complete the auction as per the recovery certificate. What has happened is subsequent to the issuance of recovery certificate, I filed a writ petition and came to be disposed of. Non-compliance of that writ petition, I filed a contempt proceedings. Contempt proceedings judgment can be seen at page number 19.
This for recovery certificate and 40.
Yes, Your Lordship.
Ah.
Contempt petition order is at page number 19.
Okay, why it has not been implemented as a recovery certificate?
I'll have to verify.
Prove it, that's all.
It's only a writ of mandamus if Your Lordships can issue it.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the recovery certificate issued under section 40 of the RERA Act by the Real Estate Regulatory Authority has not been complied with by the respondents by bringing to auction the property of respondent number 3 developer. And AG on instruction submit that the office of the Special Deputy Commissioner has been created for the purpose of implementing the recovery certificates issued under section 40 of the RERA Act, and given 30 days time, necessary action could be taken. Given 60 days time, necessary action would be taken. His further submission is that if the petitioners were also to furnish the details of the properties owned by unencumbered properties owned by respondent number 3, it would enable speedier action to be taken by respondent number 1. In that view of the matter, the such submission answering the grievance of the petitioner, granting liberty to the petitioner to place on record any details of any of the properties owned by respondent number 3, and directing the respondent number 3 to
That's
take
one
action
small
within 8
submission.
weeks from
They
today.
have
the petition.
already, as per their submission in the contempt proceedings, 25% of the deposit is already made, and they've taken a submission, made a submission that it's already been sold. If Your Lordships can see the contempt petition,
You
to
do-
that
you-
extent at least.
You are enough only with that much.
No, at least to that extent if it can be given to me.
8 weeks from today. The disbursal of the amounts to be done as per the applicable provisions.
Great.
Serial number 37, Arjan, 38, Prithvi Kiran Shetty. Namo.
I'm appearing for the petitioner in this matter, Your Lordship.
Yes.
The petitioner in this matter.
You don't want to file wakalatnama for respondent number 3? That will not file in respect of. So long delay. Registry direct correct the appearance of the councils as learned AGA for respondent number 1, Sri Venkatesh Arbatti as for respondent number 2 and 3. Yes.
Your Lordship, the case is that the petitioner, when he was working as chief officer of Yalandur district, he had issued a building license in respect of one HV Chandru. This,
We'll come back. You have filed your objections.
Not yet.
Not yet.
Not yet.
You want to file or
We'll file, man. We'll file.
you can argue like that only. If you
No,
want.
in fact, short point, whether there is delay, short
How
point,
ಹೇಳಲ್ಲ.
Lordship may have it immediately after 2:30.
Immediately ಅಲ್ಲ. It will come back.
I mean, whenever it is. Yes, great.
Yes, madam.
This is serial number 21. I request that should be taken up at 2:30 because. the matter I
2:30 list
mentioned-
2 will be taken up. 1, 2, 3, 4, 21.
ಏನೋ ಹೇಳಿದ್ರಲ್ಲ ಹೌದು. ಫಸ್ಟ್ ಧಾರವಾಡ 2 ಮ್ಯಾಟರ್ಸ್, ಕಲಬುರ್ಗಿ ಒಂದೇ ಒಂದು, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಅಲ್ಲಿ ಯಾರು ಎಷ್ಟೊತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ, ಯಾರು ಟೈಮ್ ತಗೊಂಡು ಹೋಗ್ತಾರೆ, ನನ್ಗೆ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ?
2:30.
ಜೋರಾಗಿ ಹೇಳ್ಬೇಕು ಹೇಳಿ. ಅದು ಗೊತ್ತಿಲ್ಲ ಸರ್, ಯಾರು ಎಷ್ಟೊತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ. ಹೌದು, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆನೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್. ಅದೇ ಹೇಳಿದ್ರಲ್ಲ ಮಧ್ಯ ಅವಾಗ್ಲೇ ಯಾರೋ ಹುಡ್ಕೊಂಡು ಬಂದಿದ್ರು. ಏನ್ ಗೊತ್ತಾ, ಆರ್ಡ್ರು ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ, ಇನ್ನ ಸೈನ್ ಆಗಿಲ್ಲ ಅಂತ. ನೆನ್ನೆ ಆಗಿದ್ಯಾ ಅಪ್ಲೋಡ್ ಆಗಿದ್ಯಾ ಆರ್ಡ್ರು? ಫೈಲ್ ಮತ್ ಒಂದು ಇಲ್ವೇ ನಮ್ಮ ಹತ್ರ? ಅವ್ರು ಕಳಿಸ್ಬೇಕು. ಫೈಲ್ ಕಳ್ಸಿದಾರ? ಫೈಲ್ ಇದ್ರೆ ತಾನೇ ನೀವು ಮಾಡಕ್ಕಾಗೋದು. ಹಂಗೆ ಏನ್ ಮಾಡ್ತೀರಾ? ಏನಿಲ್ಲ, ಫೈಲ್ ತಗೊಂಡ್ ಮಾಡ್ಬೇಕು. ಫೈಲ್ ಬಂದ್ರೆ ಕೊಡ್ತೀನಿ. ಒಂದ್ ಫೈಲು ಇಲ್ಲ ನೋಡಿ, ಆ ಕಡೆ ಕಾಣಿಸ್ತಿದ್ಯಾ? ಇದೆಲ್ಲ ಇವತ್ತಿಂದು, ಇವಾಗ ಕರಿಬೇಕು ನೆಕ್ಸ್ಟ್. ಇಲ್ಲ, ನಾನೇನ್ ಮಾಡ್ತೀನಿ ಹೇಳಿ? ಕೈ ಹಿಂಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ. ನಿಮ್ಮ ಹತ್ರ ಇಷ್ಟೊಂದು ಏನ್ ಹೇಳಿಸ್ಕೋಬೇಕು ಅಂತ. ಫಸ್ಟ್ ಧಾರವಾಡ, ಕಲಬುರ್ಗಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಅವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಇಲ್ಲ, ಯಾವ್ದು ಬರ್ಲಿಲ್ಲ. ಇವತ್ತಿನ 21. ಹೇಳಿದ್ರಲ್ಲ, ಅದು ಬಂದಿದೆ ಇವತ್ತು ಅಷ್ಟೇ. ಇನ್ನೇನ್ ಬೇಕದ್ರಲ್ಲಿ? ಫೈಲಲ್ಲಿ ಫುಲ್ ಎಲ್ಲ ಇದೆಯಾ ಅಂತ ಒಂದ್ಸತಿ ನೋಡ್ಬಿಡ್ಲ. ಇವ್ರಿಗೇನು ಉತ್ತರ ಹೇಳಿ ಕಳಿಸ್ಬಿಡ್ತೀನಿ ಆಮೇಲೆ. ಬೇಡ, ಫೈಲ್ ಬರ್ದಾಕಿ. ಅದಿಂದ ನನಗ್ ಬರಲ್ವಲ್ಲ, ಇದು ಪಾಸ್ ಓವರ್ ಅನ್ನೋದಕ್ಕೆ ಕೇಳಿದೆ. ಬೇಡ, ಬರೆಯಂಗಿಲ್ಲ. ಟೆಂಪ್ಲೇಟ್ ಫಸ್ಟ್ ಧಾರವಾಡ, ಕಲಬುರ್ಗಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಅವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಅಲ್ಲಿ ಏನ್ ಗೊತ್ತಾ, ಫೈಲ್ ಎಲ್ಲಿದೆ ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನೀವು ಮಾಡ್ಬೋದು, ಎಲ್ಲಿ ಸಿಕ್ಕಿದ್ರು ತಗೊಂಡ್ ಮಾಡ್ಬೋದು ಅಮೆಂಡ್ಮೆಂಟ್. ಈಗಿದ್ರೆ ಹಿಂಗ್ ಕೊಟ್ಬಿಡ್ತೀನಿ. ನಿಮ್ಮ ಹತ್ರ ಇಷ್ಟೊಂದು ಹೇಳಿಸ್ಕೊಳಂಗೆ ಇಲ್ಲಲ್ಲ. ನೀವು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿನ ಅಲ್ಲ, ಕೈಯಲ್ಲಿ ಇದೆಯಾ ಫೈಲು? ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತಾನೆ ಇದೆಯಾ? ಹೆಲ್ಪ್ ಮಾಡ್ಲಾ? ಜಾಗ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತೀನಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಹೆಲ್ಪ್ ಬೇಕು ಅಂದ್ರೆ ಇದೆಯಾ? ಅಪ್ಲಿಕೇಶನ್ ಬಂದಿದ್ಯಾ? ಡೈರೆಕ್ಷನ್ ಸಪರೇಟ್ ಫೈಲ್. ಅದು ನೆನ್ನೆ ಫೈಲ್ ಮಾಡಿರೋದು ಡೇಟ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸುಮಾರು 50 ಸಲ ಅವ್ರಿಗೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ ಆಗಿದೆ, ಕೋರ್ಟ್ ಮುಂದೆ ನೀವು ಕಳಿಸಿ 4 ಸಲ ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಕಳಿಸಿ.
ಅಲ್ಲ, ಅದೇನಾದ್ರು ಅಪ್ಲೈ ಮಾಡೋಂಥದ್ದು ಏನಾದ್ರು ಇದೆಯಾ? ಅಲ್ಲ, PF ಕೊಡ್ತೀರಾ ಇರೋದು, ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್. ನಾಳೆ ಬರ್ತೀರಾ ಸರ್?
ನಾಳೆ ಬರ್ತೀನಿ. ಕೋರ್ಟ್ ಮುಂದೆ ಮೂವ್ ಮಾಡಿದ್ರು ಕೂಡ ಈಗ ಬೇಕಂತೇಳಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಕಳಿಸ್ತೀವಿ.
ಕೊಡ್ತೀರಾ? ಕಳಿಸ್ತೀರಾ? 70. ಸರ್ ಇದೆ ಇದೆ. ಈಗ ಧಾರವಾಡ 2 ಮ್ಯಾಟರ್ಸ್, ಕಲಬುರ್ಗಿ 1, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಕೋರ್ಟ್ ಗೊತ್ತಿಲ್ಲ.
Previous 10 years.
42. ಅಲ್ಲ ಇವತ್ತಿಂದ ಇಲ್ಲ, ಇನ್ನು ಕರೆದಿಲ್ಲ, ಅಲ್ಲಿವರೆಗೂ ಬರ್ಲಿಲ್ಲ. ಅಷ್ಟೇ ಲಾಸ್ಟ್, 38 ಲಾಸ್ಟ್. ಅದೇ ಮಧ್ಯಾಹ್ನ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಅದೆಲ್ಲ ಮುಗ್ದು ಟೈಮ್ ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಕಳಿಸ್ಬಿಡಿ ಚೇಂಬರ್ಗೆ, ಅಲ್ಲಿ ಹಿಡಿತೀನಿ. ನೀವು ಪ್ರಿಂಟ್ ಮಾಡಿ ಕಳಿಸಿ. ಪ್ರಿಂಟ್ ಬಂದೇ ಬಿಟ್ರೆ ಹಾಕು ಬಿಡಿ, ಪರವಾಗಿಲ್ಲ. ಅದು ಸರಿತಾ ಕುಲಕರ್ಣಿ, AGA. AGA ಸರಿ. ಒಂದು ಇನ್ಫ್ರಾಕ್ಷಿಯಸ್, ಒಂದು ಇನ್ನೊಂದು ಡಿಸ್ಪೋಸ್. ಫಸ್ಟ್ ಒನ್ ಡಿಸ್ಮಿಸ್ಡ್, ಎರಡನೇದು ಡಿಸ್ಪೋಸ್.
ಸಂಬಂಧನೂ ಅಲ್ಲ, ನನ್ನ ಸ್ನೇಹಿತನೂ ಅಲ್ಲ ನನ್ನ ಸಂಪರ್ಕಿಗೆ. ಸುಮ್ಮನೆ ಅವರು ಪಿಟಿಷನರು ರಿಲೇಟಿವ್ ಏನು CCB ಅವರಿಗೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಡ್ತಾನೆ. ನಿಮಗೆ ಏನು ಕರ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಪೇಷಂಟ್ ಕರ್ಕೊಂಡು ಹೋದ್ಮೇಲೆ ಅರೇಂಜ್ ಇಂಟಿಮೇಷನ್ ಎಲ್ಲನೂ ವೈದ್ಯ ಯಾರೋ ಸ್ನೇಹಿತರು ಯಾರೋ ಬಂದಿದ್ದಾರೆ. ಆಗಿತ್ತು CC ಕರ್ಕೊಂಡು ಹೋದ್ರೆ ಯಾರೋ ಸುಬ್ರಹ್ಮಣ್ಯಪುರ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್
ಇಲ್ಲ ಬರ್ತಾರೆ ಕೊಡ್ತಾರೆ ಆ ಪೇಪರ್ ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಕೊಡ್ಲೇಬೇಕು ಅದು. ಇನ್ನೊಂದು ಇದೆ. ಇಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಅವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಹೌದು ಹಾ. ಹೇಳಿ ಸರ್. ಈ ಕನ್ವೀನಿಯನ್ಸ್ ಬೇಡ. ಪಿಟಿಷನ್ ಇರುತ್ತಲ್ಲ ಅದ ಪಿಟಿಷನ್ ಇಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಅವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಆತ ವಾಲ್ಯೂಮ್ 1 and 2 ಅಂತ ಇದೆ ಇದೆಲ್ಲ ಗವರ್ಮೆಂಟ್ ಸ್ಟೇಟಾ ಸ್ಟೇಟ್ದೇ ಬೇಕಾ ಮೆಮೋ ಇದು ವಾಲ್ಯೂಮ್ 2 ಒಂದು ಇದೆ. ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಅದು
ಸೀರಿಯಲ್ ನಂಬರ್ 55 ಏನಾದರೂ ರೀಚ್ ಆಗ್ಬೋದಾ ಮೇಡಮ್? ನಾ ಕೇಳ್ಬೇಕಾ ಈಗ? ಅದಕ್ಕೆ ಕೇಳಿದ್ದು, ಒಂದು ಡೇಟ್ ಏನಾದರೂ ಕೊಟ್ಬಿಟ್ರೆ ಇನ್ನೂ ಒಳ್ಳೇದಲ್ಲ ಅಂತ ಮೇಡಮ್. ಮೇಡಮ್
ಡೇಟ್ ಇವಾಗ ಕೊಡಲ್ಲ, ಸಂಜೆ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ. ಗೊತ್ತಿಲ್ಲ ಯಾವ್ದು ಎಷ್ಟೊತ್ತು ನಡೆಯುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗಲ್ವಲ್ಲ. ಅದು 4 ಗಂಟೆ ಆದ್ಮೇಲೆ ಬರೋದು. ಪಾರ್ಟಿ ಇದಾರ ಮಾಡಿ ಇಲ್ಲಿ ಕೊಡಿ ಒಂದು. ಕಲಬುರ್ಗಿ 1, ಧಾರವಾಡ 2. ಇಲ್ಲ ಇದು ಕಲಬುರ್ಗಿ ಜಾಸ್ತಿ ಆಗ್ಬೋದು. ಹೌದು 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 ಮೆಮೊ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೆಮೊ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಷ್ಟೇ ಹಂಗೆ ಮೆಮೊ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಫೈಲ್ಡ್ ಇನ್ ಕೋರ್ಟ್ ಕೆಫುಲ್ ಅಂತ ಬರುತ್ತೆ ಎಲ್ಲ ಬರುತ್ತೆ ಲಾಗಿನ್ ಅಲ್ಲೇ ಆಗ್ಬಿಟ್ಟು ಆಮೇಲೆ ಓಪನ್ ಮಾಡ್ಬೇಕು ಬೇಡ ಬಿಡಿ ತೋರಿಸ್ಲಿಲ್ಲ ನಡೆಯುತ್ತೆ ಇಲ್ಲಿದ್ದಾರೆ ಎಲ್ಲ ತೋರ್ಸೋದೇನು ಬೇಡ ಬರೀ ಅಪ್ಡೇಟ್ ಮಾಡಿ ಇಲ್ಲಿದ್ದಾರೆ ಇದ್ದಾರೆ ಅವ್ರೇನು ಇಲ್ಲಿ ಬರಲ್ವಲ್ಲ ಎರಡು ಇದೆ ಕಲಬುರ್ಗಿ ಇದೆ ನೆಕ್ಸ್ಟ್ ಇಲ್ವಾ ಒಂದೇ ಪೇಜ್ ಒಂದೇ ಒಂದು ಇಲ್ಲ ಇಸ್ಕೊಳ್ಳಿ ಇದೆ ಇದೆ ತಗೊಳ್ಳಿ ನಾಗರಾಜ್ ಇದೊಂದು ಫೈಲ್ ಬಂದಿದ್ಯಾ ಅಂತ Dharwad bench matters, serial number 1. Yeah, Abhijit,
I
yes.
appear for the people.
Mirrors, this is for compliance of mirrors directions, wherein mirrors in the last on the last date of occasion mirrors we have filed an application seeking extension of time. The time was extended mirrors, but as there is non-cooperation from the mirrors forest authorities, now mirrors we have preferred a writ appeal mirrors.
Forest department is not cooperating with you.
Yes,
Why is
mirrors.
it your own department?
Yes, mirrors. Because mirrors to the some extent mirrors the SIT is mirrors investigating. Therefore, mirrors records are with SIT and they are not cooperating. In view of the
If
same,
your departments are fighting, what happens to the citizens?
Therefore, mirrors to take appropriate directions, mirrors writ appeal is also filed. So maybe mirrors this matter may be adjourned by 2 weeks, mirrors. If any orders, mirrors we will get in writ appeal. I'll mirrors
You can wait for that also, but if who is not cooperating with you from the forest department?
Mirrors, the I shall place on record mirrors because the CCF is.
We'll bring the principal secretary of forest on record.
Please.
Anyway, you only have to accept notice for that.
My lords,
Please.
there is one submission I want to make. My lords, there is this paper. this is a village map. This is a layout of the village in accordance to which land was allotted to me 40 years ago.
You have already file a contempt.
No, just
We
my
can't
submission
look
may
into
be
that.
heard, my lord, just for a moment. What has happened is the land is already been allotted 4 decades ago. So now what has to be done is only rectification of the survey numbers, which they have not done. They cannot say that the
Is what we
survey
have
is to be
already
done.
directed. Now Forest Department is not cooperating. We'll bring them on record. Have you filed a contempt?
I had filed a contempt, but the contempt was dropped for the reason that an extension has been sought. Moreover, when the extension was sought, the application was not been supplied to me. And because it was,
Yes, Mr. Uppar, what is all these things you're doing?
my lord, there is just one more documents which I want to.
They're not fair.
Now, Millers,
Don't do
I
this.
also inform my learned friend that Millers now writ appeal Millers FR number.
Because you seek for extension and thereafter you don't do it, and now you say Forest Department, then
My lord.
there's nothing, there's no, it doesn't inspire confidence.
No, Millers. Now we have tried Millers as per Millers our IFR extension. We have done Millers almost more than 50% of the work Millers. Now the pendency is from the Department of Forest
My
Millers.
lord, there is just one more thing. They say that there is discrepancy.
Shri Praveen Uppal and AJ submits that though the Revenue Department has complied with the directions which have been issued to a large extent, complete compliance could not be made due to non-cooperation on behalf of the Forest Department. In that view of the matter, the state of Karnataka, represented by its Principal Secretary, Forest, Ecology and Environment, is brought on record as respond number 4, counsel for the petitioner to carry out necessary amendment and file amended cause title. And AGA accepts notice for respond number 4. And AGA is directed to the Principal Secretary, Forest, Ecology and Environment is direct to file an affidavit by next date of hearing indicating the compliance which have been made and why the Forest Department is not cooperating with the Department of Revenue. Relist on 17th September.
My lords, may I have it on 18th of September.
18th September.
Please.
Serial number 2, SR Hegde Associates.
Yes, Mr.
In
Uppal.
this matter, yes, Millers. In this matter, Millers, since February 2026, the file is Millers pending with the Chief Executive Office of Center for E-Governance, Millers. Till date, Millers, we are not having any reply from them. Therefore, Millers.
And AGA submit that. No, you have got a reply on 4.6 saying that the functional requirements have been approved. And that will be, that is what was recorded on 4.6.
Yes, but now the final Millers outcome would not be Millers coming from the Center for E-Governance.
AGA submit that necessary instructions and or information has not been received from the E-Governance Department. The Chief Executive Officer, E-Governance Department, is direct file an affidavit stating by when all the actions will be completed. Relist on 18th September.
Please, please.
Kalburgi bench matter, SP Patil.
Petitioner. There appears to be a compilation which has been filed just now, given to me in court just now. This is the compilation. And another thing, my lord, they have
It
filed
seems
a
to be
note.
very small compliance.
On the last occasion, my lord recollects, somebody had appeared on behalf of the AG and said, papers were filed here. Now, I was given a note. In that note, there are certain survey numbers of lands which apparently vested in the government, given to the tenant, and I was paid certain amount, but those papers are not found with them. So the officer, he was talking to me just now with my with the AG's junior. So he said he has got the papers, but he has not filed it. So, my lord, may I?
Sorry, he's not got the?
He has got the papers, but he has not filed it. Though the note says the papers are lost. The note which they said they had filed in court.
Where's Mr. Vijay Kumar?
No, this one, these two. This is a note that you said you have given it to the.
See, where is Mr. Vijay Kumar? He's in some other man. Contempt. He's appearing for the contemner. So now what is the status then?
Lord, if my lord, because I have just been given this, I have not even seen a page of this. Just now at around.
Okay, this you have been given, you have not been given the earlier set.
No, this has been given just now. However, a note which was apparently circulated last time, which I don't know whether it is there or not. Courtmaster, is a note like this there on the record? Oh, but you said last time you had filed it. Oh. Lord, in fact, if my lord
You have been given a note and one compilation now.
the note was given earlier. I mean, this is with due respects, the AG gave me directly. He said, Mr. Jaikar, I'm giving this to you. Now, this compilation has
Both
come.
of you have become friends with.
Yes, my lord. But in this note,
Is he coming now? So what do we have to do? We have to pass over? What do you want to do?
but we were thinking of, that's what he said, a short date may be given. That's all I'm saying. Only thing is, my lord, may I only say one thing? They said they have these documents, which is in their note, which is not in this. So they said, we have it, we'll file a compilation, another compilation.
Another compilation.
Yes, yes. Now, this is what I was told just now. No, they're not there. Yes.
We have dumbbells, we don't need this. How much will you be filing? And again, it will be adjourned on that ground. So you're not filing anything, only this much?
No, only 2 is still to be filed.
Give that. You're filing that now?
Yes, sir.
That AGA is filed a memo with document. What is this? Memo with documents. A memo with documents titled Volume 3. Copy thereof has been served on the counsel for the petitioner. The said memo is taken on record. So you are going to file those other documents also, or anything to be filed?
Two survey number documents were there,
Uh,
tomorrow, only two survey number documents are there. One is Uchit Navadi and one is Devan Balganur.
Okay, then if you are finding it, serve it on the council. So if they are going to, assuming that they are going to serve it next week,
Would my lord, is 9th all right with my lord?
will you be able to go through all of them by that day?
Yes, yes. Lord, I can't take a risk because after that comes Ganapati, and in Bombay it is a.
1 week
No,
you will be.
Yes, 10 days.
Pre-list on 9th.
Much obliged.
Two 30 matters. List number 2, serial number 1, Karthi Somsekharaya.
Lord, apologies that we are troubling your lordship, my lord, with a disposed of matter, my lord. But my lord, I'll just point out 2 things, which, my lord, I feel, my lord, at least I feel, my lord, subject to what your lordship says, that the compromise is unconscionable. Now, kindly see, my lord, the order sheet at page 88 in the, my lord, writ petition papers, my lord.
It may be unconscionable. As long as you have accepted it, how can you say it is?
No, my lord, it cannot be, my lord. I'll just point out 2 things, my lord.
Yes.
Lord, this suit is filed on 6/6/2023, my lord. Then, my lord, on 7/6/2023, my lord, summons is issued. Issue summons if proper PF is paid and returnable by 27/7/2023. Then, my lord, I do not understand, my lord, how it gets referred to, my lord, the Lok Adalat on 8/7/2023. And, my lord, on that very day, my lord, lady, my lord, files a wakalat on behalf of the petitioners. And, my lord, a compromise is already kept ready, my lord, and it is signed. Now, my lord, this compromise.
Lady, in the sense, an advocate has filed.
Advocate files a wakalat on that very day, my lord. It
You
says
have not
so.
authorized. You did not authorize.
Lord, a wakalat is signed, my lord. Lord, I've taken instruction from the client. They have signed the wakalat, my lord. But they were not aware of this Lok Adalat and compromise thing, my lord. Now, kindly.
Before the Lok Adalat, they have signed the order sheet.
They have signed the order sheet, my lord, but it was, my lord, by fraud, my lord, by misrepresentation is what I'm saying. No, the second point, I'll just say.
It is so. If you take action against that council and make.
We have already filed, my lord, application, my lord, before the bar council, my lord. That's a part, my lord. But I'll just point out one more point, my lord. There are 3 properties involved in this compromise, my lord. The first property, my lord, is mortgaged in favor of my father, my lord. So I am a holder as a mortgager. It is not a joint family property. Second property, my lord, the sale deed is in my name, my lord. The sale deed is in the petitioner's name. So it is again not a joint family property. The third property, my lord, also, my lord, belongs to my mother, which is, my lord, 40 into 15 site in Bangalore. The other two properties are Nelmangla properties, my lord, which is about 1 acre and odd. Both the properties, my lord, about 2.5 acres, my lord. That, my lord, is shared by the plaintiff and defendant number 4 and 5. Third property, which is already my mother's property.
Mr. Male, if your client was not a party to it, we would have intervened.
I understand, Lord.
If your client had not signed it, we would have intervened.
No, if she had not signed it, then there would be no decree.
Exactly. Now, if a person were to sign a compromise before the Lok Adalat, and Lok Adalat disposes the matter, and if later on a person comes and says, no, I was misled, that would be a very easy ground to be accepted.
No, I am only pointing out,
then
Lord,
every Lok Adalat, this one will be allowed to be set aside.
Lord, I am only saying this because, Lord, now against the Lok Adalat, my lord, I cannot file a fresh suit. I can't file
That is
an
the whole
appeal.
purpose. That is the purpose.
Yes, my lord. So, my lord, the writ is the only option, my lord, that I have. And here, my lord, this court, my lord, has dismissed it at the preliminary hearing stage.
The purpose of Lok Adalat is that if a settlement is arrived at Lok Adalat,
No,
it
but
should
a
not be
settlement,
questioned.
Lord, a settlement of my own property, which is given to others, my lord,
You have
is,
signed
my lord,
it.
it is not a joint family property, my lord. The documents are before your lordship.
Why did you sign it?
Lord, that's the thing, Lord. That the lady is here, my lord. They were misrepresented, my lord. They were.
Explain that to us, then we can consider. Once you sign the order sheet, the compromise petition, you wait for 3 years.
Lord, that also there is a thing, my lord. That is explained in the
Thereafter you
review
come.
petition. That is explained in the review petition.
First
Lord, there was
explain
another writ petition
Why did you sign it?
because, my lord, the plaintiff there, my lord, is a relative, my lord. Lord, he takes the lady and her children, my lord, to the court, Lord, and gets it signed, my lord. But on that day, my lord, when the decree is signed, when the compromise petition is signed, there is already a litigation pending before this honorable court, which later on gets, my lord, allowed in my favor. And thereafter, my lord, when they go to, my lord, get the khata changed, that is when they realize, my lord, that this compromise has happened and their names are entered.
Kalamma and Shivkumar.
Yes, my lord.
3 of you are there.
3 of us are there.
It's not just the lady.
No, correct.
you've been
And
only
the
arguing
lady
saying-
and the children, my lord. But they are here, my lord. They are totally, my lord, uneducated people, my lord. My lord, I don't want to point out, my lord, I can't give exhibits here. But, my lord, this is all that I can say, my lord. That
Chandrasekhar, Kalamma, Shivkumar. Chandrasekhar is 54 years, Kalamma is 47 years, Shivkumar is 19 years. Bhagyamma is 53. These are not children.
No, I mean,
The first two of them are 54 and
husband and
47.
wife.
Husband and wife.
Husband and wife.
And you are saying only lady, as if it is only the lady who was there.
No, I'm saying, my lord, the property, my lord, belongs to that lady, my lord, which is now allotted to her in the compromise.
What is the husband doing?
Very well, my lord. I can't press it more than this, but, my lord, I felt, my lord, that, my lord, because it is their own property, my lord, how can, my lord, they agree for a partition when it is not a joint family party?
After having signed, unless you make out a case why they signed, they were forced, they were taken, put at a gunpoint and signed all those things, yes.
No, we have mentioned in the review petition that, my lord, it was by misrepresentation. That is what we have said, my lord.
You had a counsel who was appearing for you.
Lord, that counsel, my lord, filed the wakalat on that very day.
Yes, but have you taken any action against?
Yes, my lord. We have filed a, my lord, petition.
Once the bar council takes this one, then
Action,
you
my
come.
lord, then we. Yes.
The counsel for the petitioner submits that action has been taken against the counsel who had appeared for the petitioners when the compromise was recorded. The category of submission of the senior counsel for the petitioner is that the petitioners did not know the said counsel, and wakalatnama was obtained by the plaintiffs in the suit on that very day, and the counsel appeared on behalf of the petitioners. His further submission is that the petitioners are not aware of the terms of the compromise. Since a serious action has been taken against the counsel in order to enable the petitioner to place the same on record, pre-list on 11th September.
11th. Or your lordship may give a later date also, my lord, so that BCI can take
18th, re-list on 25th September.
25th. Obliged.
Serial number 2, Maitreyi Krishnan.
Modification.
Lord, for the petitioners, BBMP has moved this matter. This is a disposed of matter, Vijayanagar street vendors.
A1 of 26.
The directions were issued that we should move the carts, etc. All the directions are complied with. Not sure why they have moved the matter.
Yes, Pawan.
I need to update my instructions. What has happened was for the senior citizens, my lords have said that for them, they can leave their material there only, or some space should be made available.
Vijayanagar.
So we have made some space available besides police station, Vijayanagar police station. But the petitioners are refusing to go there and keep their belongings there. So I will update my instructions whether they have kept their things, because in the night they were leaving their own.
Milord, they identified a space, but there are vehicles parked out there. So we requested them, you please clear it. Oh, this is only with respect to the senior citizens. The others are all moving the carts as per the directions. For the senior citizens, we said they will also move there, but let it be cleared. If my land friend can take instructions from the
police
GPA.
station.
Produce the photographs also.
I will update my things.
You produce where they are parking, not where they are supposed to.
So, what's the development? I'll resend
For respond number 1 to 4 and 7 is filed the application IA1 of 26, seeking for modification. The submission made by council for respond number 1 to 4 and 7 is that in the space identified for senior citizens, they are not storing the goods at that location, but continue to store it on the road. The council for the petitioner submit that in the place which has been identified, the vehicles are parked, and as said, the items of the petitioner could not be stored there. The council for respond number 1 to 4 and 7 seeks for and is granted a week's time, 2 weeks' time.
2 weeks.
Get his further instruction as also to place the photographs of the location which has been identified, indicating that the same is empty and capable of being used by the senior citizens.
My lords said the police station should also coordinate. Where's the police station space? So the police
As long
also.
as it's empty, they can use it. If you're
Yes, we will ask them. Yes.
list on 17th September.
Yes, obliged.
Much obliged.
Serial number 3.
My lord, in this case,
I appear on behalf of the petitioner, my lords. This is a matter pertaining to.
my lord, one make submission now. In this case, I am appearing proxy counsel on behalf of Sumangala Gachinmat for represent respondent number 2, my lord.
Yes.
She is not keeping well. I think she is. Can you please kindly adjourn the matter for next week, ma'am?
This is
not
that
keeping
matter
well.
pertaining to allotment of industrial site in Nelmangla, my lords. The lordships had directed an affidavit to be filed. They have done so. On the strength of that affidavit, the matter may be disposed of.
Council is
He is not keeping well, my lord.
not well.
Kindly have it on next week.
My lords, it may be taken up on Monday, my lords.
When is she back?
After 3rd only.
The council for respond number 2 and 3. The council are appearing for respond on behalf of the council for respond number 2 and 3 submit that the arguing council is unwell. Relist on 3rd.
Much obliged.
In the same list, my lord.
At preliminary hearing.
In list 2, my lords.
In list 2. Yes.
Much
Well,
obliged.
interim order to be extended.
Interim order earlier granted.
Great.
Serial number 4. Naveen Jain.
Extension of parole. You surrendered.
ನಾಳೆ ಇದೆ ಸರೆಂಡರ್ ನಾಳೆ ಇದೆ ಸ್ವಾಮಿ.
What is the reason for the parole?
ರೀಸನ್ ಮೇಲೆ ಪ್ರೀವಿಯಸ್ 60 ಡೇಸ್ ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ. ಅದು ಹೌಸ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ವಿ.
House construction we want in.
ಹೌಸ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಈಗ 4th ಗೆ ಅವ್ರದ್ದು ಗೃಹ ಪ್ರವೇಶ ಇದೆ.
ನೀವು ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. 6 months you are cooling off ಮಾಡಿ.
At least ಒಂದು 15 days ಮೇಲೆ. I producing invitation card also ಮೇಲೆ.
Only medical things we are in. IA1 of 26 has been filed.
At least
for
10 days
extension of parole. The parole earlier granted expires tomorrow. If that be so, it would be for the petitioner to surrender to the jurisdictional jail authorities, and after the cooling off period, apply for a fresh parole. Reserving such liberty, IA1 of 26 stands dismissed. Much.
Serial number 5. Rakesh B. Bhatt.
Rakesh Bhatt. Ilva. None appears. Relist on 18th September.
Number 6.
refer the respondent statement regarding that FR.
You got the busy man here.
My lord, in complaints of the daily order dated 13/1/2026, my lord, there are a series of directions in para number 4 of the daily order, my lord. In complaints of that, my lord, now the state has come up with a committee and a coordinated committee, and a government order has been passed to constitute a special committee to look after the illegal overstay and illegal stay of the foreigners, my lord.
The
First
committee has
document,
been-
your lordship will get it in page number 3.
So 8/4/26 ಆಯ್ತು ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು?
My lord, kindly see page number 3, my
16/4
lord.
is the meeting.
3.
Yes.
Wide order dated 8/4/2026, my lord, the committee was constituted. Thereafter, the committee
How long
was.
will you take?
My lord,
How long will the committee take?
my lord, the proceedings have taken place on
13/1.
that. Yes, my lord. Thereafter, there is one more uh, order dated 22/7/2026. Your lordship will get it in page number 10, my lord. There we have roped in certain. We have constituted a core working group, my lord. These are the members, my lord. They have acting upon that.
When will you?
My lord, even sometimes, my lord, that we have achieved some.
Time ಅಂದ್ರೆ ಎಷ್ಟಪ್ಪ 1 day, 2 day, 3 days?
My lord, in that 4 weeks, my lord, I'll see that, you know.
Correct ಆಗಿ ಅದು ಹೇಳಿ ಅಷ್ಟೇ. 4 weeks ಅಲ್ಲ 6 weeks ಅಂದ್ರೆ ಮಾಡಿ. The memo has been filed by learned AGA. The submission, enclosing certain documents. The submission is that a state level coordination committee under the chairmanship of the Additional Chief Secretary Home Department has been formed by government order dated 8/4/26. A meeting was held of the said committee on 16/4/26 when directions were issued to the various departments. Subsequently, the committee has also been reorganized as a core working committee. Subsequently, from and out of the heads of the department, a core working committee has been constituted who is looking into the matter. He seeks for and is granted 6 weeks' time to place on record the progress which has been made. Relist on 6th October.
Serial number 7, Prithviraj DA.
ಜಾಫರ್ ಯಾರಪ್ಪ ಇದರಲ್ಲಿ? Where's Jafar? Where's Jafar?
He's held up in another court. He's on his legs in another court. I'm sorry.
Well, there's a list of trusts which are supposed to be formulated. We're formulating that list before we upload it. It requires some time. Section 81. Formulating the list of trusts which are there, which will have to be put into revenue entries. We require some time
And
for that.
AGA submit that the compliance is under progress. The public properties are being identified, as also the entities owning the public properties are being identified. He seeks for 4 weeks' time, please, to report compliance. Relist on 6th
My lord,
October.
I'm appearing for petitioners, my lord.
Yes. The matter has been disposed. You don't need to appear. This is between us and the government.
Oblige.
Serial number 8, Ravi L. Vaidya.
SPP's office, my lord.
Their SPP office. Paso.
Serial number 9, H.C. Shivramu.
ಏನಪ್ಪ ಇವತ್ತೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ.
Maybe Melody is
Where's
an
this
amendment to that rule where the suitable business premises, that may be the reason, that complaint.
ಅದ ಏನಾಯ್ತು?
Maybe that is the reason. Order.
ಕೊಡಿ ಅದೇನು? Jaffer is also not here, Mrs. Kulkarni is also not here.
8 ಅಲ್ಲ sir?
8, 9, 9.
A policy to be submitted as regard that compassionate appointment.
That I'm not. I'm not.
Order. Is it residential premises, business premises? AGS 6 fund is granted. 2 weeks time. Relist on 11th September.
Serial number 10. Lakshmi Narayan Care, party in person.
Learned AGS filed. Disposed of matter. Inna ಎಷ್ಟು ದಿನ ಬೇಕು? How long do you need?
4 weeks, 2 months.
FSL lab. And AGS filed an application for extension of time than that granted while order dated so and so. Accepting said submission, time granted is extended by a period of 8 weeks. Made clear that no further extension will be granted. The compliance to be made by 30th October. 10 of your application.
We have summoned him in substance of the Honorable High Court order where he is directed to give a statement. Instead, he chose to give his reply by this submission. And one such allegation, my lord, is para number, page number 14, clause 15F. Recent times, this woman has been physically attacking me and slow poisoning me within the unconscious.
Is there some of these allegations we are not able to, but is there some way of
Not able to investigate this matter. If there is an offense, it has to be to the IPs.
is there some way of providing medical assistance to the complainant?
It's difficult for us to investigate. These are the things. Yes,
If there's some medical assistance required, provide it. So that
direct investigation.
don't treat him as a adversary.
We wanted to record his statement, but he says he comes and gives this kind of submissions, where he again he make a point where we did not investigate in a proper manner.
As per your investigation manual, if somebody does like this, is there any provision of assessing their status of mind and providing medical assistance? Nobody will do that. October 30th. Yes. 8 weeks. Birthday. Who's next?
Serial number 11. Gautam Chand.
Yes, Mr. Prashant. They'll file the amended cost title. That's only for the purpose of the officers to be brought on record. That's all. You are appearing for whom? You are the one appearing for all the corporations. What have we done?
Appearing for petitioner in this case, madam.
Just carry out the amendment including all these corporations. What have we done? Last time Prashant wanted everybody to be implemented. They'll get the instructions. 2-3. Again 6 for a short accommodation. Relist on 25th September.
Serial number 12. Puneet Kumar.
E-Janma integration, my lord, the center has to answer.
Center has to ASG. Who is appearing in this? 12.
Well, by a certain.
We'll put your name. ASGI's name was there. Now we'll put your name.
This is served.
Yes.
Alexa.
Shri Mahesh Arkulgut is registry directed to print the name of Shri Mahesh Arkulgut as that are paying for respondent number 5. Vinay Venugopal is that are paying for respondent number 5. So on 18th September.
13. Yaman Madhusudan, connected matter.
2 weeks time.
Not in this matter. ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ನಿಮಗೆ ಟೈಮ್ ಕೊಡಲ್ಲ ಮೊನ್ನೆನೂ ತಗೊಂಡ್ರಿ ವೇ ಸತ್ಯಾನಂದ್ ಪಾಸು ಅವ್ರು ಬರಕ್ ಹೇಳಿ ಅವ್ರಿಗೆ
14.
Yes.
The GST has become the center for
Yes.
the commercial taxes department.
What has happened?
On the last occasion, the GSTN was included.
Who appears? Arvind Chauhan appears. Arvind appears for them.
I believe so. I think the 19th June already.
So Arvind Chauhan, where is it? ASG ಎಲ್ಲಿದ್ದಾರೆ ಇಲ್ಲಿ? Arvind Chauhan for respond number 8. Paso. Just ask Arvind Chauhan to come. Paso.
16.
Yes.
But in this matter, my lords, the WP number 30657 of 2025, in paragraph number 20 of my lordship order, my lords. That order was also been dealt by the honorable division bench, my lords. I pass over the division bench has already disposed of that matter, and my lords, the impugned order also has been observed to be does not survive in writ appeal, my lords. The matter which is listed is also disposed of matter, my lords. In page number 61 of my lordship order, my lordship had observed that certain directions has been issued. 3/11/2025, my lords. It's why this petition is listed is, my lord, in paragraph number 20.1.
In which matter?
My lord, in 31057 of 2025. May I read my lordship order, my lords?
31057. Yes.
Yes, my lords. Page number 61, my lord, paragraph number 20.1.
Yes.
This court by its daily order dated 13/11/2025 and WP number 30657 of 2025 had directed the state to furnish certain information. My lord, that order has been already been dealt by the honorable division bench, my lords. In the writ appeal number 1921 of 2025. That order I had passed over to my lordship, my lords.
Writ appeal 1921 was challenging 31057.
Yes, my lord. That daily order 13/11/2025 was challenged, my lords.
That is challenging. Direction issued and so on. So.
On that time, my lord, the entire writ petition was taken on board, and the writ petition was disposed of. My lord, the impugned order also observed to be does not survive by the honorable division bench, my lords.
Because you have said that you will comply with, they'll comply with 107 and you will give the gold.
Yes, that is what happened in division bench. But why this matter is listed today is, my lordship had issued certain directions in 20.1, paragraph number 20.1 in page number 61. In view of that complaint, so it is listed.
They'll have to comply.
That direction is already been,
No, that has not been set aside.
the division bench which has been observed is the impugned
What has it
direction.
been? No. The only thing that has been said is please don't do these kind of things.
My lords, my paragraph
Mr.
number
Anish,
7, my
don't
lords.
try to misinterpret and misquote the order.
My lords, may I kindly see paragraph number 7.
Para number 7 is in view of the present appeal is disposed. That's all.
In view of the above, WP number
View of the above is para
30657 is
4 and
taken on
5.
board.
Read para 4 and 5 that you
Yes,
will
that is on
apply.
merits.
And they'll do 107. That's all.
Yes, yes.
This direction has not been set aside.
But that is what my lords, may I kindly see the order, my lords. This writ appeal is filed under section 4 of the Karnataka High Court Act, praying to set aside the direction issued by the Learned Single Judge in WP number 30657 in order dated 13/11/2025 from paragraph number 3 to 12 and grant such a relief and further reliefs. That is what has been challenged.
If you want, we'll place it before the division bench now with your submission.
But that was a writ appeal. That order, that daily order was
Place your
challenged.
submission now on record and place it before the division bench for clarification.
But that order was been challenged. My respect, I had appealed before the division bench.
It's
My
been
respectful-
challenged but not set aside. Your writ appeal was disposed on the basis of submissions made.
Yes, my lords.
So don't try to get away with all these things.
But what the division bench has observed that impugned order does not survive. That is what it was observed by the.
Not what impugned order does not survive.
But that is in paragraph number 7, my lords. The impugned order does not survive.
We'll place it on record and ask the clarification. You want us to do that?
But I am this
You want us to
matter.
do that, we'll do that.
But I leave to my lordship. I just want to on the date of my lord's
Learned counsel for the petitioner
one submission.
submits that.
One submission. My lord, this matter, IAFL matter was listed today, printing my name. I just want to bring in the notice of this order before my lordship. That's what I am doing.
You made a submission that
Yes,
this
my
does
lord.
not
This
survive.
is what has been
So we're
happened.
asking for the clarification if it does not survive
Yes, my lords.
by placing your submission on record.
Yes.
So when it goes before the division bench, you make your submission there.
Yes, my lords. Yes.
The matter has been listed today for compliance with para 20 of the order dated 4th February 26 in WB number 31057 in the above writ
Three.
petition. And counsel for the petitioner submit that the said order had been challenged in WA number 1921 of 2025.
Not the said order, my lords. The order in WP number 30657 of 2025. My lordship, observations in the paragraph number 20.1 also I may be permitted to read.
Can we dictate
Yes, my lords.
or do you want to dictate?
My lord, no, the WP number, the present interpretation order is not challenged. This order has been final, it's absolute. I'm only making a clarification with regarding to
Again,
the.
a dictation ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿ. Give the
No,
dictation.
but my respectful submission is that.
You have made your submission, we are dictating, so
Great,
please
Great.
take your seat.
Yes, ma'am. It's great.
Please take your seat.
Great.
Advocates, when they stand, want to talk. Please take your seat.
My lord, my
Please
respectful.
take, see, that's
Yes,
why you're standing and talking. Has been listed for compliance with the direction which had been issued in para 20 of the order dated 4th February 26. Shri Anish Jose Anthony, Learned Counsel appearing for the petitioner, would submit that the directions which had been issued on 13/11/25 in WP number 30657 of 25 had been taken up on appeal in WA number 1921 of 2025, and this court and the division bench, honorable division bench, recording the submission, held that the impugned order in WP number 30657 of 2025 does not survive, and on that ground he submits that the compliance with directions in para 20.1 in the order dated 4th February 26 is not required. Is not required, or what is your word for that?
No, my lords. The original order is 13/11/2025.
That is what we dictated. So what about this compliance? According to you, is not required, is it?
But that order dated 13/11/2025 is the honorable division bench has observed that does not survive. That is my submission.
now
I am
what
not
is-
making any submission that My lordship, order dated 4th February 2026 is not, need not be complete. But on the date of the, when the matter was taken on board, this writ petition, writ appeal order was
What
not.
is your submission? Why are you wasting the time of the court? If there is no submission that you are making.
My lord,
to comply, we will ask them their compliance.
only,
There are no
my lord,
submissions.
only I am making, my lord, when this matter was argued, this writ appeal order was not taken.
What is that? Okay. Panini, what has happened on compliance? Yes.
The arguments from both the sides have been over and they have withdrawn the.
He is trying to mislead us, so
But
that is okay.
with regarding to, my lord, the writ appeal challenging the final order, this petition order is withdrawn. I am not making any submission with regarding to that, my lords.
NF?
Yes, my lords. Even I.
Yes, Mr. Panini.
I'll submit, 1 week time may be granted, my lord. I'll submit about the complaint.
They are misusing this because you are delaying.
My apology.
So we'll ask the Home Secretary to file an affidavit.
No, my lord, kindly have it on Monday, my lord. I'll submit on.
And AJ seeks for 2 days' time to comply with para 20.1 of the order date 4th February 26. If compliance is not made by that date, affidavit of the Home Secretary would have to be called for. Relist on 31st.
Okay.
Grateful, my lords.
17, E.R. Mohan.
Lords, I appear for the respondent in these matters.
17.
Lords, this was earlier
railway
a memo
thing.
for being spoken to. Thereafter, there was a IA
Railways.
file for amendment
Railways.
for 70 to 71. Railways.
Where's Mr. Mohan? He has carried out the amendment.
17.
He mentions the matter. Non-amendment of IA. None appears for the petitioner. Relist on 10th September.
Lordship may just kindly make a mention in seal number 12. Your Lordship had directed me to take notice. There, it does not indicate in the cause list that the ASG has been served. Can there be a direction for service?
AG for R5.
I have amended the IA1.
One nimsha. He's mentioning something else.
Seal number 12. There is no, generally ASG is served on the Barodo, but otherly cause list.
We have implemented a authority and requested him to take notice.
A copy.
Copy kottirbeku.
You've implemented.
Copy kodi.
I'll.
Yes, Mr. Mohan, what have we done?
I have carried out the amendment on IA1 of 25.
Now, what is the other application which is pending? Innೊಂದು application pending ಇದೆ ಅಲ್ಲ ಎರಡು application ಹಾಕಿದೆ.
Survey number corrections I made. IA1, page number 5, you will keep. 5 of the IA. IA1 of 25.
IA1 of
25. IA1 of 25 below the petition copy, which was filed on 9/12/25. Page number 5, Lordship.
9/12. When was it filed?
5, Lordship.
IA1 of 26.
Yeah. Yes, survey number I corrected. In red I have corrected. IA1 of 25. Lordship.
25.
Yes, IA1 of 25. Immediately after the petition it is there.
It's 71. Seven. disposed by this court on 7/7/26. Subsequently, an application had been filed in IA 1 of 26 to amend the said application IA 1 of 25 on the ground that the survey number which had been mentioned in IA 1 of 25 being survey number 70 was a typographic error and wrongly mentioned. It ought to have been survey number 71. The said application
Para 5 will achieve.
came to be allowed
Petitioner cannot
It
claim
came
any
to be
right.
on 18/8/2026, and the amendment has been carried out. In view of the said amendment which has been carried out, there would be a correction which would be required to be made of the order dated 7/7/26. Hence,
Reconstruction is being started, that's why in survey number 70 it is mentioned, so 70 will achieve.
hence, the following corrections are directed to be made. In line 6 of para 2, the reference to survey, the number 70 to be deleted. In line 9, survey number 70 to be replaced with 71. In para 5, page 3.
Fifth line you will achieve. Fifth line.
Line 5, survey number 70 to be replaced by 71. Line 8, 70 by 71. Line 12, 70 by 71. In para 7, line 3, survey number 70 to be replaced by 71. The last but one line in para 7 to be replaced, 70 to be replaced by 71. In para 8,
No change.
ಇಲ್ಲಿ ಬರಲ್ಲ.
Para 7 second line you will achieve.
This cannot be carried out, Mr. Mohan. Because if that amendment is carried out, it would not make any sense.
On perusal of the amendment application,
17
the claim has been made in respect 28, survey number 71 it is.
Till para 5, it can be replaced.
Para 5, fifth line.
Their submission, Your
Fifth
Lordship.
line.
It is their
Till
submission.
para 5, bada, till
Fifth
para
line.
4. Para 4 can be replaced. Para 5 is their submission.
7 ನಲ್ಲಿ
Para 7 ನಲ್ಲಿ, if that gets replaced, it will not make any sense.
Para 7 second line. The perusal of the amendment application would indicate that the claim has been made in respect of 28 quintals in
ಅದು
survey number
ಮಾಡಬಹುದು.
70.
ಅದಾದ್ಮೇಲೆ ಬೇರೆ ಏನು
It is 71.
ಅದೊಂದು ಮಾಡಬಹುದು. ಬಾಕಿ ಎಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. Para 7, line 3, 70 to be replaced. The first reference to survey number 70 to be replaced with 71. The rest of references to survey number 70 continue.
Deeply obliged.
Obliged. As for other aspect, main matter, the DCR is going on, there's no problem. Obliged. Sorry, because of some mistake.
One mistake led into 3 applications. Yes.
Serial number 18, Chandra Prabha DS.
Yes, Mr. Kambi.
ಹಾಕಿದ್ದೀರಾ?
Yes, Mr. Alva.
ಏನ್ ಹಾಕಿದ್ದೀರಿ?
My lord, I've complied and I've given the copies to them.
Sorry.
I had moved an IA on Monday. I filed it in the counter. And there is an objection raised that I have not served it to the petitioner. I have served it, my lord.
What application? When did you file the application?
IA number 4, I have filed it Monday, my lord.
Monday file. ಇದೆಯಾ? ಕೊಡಿ.
ಎಂತದಿದು?
What is this application for?
My lord, what we have done is we had sent a mail and also contacted the officials of the GBA to clarify
Want a clarification?
whether 249 is in toto applicable or not. So for that, what they have done is they have moved a trial of the paper. So it has gone to several offices I have mentioned in the IA, but no clarification has come about. But recently, only yesterday, the town planning office gave their note sheet telling that 249 cannot be applied directly because there is no amendment or a rules framed by the state of Karnataka as of yet. But the 5% what was there in the earlier acts of that margin of error, that has been made a larger to 15% with some amount of compounding fees. Those are those 5 amendments what we have listed in the IA. So there are 3 conflicting issues here. One is according to the Supreme Court in the Barjatia judgment and in the ongoing Loganathan versus State of Tamil Nadu, no regularizations are possible for any illegal constructions at all. So it's still going on, and the Chief Commissioner of the GBA has been implicated in this Loganathan case as a respondent number 20. It's still going on. That clearly states Barjatia judgment should be scrupulously followed and no regularization can take place. Number one. Number two is this section 249 is a continuation of the section 249 of the BBMP Act, which was relying upon the amendment what took place in 2013, that is section 76 FF of the Karnataka Town and Country Planning Act, which is in abeyance due to the stay order in the Akrama Sakrama case. So there is some change in the wording telling that 1 year before the GB Act, things can be regular. I mean, unlawful buildings can be regularized. However, there's a recent state government amendment telling that up to 15% only the unlawful can be.
You want a clarification?
Yes, whether which of these 3 is applicable here.
But you want to challenge to, but it's their writ petition.
No, I'm not challenging. They have moved
challenging 249.
They have moved an application or other, they have given a representation to the commissioner who is the competent authority to look into the section 249. The town planning has given their note sheet. If the court permits, I can transmit.
This application will have to be answered by respondent number 1 and 2.
Yes, my lord. 1 and the commissioner of the GBA BWCC, because he is the competent authority under section 249.
What is Commissioner BWCC GBA?
Now, from September 2nd, 2025 onward, my lord, GBA is not a single entity. It is a parent entity, and 5 baby corporations or sub corporations have come about. Among them are Central, South, East, West, and North.
Bangalore West.
Yes, we come under the Bangalore West City Corporation, my lord.
Have you furnished a copy to Mr.
Yes, my lord, I have submitted the copies.
IA 4 of 26 has been filed, seeking for clarification from respondent number 1 by respondent number 5 and 6.
4 and 5, my lord.
4 and 5, seeking for clarification from respondent number 1.
And commissioner.
None appears for respondent number 1. A week's time is granted for respondent number 1 to make a submission on the said application and the clarification which has been sought for. Relist on 10th September. Please.
Much sorry.
19, Chokka Reddy, corrected by the.
Appearing for respondent number 1 to 3, madam, on behalf of Sumangala Gachinma.
Yes, madam.
Kindly grants 2 weeks.
The request of council for respondent number 1 to 3 relist on 3rd Allah, we have posted the other matter.
Oh, 1 to 3, madam.
Your other matter we posted on 3rd.
3956.
Third.
Third.
Serial number 20.
This is regarding that placing of these MTP reports to third parties. We have sensitized, my lord, 14 hospitals. We've sensitized 14 hospitals as regards to your lordship's SOP.
Only 14.
14 of the main hospitals.
What about your juvenile justice? This one, child care.
That will require some time. 14 hospitals are sensitized.
Even the Director General of
AG has
Police
filed a memo indicating that 14 hospitals, 14 major hospitals have been sensitized as regards the SOP, and they would be following the SOP. Insofar as the childcare officers, etc., his submission is that the sensitization drive is going on. He seeks for 8 weeks' time to place the further progress on record. Pre-list on 4 weeks' time. Pre-list on 30th September. At least something will be happening.
21. Manasi
May
Kumar.
it please the Honorable Court.
WP is disposed.
Yes, Your Lordship. On 19/8, Your Lordship had passed the judgment. Paragraph 3 at page 4, if I may point out to the relevant portion, 5th line from the top. In that view of the matter, reserving liberty to the petitioner to move the pending proceedings before NCLT on 28th, which was the next day, and directing NCLT to take up the said matter and pass such orders as may be necessary in the matter, the petition stands disposed. And then in the last line, to also exercise its discretion to protect the assets of the companies in the manner that it deems fit.
Yes.
So on 20th at 4 a.m., I e-filed all the papers as Your Lordship had reserved liberty to provide all of it. 10 a.m., I physically filed it. 10:30, I mentioned the matter, which was accepted. And end of the board, I was heard for nearly 100 minutes, 1.5 hours.
100 minutes.
Yes,
You
that's
took
how
so much
long
time.
the hearing went on. And senior counsel for respondent on the other side appeared online, argued the matter. Their only objection was that we haven't filed an affidavit. And so we pointed to NCLT Rule 14 rules, which basically exempts
But why have we moved this matter now? What is it?
Your Lordship, from that date until now, NCLT only sat on 21st, which was the immediate next day, for half a day. After hearing me for that long, no order was passed on that day, nor on the next day. I, in fact, tried to mention the matter online the next day, but because they rose early, I was not allowed to inside the courtroom proceedings. And thereafter, there has been no sitting. And in the meanwhile, I've received complete information that not 16 as pleaded in the application, but 36 containers full of my assets worth 150 crores have been moved to Mumbai. On 21st, as soon as I came to know about this, I even wrote to respondent number 2 herein, who is the successful bidder, and I had it hand delivered, notifying him that I've initiated all these proceedings and any sale is going to be subject to it. The hand delivery did not even get completed because when the person went there, and I've produced pictures along with my application, it's an under construction building. The security guard said renovation or something, but that's the address on the MCA website. So the only email ID on the MCA website is all I could serve him on. I've not received any further information thereafter. And now the apprehension is R2 is going to immediately sell the assets. He's received it for a meager 16.6 crores, what is worth 150 crores plus. And this is a case of absolute fraud and suppression of documents by the respondent. So that is what I would like to point out. If your Lordship may permit me 10 minutes, I'll be able to demonstrate the fraud played by the respondent, because of which today my estate is going to be completely empty. Once the assets dissipate, even though NCLT may pass an order on 31st of August or 1st of September, nothing else will remain. So all I'm asking for is a status quo.
Mr. Kamath, NCLT is your favorite. You are there when these kind of things come up.
In fact, I just communicated to the ministry that we desperately need a second bench. I've received a complaint from so many lawyers. Bangalore is one of the busiest NCLTs, and we don't have
Coming before us in so many matters, our hands are tied.
I understand.
There may be fitting cases for us to pass orders, but only jurisdictional decorum is what we are.
Now there is a PIL seeking a direction for the constitution of the second bench.
See, in this matter, that is why we had.
No, in fact, I did receive a copy from Mansi. I went.
We fixed the date also because there is one resource professional as regards one company filing it as regards another resource professional in another company. So that resource professional is taken away the assets of this first company.
Yes, yes.
it requires an order to be passed, but
Absolutely,
only
absolutely.
because of
They should
jurisdictional
have- they
issues
should
we
have.
are refraining.
And I also looked into their calendar. The Monday, Tuesday, they had a calendar holiday out of the, and then Wednesday was a public holiday. Yesterday, today, the judicial member is on leave. So, which is why there is some difficulty.
We'll restrain in this for them to sell. But let them consider the application. Can't help it. Otherwise, if it is sold, then.
But my lord, I thought this is a perfect 227 situation.
Yes. But because of the jurisdictional issue, 227 is normally self-imposed fetters. This court had wide order dated 19th August 26, acting within the self-imposed fetters under Article 227, declined to intervene and pass any protective orders in respect of the petitioner, sought for by the petitioner, by directing the petitioner to approach the NCLT on 28/26, while directing the NCLT to take up the matter and, if necessary, to protect the assets of the company in the manner that it deems fit. The counsel for the petitioner submits that in personal said direction, the petitioner had moved the matter before the NCLT on 21st August 26,
20th, Your Lordship.
20th August 2026, and addressed arguments for nearly 100 minutes. You argue too much, that is why. Argue less. You argue 100 minutes, then when will they pass orders?
That was in a lighter way that may kindly not be mentioned in the order.
Argued for considerable period of time. But, and thereafter, on what happened on 21st?
They sat for half a day.
21st, the sitting was only for half a day and the matter could not be taken up.
No orders were passed. They rose
Orders-
on 20th. to
Arguments are
pass orders.
completed.
Concluded.
Arguments, though concluded, no orders could be passed and the matter was adjourned to.
There's nothing that they said on next date, but the main matter is listed for 21/9. That was the original date given on 13/8.
And the main matter is now listed on 29/26.
21/9.
21/9/26. There being a serious ground made out as regard dissipation of the assets of the petitioner company represented by its resolution professional, by way of sale of a resolution professional of the first respondent company. The fact remaining that both the companies are undergoing CIRP process, the interest of justice would require that the assets of the petitioner be protected pending orders to be passed by the NCLT. Hence, respondent number 1 is restrained from conducting any auction or sale of the properties of the petitioner till orders are passed by the NCLT.
My information is that it's already with respondent number 2 now. In the interim, 36 containers have left the Indospace Bomsandra
There
warehouse.
is no
and-
sale which has taken place.
I'm sorry?
Is there a sale which has
Yes,
taken
auction sale.
Auction has happened.
Auction sale happened on 13th of August.
Then how do we intervene?
Your Lordship, so I had filed my application on 25th of July. After I filed my application, they issued the public auction notice on 2nd of August, which was a Sunday, giving a notice of only 4 days to invite bids. And in 4 days, they
Then
managed to
a
obtain
status quo
5.
may help. A status quo as on today.
A status quo along with a direction to respondent number 2 to, I mean, he needs to be restrained from dissipating the assets of the petitioner. Because as of today, there was a direction on the respondent number 1 RP.
If there is an auction which has taken place, then we can't pass any orders.
The auction itself was subject matter of,
Until that is set aside, your consequential reliefs cannot be considered in
yes,
426.
and for that I will have to file another application seeking to challenge the sale itself. But in the meanwhile, if this respondent number 2 is allowed to dissipate the assets and sell it as junk, 150 crores will be reduced to nothing. And my estate will be completely dead-ended.
Your auction is carried out, madam, unless it is set aside, you can't ask for
It's
this
only in
relief.
the interim, Your Lordship. It's
Can't
only in the
follow
interim.
through to the
May I point out the suspicious circumstances in which the auction itself has been carried out, which itself demonstrates the fraud, which will eventually, I may eventually be entitled to it, but by the time NCLT will decide that fraud has vitiated the entire process, the assets will be gone. So despite having a positive order in my favor, I'll be left with nothing. And there's nothing I'll be able to do. My assets are, so the registered office of both these companies was the same, because they were a holding company and a subsidiary company. They held their assets in common warehouses. The distinction between these two companies is the corporate data that I represent catered to children from pre-KG to grade 3. And the holding company catered from grade 4 to grade 12. While my product was basically a Learn Station tablet, which was a custom-made tablet for children of ages 3 to 9. So it's basically an assembled product and is not pertaining to any one brand like Samsung or Lenovo. Whereas those...
To get into all these things in 227,
our
jurisdiction is restricted.
227, if your lordship, even my prayer today is a status quo ante, but if not for an ante order, if I were given a status quo today,
how do we do that?
No, a status quo to the second respondent before your lordship, notice has not been issued. But if the second respondent is today not directed to not do anything with the assets, I'm not even asking him to bring it back to the warehouse. I'm not even asking for that. Let him hold what he has and give it.
If it was only the first respondent, yes. If it is a second respondent, it is a private entity. Your matter is disposed. Now we can't pass that order.
No, so when I filed my writ petition, this had not yet happened. So today I'm in a situation where despite having taken every step possible from 25th of
that
July.
extent we cannot do. If it was in the first respondent, yes, we could have done. Not at the second
Your lordship, the very reason why they have prevented this whole thing from happening is because they wanted the first respondent to immediately hand over possession. So on 3rd August, when I mentioned this to the Honorable Tribunal, they told me 13th August, the matter has been fixed for hearing on the main petition. The sale closure by R1 is slated to happen on 14th August. So we'll only hear you on that day. So despite having filed my application on 25th, they did not do it.
Madam, we can't do that now.
Just for a status quo order, in order to, my submission is only this, your lordship. If today there is only a status quo to all and sundry as is, then let NCLT decide the matter on merits.
Has been filed for ordering of status quo. The above matter had already been disposed by order dated 19th August 26 without issuance of notice to the respondents. When the matter has been disposed, the question of after disposal issuing a status quo order on as regards parties who have not been served in the matter would not arise. Liberty is reserved to the petitioner to move the NCLT. 31st they are sitting. 31st there is a sitting of the NCLT.
There is a sitting.
On 31st August 2026. With a direction to the NCLT to consider the application to protect the properties, subject matter of the resolution professional and pass necessary orders.
May I request for one,
yes.
If there is a direction to R2 to basically render accounts
in a disposed
on the
matter, we
assets
can't
itself.
do that against a private party because this matter will continue to be disposed. After disposal, can we do that? If it was at least the RP, yes, we
It was
could
only
have done.
under 227 because if orders were passed on 20th, then I would have definitely
They're
been
passing
entitled
orders
to it.
for respond number 1, not for respond number 2. Can't do that for respond number 2.
May I just persuade your lordship for one more relief? May respondent number 1 be directed to provide all the details that we have sought in our memo on 20th of
The
August.
respond number 1 would needless to say, respond number 1 would be obligated to furnish all such details relating to the transaction and sale as may be sought for and available with respond number 1 on the direction issued by the NCLT. Yes.
Hand delivery of the order, your lordship.
31st, no. Tomorrow you'll get it. Don't worry. Yes.
Obliged.
Last four matters. List number 1, serial number 2, Babu DR.
None appears for the petitioner, though called twice, once in the morning session, once in the afternoon session. Relist on 22nd September.
Serial number 31.
Yes,
I appear on behalf of the Olympic.
you're back.
Yes, my lords. My lords, I've just received the copy of the petition. I'll seek instructions on the same and file my wakalatnama as well.
We'll have it tomorrow. Now the issue is this. This is even worse than the earlier one. TTFI has already been superseded.
Yes, my lords.
Paralympic, you have now constituted a committee.
Yes, my lords.
The committee is to look after.
Yes, my lords.
Instead of that committee looking at the earlier recommendation made by TTFI just before it being superseded, that had been sent to the POA. POA is Paralympic Association.
Yes, my lords.
And they have writing
We have sent it to the
same downstream, nobody is responsible.
Yes,
That has reached the International Olympic Committee.
And everything goes to the sea.
As far as I have gone through the notification, my lords, I believe that I am in connection with the International Table Tennis Federation. I have to make a mechanism for selection. And I've just received brief instructions that I have already written to them, but detailed instructions I'll get and I'll produce this.
This is serious for the reason that you yourself have said
Yes, ma'am.
that this federation is not functioning properly,
Yes, ma'am. The notification.
including the selection.
I'll just go through the petition. I'll seek instructions and file it.
When you have come to a finding that they are not doing, MIAs has come to a finding that they have not done, and they've appointed you
Yes, ma'am.
as ad hoc,
Yes,
they've asked you.
I understand. Ma'am.
Go through. You should have at least applied your mind to see if the athletes are taken care of and the correct persons are selected.
Yes, ma'am.
That responsibility you owe.
Indeed.
You can't say they also do that. That's what Mr. Raikote also told you. They can't just forward it on downstream. I'm not responsible.
Because the Table Tennis Federation has forwarded it to us. They have selected authority is the Table Tennis Federation, not us.
All these federations say we can do what we want. And you are supposed to be the checks and balances for all of them. And all of you come forward and say we are not the check and balances. You say you are the check and balance, not the then why are you there? You can say it directly.
Because they are not the main authority.
Then why are you? That is exactly true. Whatever. If he has done his duty. B sends to C, C has to verify if B has done the duty. May not be A, but at least B. If it goes to D, D has to check whether C has done the duty.
That material we have saying the rankings are there, and as per the rankings, they have sent and we have forwarded. The ranking of the petitioner, above the petitioner, is one more person who is in rank,
But
who has
my
not
lords,
been sent.
eligibility comes, my lords, first the medal criteria, my lords. They have not taken that, my lords. Who has won the medal, my lords?
The ranking is given by the international.
I know, my lords.
This is
The
deja
same-
vu.
Yes.
Same argument.
Yes, my lords.
By ignoring the medal winners. Anyway, that other matter we are
Yes,
pronouncing tomorrow, so you will have your field day tomorrow on.
Indeed, my lords.
This you get instructions tomorrow.
Yes, indeed.
My lords, Annexure G, my lords, there is an appeal pending before the PCI, my lords. I have filed an appeal before the
Annexure
G, my lords. Page number 57, my lords. They are the authority to have an appeal, my lords.
I'll just go to-
What has happened to this appeal?
They have not considered it. Annexure G. 57 page.
Yes, Mr. Raikote. This at least is in your on your table.
Yes, that we can do because the rankings are there, we can give a reply.
This is not in your post box. This is on your table. What has happened to this?
Lords, I filed a memo, my lords, in that I have filed a memo yesterday. In that there is a selection policy of the TTF, my lords. In that there is, it says that no, if unresolved, the matter will be referred to the appellant tribunal of the PCI, my lords. It's clearly mentioned. No.
Where is the,
lords,
yesterday you filed a memo?
Yesterday, my lords.
Memo idea, no? Bharti, memo.
I'll give my copy, my lords.
You don't have that memo here.
Yesterday I given it. I'll give my copy, my lords.
This is the selection policy.
Yes, my lords. In the para 9th, my lords, if there is an appeal, para 9, my lords.
ಸ್ಪೆಲ್ಲಿಂಗು ಗೊತ್ತಿಲ್ಲ ಏನು ಬರಿಬೇಕು ಅಂತ. Appellate tribal. You have only 48 hours. Approved by para committee, table tennis Federation of India.
Distributed within 48 hours, it says, in the announcement. Announcement was on 30th of July. You have sent the list on 30th of July, 31st of July.
Till now, it's not published.
The International Association has asked us to send only 6, top 6 of the ranking. Top 6 we have sent.
No, my lords, there is
National Asian Committee. Asian.
First issue would be that when it is superseded.
Before that.
Yes, but it has been superseded for that very reason.
We don't know the reason.
Please see that order which has been placed on it.
Election.
TTFI has failed to adhere to the principle of good governance, transparency, accountability, democratic functioning. Besides repeatedly disregarding the directions and guidelines issued by the ministry from time to time. The governance deficiency and institutional failures have adversely affected the effective administration of the federation. Have the potential to prejudice the interest of athletes and the sport of table tennis in the country. What else do you require? Whereas selection policy of TTFI is framed on 9/5/23 as well as on 14/7/26 is a clear violation of the ministry's policy dated 5/3/25. Para 11. We don't need to get into anything at all. There's already a finding on this. And the very same selection in terms of that effective violative policy you have acted upon. Fundamental contraventions have been observed which not only raises concerns about fairness of the selection criteria put in place by TTFI, but at the same time is also disadvantages and put restrictions on some meritorious athletes who are regularly participating in the international circuit and having better world rankings. The release selection policy, being the only selection policy in force, does not address selection criteria for mega sporting events such as Olympics or Asian Games, notwithstanding that the qualification pathways for these events differ significantly.
from each country, my lord, the Asian Paralympic Committee has given the details as to from each country how many has to be sent.
Yes, Mr. Raikote. Okay, you are saying you came to know about it later to some, we'll come back to you later.
No, from each country, my lord, there are number of candidates to be sent and to be sent is given by the Asian Paralympic Committee in Japan. This time it is to be held in Japan. They have sent us the list to India as to each country in Asia as to how many participants in table tennis are to be sent. As per this, India six have to be sent. We have sent 6.
Who has given you those 6 names?
As per that 6 names also, my lord, the Asian Paralympic Committee use the international ranking, the Asian ranking. As per that only we have to send.
You have done a verification?
Yes, my lord.
Place that verification tomorrow on record.
Please, my lord, I'll place.
Place that verification. And have you considered all the things? And is it the same as, please remember this, if it is the same list as what has been sent by TTFI,
Please.
TTFI policy has already been held to be bad.
Please.
And if your selection is the same, then your actions are also bad.
If the selection is the same, my lord, then because my lord, we have sent it before the 12th August. 12th August order is passed by the government of India, my lord. Before that, my lord, 12th August, we have already forwarded it to the International Federation.
You are trying to make an artificial distinction on those dates,
No,
which
no,
is
no,
completely.
we have not given the dates. They have given the dates, my lord. The Japan committee.
You are
has
the
sent us
one
the
mentioning the dates, which is artificial for this purpose. What is under consideration is the selection policy and the selection made, not the last date of submission or your sending. If the selection policy is bad, selection made is bad, it does not matter when it is sent. That is the finding given here.
on 12th August order. That is the finding of the government of India.
So you want to act against what the government of India has said?
No, we
Very
are not
happy.
acting against the government
You
of
are
India,
acting.
but
You are acting. You are acting against what the MYS has said.
that was before they said, my lord, we have acted.
That means you also have not verified anything.
No, because that, my lord, TTFI's federation is in Delhi. We are not verified whether they have sent it after that or before that.
But that's my limited submission as of now is para 17 of this notification, my lords. It requires me to form an interim mechanism in consultation with the International Table Tennis Federation. For the same, I have already written communication to them. I'll produce this.
What is the effect of this order?
Yes, my lords.
Mahesh,
I
you will have to
understand.
tell us because they are violating your orders.
My lord, till they form that interim committee, my lord, it would have to remain like a status quo, my lord. They would not be able to take any decisions until that ad hoc committee or that interim committee comes in.
No, what is your stand on the decision taken by the TTFI earlier in light of para 11 of your order?
My lord, based on what was observed, my lord, during the previous elections, this decision was taken based on the policy that they were adopting at that point of time. This decision was taken, my lord, because it did not seem to be very fair in the manner in which the selections were being made, and there were several complaints which were received, because of which, my lord, this order came to be passed.
Right. Now that you have recognized that TTFI is not, their policy was bad and they have not even acted as per the bad policy, what happens to those selections? Is it to be redone? If it is to be redone, who is going to redo it and what is the time period in which it is going to be redone? Because ex officio, after hearing everybody, you passed a reasoned order.
True, my lord. My lord, though this has been in consideration for some time, my lord, the order itself, my lord, has been passed on 12th of August. So if the third and fourth respondents, my lord, were to place before the court the recommendations they received from the sports body and their communication there afterwards, my lord, it would really help.
I will direct them to place, but you will also have to make your stand clear because this is your order.
I will do that, my lord. I will make those submissions tomorrow.
See, Snail Belani, Snail, right?
Yes, my lords.
Snail Belani accepts notice for respond number
3.
3. Registry is direct print his name as such. and correct the appeal of Shri Praveen Kumar Raikote is that appearing for respondent number 4 to 6. A memo with enclosing an order dated 12/8/26 of the Director Sports, Government of India, Ministry of Youth Affairs and Sports has been placed on record as relating to the suspension of recognition granted to Table Tennis Federation of India as a national sports federation with immediate effect. In the said order, it has been categorically observed that due to serious concerns regarding the effective functioning of TTFI in accordance with Constitution and the obligation expected of a recognized national sports federation, particularly in relation to athlete welfare, transparency in selection process, access to competitions, grievance redressal and overall administration of sport. A show cause notice had been issued on 30/6/2026, which was replied to on 7/7/26. And on consideration of the show cause notice and the reply notice, it was held in para 11 that the selection policy of TTFI as framed on 9/5/23 as well as on 14/7/26 is in clear violation of the ministry's policy dated 5/3/25, wherein some fundamental contraventions have been observed, which not only raises concerns about fairness in the selection criteria put in place by TTFI, but at the same time is also disadvantageous and puts restriction on some meritorious athletes who are regularly participating at the international circuit and having better world rankings. The release selection policy, being the only selection policy in force, does not address selection criteria for mega sporting events such as Olympics or Asian Games, notwithstanding that the qualification pathways for these events differ significantly. Moreover, no mechanism has been provided in the TTFI selection policies concerning redressal of the athlete's grievance related to selection. Apart from this, there were several other deficiencies which have been noticed by the MYAS. And at para 15, after considering all the aspects and material on record, the ministry was satisfied that TTFI has failed to adhere to the functioning of good governance, transparency, accountability, and democratic functioning expected of a recognized national sports federation, besides repeatedly disregarding the directions and guidelines issued by the ministry from time to time. The continued governance deficiencies and the institutional failures have adversely affected the effective administration of the federation and have the potential to prejudice the interests of athletes and the sport of table tennis in the country. And in that background, the ministry suspended with immediate effect the recognition granted to Table Tennis Federation of India as a national sports federation for the sport of table tennis until further orders. During the period of suspension, TTFI was directed not to be entitled to any financial assistance, official patronage, or any other benefits accruing from its recognition as a national sports federation. In the meanwhile, for continuity in the administration of the sport and facilitate uninterrupted participation of Indian sportspersons in national and international competition, Ministry had requested the Indian Olympic Association, being the National Olympic Committee recognized by the International Olympic Committee, to take appropriate steps in consultation with the International Table Tennis Federation for constituting an appropriate interim mechanism, including an ad hoc committee. That being the background, it being clear that the ministry had issued the show cause notice on 30/6/26 and has held the policy, selection policy on 9/5/23 as well as 14/7/26 to be in violation of the ministry's policy dated 5/3/25. The selected list of candidates by the TTFI on Yavaga ಕಳ್ಸಿದ್ದು ನಿಮ್ಗೆ? When did I send it to you?
20th
20th of
July.
July. The selected list of candidates forwarded by TTFI on 27/2026 has been forwarded by the Paralympic Association to the
Asian Paralympic Committee, Japan,
Asian Paralympic Committee, Japan on
31st July.
31st July 26. This leaves many questions unanswered and the action taken by the downstream authorities questionable. It would be for the respondent number 1 to make its position clear as regards the action of such selection made by TTFI when proceedings were underway before the MYAS. The notice having been issued on 36/26, the final list having been forwarded by TTFI to Paralympic Association on
20th July.
20th July, stands in the teeth of the said proceedings, apart from being in violation of the policy, in violation of the policy of the ministry dated 5/3/25 as stated in para 11. The Paralympic Association would also have to make its stand clear as to what are the safeguards that the said association has taken and applied, in as much as it is required to act as a check and balance mechanism to the action taken by the TTFI, it being a downstream authority. The IOA is also directed to look into the matter and make its position clear, in as much as it is the IOA which is required to constitute an appropriate interim mechanism, including an ad hoc committee with the International Table Tennis Federation for the purpose of administration of the sport of table tennis and facilitation of uninterrupted participation of Indian sportsperson in national and international competitions, including the Para-Asian Games scheduled in
October.
2026. Relist tomorrow.
Indeed. The appeal before the PCI may be considered.
Learned counsel for the petitioner has further submitted that an appeal had been filed by the petitioner challenging the placing the grievances of the petitioner, which is yet to be considered by the respondents, though filed on the Paralympic Association, though filed on 18/8/26. Learned counsel for respondent number 4 to 6.
President Paralympic Committee, New Delhi.
ನೀವು ಯಾರಿಗೆ?
New Delhi.
ನೀವು ಬೆಂಗಳೂರಾ? ಡೆಲ್ಲಿಯಿಂದ ಎಲ್ಲಿ ಕರ್ಕೊಂಡು ಬರೋಣ ಇವಾಗ?
I'll tell them.
You are the Paralympic Association.
I'll tell them.
Filed on 18/8/26 is still pending consideration. The counsel for respondent number 4 to 6 is direct secure instruction making submission as regard the status of the said appeal.
Till tomorrow they shall not publish the list of the.
We can look at the decision making process. And we've told you we can't stop other people. We can see if we can send you, but we won't stop other people.
Yes. Grateful.
Please.
Serial number 38.
Appearing for the petitioner in this matter.
Yes, madam. Mr. Arbatti. Tomorrow preliminary hearing. Where is Mr. Arbatti? No point in
He was
relist
present
on 10th September.
Much obliged.
Passed over
Your
matters.
lordship kindly extend the interim order.
Interim order extended. Passed over.
List number 2. Serial number 8. Ravi L. Vaidya.
None appears. Released on 10th September.
May I be permitted to make a submission? Your Lordship, when I was on my legs before Your Lordship, the order got uploaded on the NCLT website.
What does it say?
They have not done anything to protect my assets, but only directed them to produce all kind of information.
Now the order has been passed, so you can challenge it.
They have
That
moved
is-
goods even after 20th of
That is
August.
because of Mr. Kamat's intervention. Probably.
But they have also moved goods after 20th of August, after the hearing.
It won't be proper for us to pass any orders.
In a general status quo,
Not in a disposed matter.
only to protect the assets.
Can't do that. Next, third.
May I file this order before
You can keep it with you. Why do you need to waste paper here? Yes, next.
13.
Yes, Mr. Satyanand.
ಸಾರಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಏನೂ ಆಗಿಲ್ಲ.
ಡ್ಯೂಟೀಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಡೇಟಾ ಮೈಗ್ರೇಷನ್ ಒಂದು ಆಗ್ಬೇಕಾಗಿದೆ ಕಾನ್ಸಿಕ್ವೆಂಟ್ ಟು ದಿಸ್ SIR duties my lord they are all
You know why this matter is not happening. The other matters it's happening.
no I don't know but this is the only matter where I am also stuck
This is not
that is what I
happening
was
because
that is what I was my lord telling my friend also
there is a golden goose.
that I should my lord retire from this case that is what
We
I
are
was
not going to permit you to do that.
but nonetheless, my lord, it is my okay
Both of us are locked in. We have to get them to do it.
ಡೇಟಾ ಮೈಗ್ರೇಷನ್ ಒಂದು ಆಗ್ಬೇಕಾಗಿದೆ ಕಾನ್ಸಿಕ್ವೆಂಟ್ ಟು ದಿಸ್ SIR duties my lord they are not ಅದಕ್ಕೋಸ್ಕರ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ
We'll direct the chief commissioner to depute suitable person for this. SIR is over.
SIR ಇನ್ನ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಈ ಮಂತ್ ಎಂಡ್
ಇವ್ರೇನು ಹೋಗೋದ್ ಬೇಕಾಗಿಲ್ಲ.
ಇವ್ರನ್ನ ಕೆಲಸಕ್ಕೆ ಹಾಕಿದಾರಂತೆ
Learned counsel for respond number Shri P.S. Satyanand, counsel for respond number 1 to 3 submits ಹಾಕ್ಬೇಕ that due to the officials of the respondents being busy in SIR duties, the necessary compliance could not be made. The chief commissioner GBA is requested to depute suitable person to take this aspect on a mission mode and war footing and get the required actions to be completed by the concerned authorities. Since the matter has been pending for nearly 3 years. If not for the submission made by Shri B.S. Satyanand, this court would have drawn adverse inference on the motives and malafide and would have passed necessary orders in relation thereto.
sufficient opportunities have been given that's right
Even though sufficient opportunities had been granted and the health officer had also appeared before
He's
this
also
court on 2 earlier occasions, as also the special commissioner had appeared before this court.
chief health officer he has got himself
Chief health officer, and as also the special commissioner had appeared before this court through VC.
the chief commissioner himself was
Chief commissioner, Mattinnenappa,
not special
and the chief commissioner himself.
in fact vendors were appointed everything is done ಈಗ migrate data old software ಇಂದ present software ಗೆ migrate data has to be migrated once that happens my lord we can take the printout of it and then
How long does it take, Mr. Satyanand? How long does it
the
take?
latest information what I have got from my IT cell
How long does it take?
no my lord
It doesn't take that much time. Chief commissioner himself had appeared before this court. Released on 11th September. It's made clear that no further adjournment would be granted.
after 15th my lord.
Released on 18th September.
Well, please
No further adjournment will be granted if compliance is not made by that day. This court will be constrained to draw adverse inference and pass necessary orders.
can I get an order
You will, everything will be uploaded tomorrow or
if I can get the order from the registry itself my lord.
registry is directed to furnish a copy of the above order to Mr. Mr. Satyanand, as also forward a copy of the order by email to the chief commissioner.
Please much
ಇನ್ನೇನಾದ್ರು ಬೇಕಾ?
sir ಸದ್ಯಕ್ಕೆ sir
Serial number 14.
Yes, Arvind, what has happened?
This matter, my lord, I have come to know about this. I just informed, my lord, this matter, my lord, requires GST Council's intervention.
Last time, that's what you submitted. It will be placed and you'll get the instructions on that. What has happened?
As of today, my lord, only thing is that, my lord, GST Council council is headed by finance ministry and it has to be, it has got members of both the central and the all the state government.
Right.
That has to meet. Now, I will.
They meet every month. You said it was going to be placed. They have to take a decision. It's a recommendation that you are going to make and it's going to be considered. Have you placed it before the council?
I'll take a
The
short
council for
accommodation of
respond number 8
2 or
seeks
3
for
weeks, my lord, I will.
and is granted 2 weeks time to obtain instruction, make a submission as to whether the proposal has been placed for consideration before the GST council and what action has been taken. If not placed, when it would be placed. Relist on 18th September.
Serial number 15.
The Jeevan also was supposed to. Where is Jeevan? 15 or 18, tell him 18.
230 mood matters. Ravi HK.
Same order as, same array of parties, the same Ravi?
Yes, my lord. The respondents, my lord, according to the Tahsildar details, my lord.
And AGA for respond number 1 to 3. Mohammed Shamir for respond number 4.
Yes.
AGA for 5, 6, 7. 1, 2, 3, 5, 6, 7.
May I pass on the copy of
the
yesterday's order?
jurisdictional Tahsildars, namely respective Tahsildars, respective jurisdictional Tahsildar 5, 6, 7.
May I pass on the copy, my lord.
Yes, Prathish.
By 29th, my lord, by tomorrow.
Same order.
Grateful.
IA 1 of 26 is allowed. 2 alone IA 1 of 26 is allowed. And AGA for respond number 1, Mohammed Shamir for respond number 2. Respond number 1 is Tahsildar. Between IA 1 and 2 of 26 is allowed.
Hand delivery, my lord.
Hand delivery. Hand delivery, yes.
Ye Venkat Satyanarayana. 230 mood.
Inna.
Appear for petition.
Yes.
My lord, the government is performing the 172 Jayanti of Narayan Guruji, my lord. And
we can't do this. We told you in the morning. We can't ask them who they have to invite and what they have to do.
yes, but my lord, there are 7 Swamijis in the community, my lord, in this community. 6 has been called and another one Swamiji, he has not been called up. And there is some
And AGA for respond number 1 to 4, petitioner is before this court seeking for the following leaves. By way of the above writ petition, the petitioner is seeking for a mandamus directing the respondent state to invite. And this is a public interest litigation, not even a private litigation. How can that be? To invite a particular Swamiji to a program to be conducted on 28/8/26. This court, while exercising its powers of mandamus, cannot direct who the invitee has to be on behalf, who the state has to invite to a particular function. That is left to the discretion of the state. And in that view of the matter, the petition stands disposed. Though also this court would have to observe that the present petition is not one in a private list, but in a public list. If the petitioner so chooses, he can also file a public interest litigation.
Pardon?
It's a private list, the public list.
Public function, my lord.
It can't come before a single judge. It should have gone before the division bench. But we can't issue a mandamus. Whatever they want to.
But it shows it is violative of Article 14.
Can we issue a mandamus?
Yes.
You know, you are a lawyer. You should tell us.
Yes.
Can a mandamus be issued saying who is going to be invited?
Much obliged.
Number 1, serial number 39. Sirajuddin Ahmad.
Yes, Mr. Aditya.
It's a passport matter, my lords. That's passport was issued, my lords, for reissuance of passport, my lords. So while I file an application,
Yes,
it
Mr.
came.
Aditya Singh. Yes, madam. Passport. Where is Aditya? I haven't seen him today.
In the last date of hearing, it was said that the case is pending, but when verified, my lords, it is the
Secure the records of CC 24775 Bandidia.
Received.
Received. Kodi adu. He's come today. Relist tomorrow. Ask him to appear tomorrow.
In the fresh matters.
Next.
40.
Shri Aditya Singh is a, who is going to appear? He is not filed wakalat. And he's not here also. What is this matter regarding? Mr. Sidhi?
Lord, this is regarding garnishee order.
By?
Garnishee order by the ESI. Sorry,
Yes.
EPF, sorry, EPF department.
EPF. Who appears for EPF?
And the issue is, Lordship may kindly see, there is a 36 lakhs order is the amount.
EPF is which respondent? ESI.
ESI, sir.
Aditya Singh appears for ESI?
I'll just verify, my lord. I'll just verify in this matter also.
Aditya Singh appear ಆಗ್ತಾರೆ ESI ಗೆ.
Appearing
Arti?
for Ram. Yes, sir. Geeta Devi.
So wrong with this one. Ms. Geeta Devi Paparna is directed to accept notice for respondent number 1 and 2. Registry is direct delete name of Shri Pramod B and Aditya Singh as that appearing for respondent number 1 and 2. You are for the bank, madam,
Yes, my lord.
Garnishi Bank. Counsel for the petition served 2 sets of the petition along with annexion on Ms. Geeta Devi Paparna.
Please, ma'am.
Released on 10th September.
Please.
41. VG Ravi Kumar.
Mr. Ravi Kumar.
Respondent in this case, ma'am.
Respondent number 5. None appears for the petitioner. Released on 22nd September.
42. MS Raghavendra
I
Prasad.
appear for the petitioners. Matter under the Senior Citizens Act, my lords.
Mr. Rajesh Rao.
Yesterday also it did not appear.
Ishak Banwara. Is not appearing?
It was listed yesterday. Nobody appeared.
Today also there is no appearance on part of, though the petitioner, counsel for the petitioner is present and ready to address his arguments. None appears for respondent number 5 and 11 as also 12. Today also. If none were to appear for them on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by counsel for the petitioner, released on 10th September. Great.
43. Nataraj Baba.
Both are challenging, my lord, the allotment issued to the fourth respondent.
43 L who appears.
43, my lord, if it appears.
Yeah, Nataraj Baba, na?
Yes, please, ma'am.
43, Shri Nataraj Baba has appeared for the petitioner, delete HN Vasudevan. Who appears for respondent number 1 here?
That in the first petition, the copy is not served to me, though I
Who
have
appears
been
for respondent number 1?
one. I don't have a copy.
Kasina Lingam, Jaikar Shetty.
I don't have a copy at all. Copy
ನೀವು ಯಾರಿಗೆ?
ಇಲ್ಲ,
The first petition.
Kasinalingam.
Kasina Lingam ವಕಾಲತ್ ಇದೆಯಾ? 43.1. Shri B.S. Srinivas has appeared for the petitioner. Delete the name of Ms. Neerja Karanth and Manjunath Hiral as that appearing for the petitioner. Aruna LV for respondent number 1. ಇದರಲ್ಲಿ ಯಾರು respondent number 1 ಗೆ?
Respondent number 1 is Union of India, my lord.
There are so many names which are shown, that is why.
Lord,
And none of them are there.
my lord, there's only 3 respondents here. Not sure why they've shown so many.
Aparna LV, Rajaram Suryambil, DSGI.
Union of India, Indian Oil Corporation. Respondents are only 3 in both the matters, my lord. Union of India, Indian Oil Corporation.
So now you don't have copy in the first matter.
In the
43.
first matter, I don't have.
You appear in 43.
Please, my lords.
Give him copies. Second matter you have.
I have, and according to me, the second matter had rendered infructuous. If it is to be taken together, I have no objection.
Take it up together. In the first matter, you serve him a copy.
Please, my lords. I'll serve the
43
copies.
counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures on the respective counsels for the respondents, who are granted 2 weeks' time to file the
You
respective
lost me,
statement.
grant me 4 weeks' time.
4 weeks' time to file the respective statement of objection. Objections, if any, to be filed on or before 25th September, released on 29th September.
44. As Shilpa Saroda.
Annexure age, the order passed by the land tribunal.
Venkatesh Arbatti.
ಆಗ್ತಿದ್ಯಾ ತೋರ್ಸಕ್ಕೆ ಆಗ್ತಾ ಇದೆಲ್ಲ ಬರ್ತಾ ಇಲ್ವಾ
We don't want to record that he's not there.
No, no, I was informed he's on his legs in another court, my lord. I was just informed.
Pass over other reach agala. Released on 10th September.
45.
Respondent number 2 in this case, Your Lordship. This is a senior citizen matter. I filed my objections to it.
Ready?
I'm ready.
Ready.
Lords, the daughter's lords release date lords is cancelled by virtue of lords the petition that has been filed my lords by the father. Lords, the facts are this my lords that earlier my lords the will was done in favor of the daughter.
Petitioners are the daughters of respondent number 2.
Petitioner is the daughter my lord.
There are two
Petitioner number 1
petitioners.
is the daughter. The petitioner number 2 is the husband of the daughter. Petitioner number 1.
Why is she a party?
The respondent my lords have made them as a party my lords in the petition.
Yes.
Lords, now my lords, the facts are this that my lords, by virtue of a will my lords earlier, the property was my lords bequeathed my lords in favor of the petitioner daughter. Thereafter my lords, will was cancelled.
When does it come into effect?
No, after the death my lords of the father and the mother. It was joint will my lords by father and
Whose
mother.
property is it?
It is the property of the father by way of a grant. Thereafter my lords, will was cancelled my lords, we have no issues. Lords, in the will my lords, there was a recital also my lords that certain amounts were received my lords by the father. Lords, insofar as the property is concerned. Thereafter my lords, release an agreement was made. Insofar as the fathers is concerned, the other brothers are concerned who are staying with the father, and with same my lords 17.5 lakh rupees is given to the father, and my lords it is acknowledged by all of them, and they have given lords the no objection my lords to transfer the property. On that basis my lords release date is done on 6/12/2024. On that basis my lords the transfer of property and khata my lords RTC is all entered upon. Now my lords, if my lords see the petition at annexure F page 30, lords the entire pleading my lords first was based on the will that was granted my lords, saying that basis on the will the property is
Where is the application filed?
lords page 30 my lords annexure F.
Yes.
Lords, that was my lords the petition that was filed seeking my lords under appeal under 136 clause 2 of the Revenue Act read bin 151, and then section 23 was added on. Lord, which entire pleading my lords is on the will and not on the settlement deed. After my lords we filed appearance my lords, an application was filed my lords for amendment seeking my lords inclusion of additional prayer as well as additional lords, grounds. Lords, if I may just pass the my lords, I have not recently my lords, when we saw my lords, we found out that there was an amendment that was made my lords to the petition, whereby my lords these settlement deed paragraphs were added into the entire my lords order of the assistant commissioners talks about the will that is there, and also my lords the assistant commissioner passes a reviewing order my lords, saying that no the document that is cancelled is not the will, it is a settlement deed that was given by the father insofar as petitioner is concerned. Please lords, this is the
Sorry.
give you the so don't have to. Lords, if my lord see the petition my lords application order 6 rule 17. Now my lords paragraph 10 and 11 my lords, now it is added by virtue of saying that the appellant had filed this petition cancellation of will bearing number so and so dated so and so, consequently to seek cancel of mutation entry so and so. The Tahsildar Bhadravati Taluk, since first respondent, second respondent got changed the mutation of property bequeathed under joint will executed by the appellant G. Bhairappa, his wife Srimati so and so. Enough, even though both the appellant and his wife Gaurama were joint owners of the said will with joint interest in the said land, have jointly executed the will bequeathing this property in favor of respondent number 1 and 2. Applicant's wife Gaurama, even one of the executant of the will, died on 6/2/24. Even though one of the joint executant present applicant is alive, respondent number 2 got change in mutation entry of the properties by so and so. Thereafter, ill-treating the applicant, neglected to maintain him as assured by the first and second respondent at the time of execution of the will. Therefore, appellant got cancelled the will under document so and so. Since the will was cancelled, the petition become infructuous. It is submitted that applicant came to know that respondent number 1 was also obtained registered relinquishment deed with respect to petition scheduled property and registered document number so and so dated so and so in the office of sub registrar Bhadravati. By playing fraud, the applicant has no other property or income to maintain himself. The first respondent, who is bound to maintain the petitioner, who is aged father, who is senior citizen of 75 years age. It is submitted that first respondent is not providing food, clothing and shelter to the applicant from whom she obtained the relinquishment deed by now, my lords, the ground, my lords, of fraud is also involved. Lords, when section 23, my lords, the provisions are invoked. Lords, the first essential, my lords, as my lords have held, my lords, that conditions are required. Lords, now the question of when the fraud comes into play. Lords, the respondent, my lords, ought to have, my lords, filed a civil suit. Lords, before the trial court, my lords, seeking appropriate relief. Lords, because he says, my lords, I did not know about the settlement deed that is done. Lords, when it is registered, when it is before the sub-registrar and everything done, my lords, and accepting amount. Lords, if there is an agreement, my lords, that is also placed on record. My lords, that Annexure D, page 24. Lords, prior to the will also, my lords, there was an agreement that is entered. If my lords see page 24, Annexure D. Where, my lord, 17,25,000 was given to the father of the respondent, my lords, and also the no objection certificate, and
24 is Kararupatra.
Lords, Kararupatra.
Agreement
Lords, please. Lords, the Kararupatra, insofar as the property is concerned, thereafter, my lords, will was executed on 3/8/23. Thereafter, will was cancelled. Thereafter, registered sale deed was registered release deed was made in favor of the petitioner. Now, my lords, if my lords see the will that is placed on record, my lords, by way of the statement of objection, the will clearly states, my lords, about the amount that is received by the respondent.
Page number?
Lords, in the will, my lords, page annexure R1, page 12, my lords, is the will. Page 13, my lords, is the recitals.
The
If my lords-
registered will.
Registered will. If my lords, I read. ನಮ್ಮ ಮಕ್ಕಳೇ ಮತ್ತು ನಮ್ಮ ವಾರಸುದಾರರು ಯಾವುದೇ ರೀತಿಯ ಗಲಾಟೆ ವಿವಾದಕ್ಕೂ ಅನುಭವಿಸುವ ಉದ್ದೇಶದಿಂದಲೂ ಹಾಗೂ ನಮಗಿರುವ ಎರಡು ಜನ ಗಂಡು ಮಕ್ಕಳಿಗೆ ಹಣಕಾಸಿನ ವ್ಯವಸ್ಥೆ ಮಾಡಿದ್ದು, ಆ ಬಗ್ಗೆ ಅವರಿಂದ ಹಣ ಸಂದಾಯ ಖರೀದಿ ರಶೀದಿ ಪಡೆದ ಮೇರೆಗೆ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತುಗಳು ನಮ್ಮ ಮಗಳಾದ ದ್ರಾಕ್ಷಾಣಿ ಎನ್ ಗಿರಿಜಾ ಹಾಗೂ ಇವರ ಯಜಮಾನ ಚಂದ್ರು ವೈ ಬಿನ್ ಯಲ್ಲಪ್ಪ ಇವರುಗಳಿಗೆ ಸೇರಿರುವ ಬಗ್ಗೆ ನಮ್ಮ ಇಚ್ಛೆಯ ಬರೆಸಿಕೊಟ್ಟಿರುತ್ತೇವೆ. ನಮ್ಮ ಮರಣ ನಂತರ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ಖಾತೆ ಪಾಣಿ ಹಾಗೂ ನಮ್ಮ ಮಗಳು ಮತ್ತು ನಮ್ಮ ಅಳಿಯ ಸೇರಿ ಜಂಟಿ ಖಾತೆ ಸಂಬಂಧಪಟ್ಟ ತಹಸೀಲ್ದಾರ್ ಕಚೇರಿಯಲ್ಲಿ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಅವರ ಇಷ್ಟಾನುಸಾರ ಅನ್ವಯಿಸಿ ವ್ಯವಹರಿಸಿಕೊಂಡು ಹೋಗುವ ಹಕ್ಕುಗಳಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಪ್ರಶ್ನಿಸುವ ಹಕ್ಕು ನಮ್ಮ ಎರಡು ಜನ ಮಕ್ಕಳಿಗಾಗಲಿ ಇತರ ವ್ಯವಹಾರ ಯಾವಾಗ ಇರುವುದಿಲ್ಲ. My lords, will is not denied. It is cancelled, my lords. It is not denied. Now, my lords, when the agreement is entered, my lords, a month prior to 3 days prior to the will that is now given, my lords, as per annexure R1. Lords, it shows that, my lords, the petitioner has given 17.5 lakh rupees to father insofar as release of property is concerned. Now, my lords, the question of fraud, my lords, and not taking care. When, my lords, the petitioner has having paid, my lords, her father of 17.5 lakh rupees. Lords, the question of, my lords, not knowing about the property, nor
What is the value of this property now?
Lords, 1 acre 30 guntas is the property, my lords, in Bhadravati Taluk, Kasaba Hubli, Hansettu Junction, survey number 42. Lords,
Hanaspate Ramada, survey number 42.
42.
What is the value of this property?
Lords, that I have to seek instruction, my lords, as on today, what is the valuation?
For instance, 70 lakhs. 70 lakhs as on date.
70. Yes.
Now, my lords, father, my lords, have also, if my lords see the next, my lords, I have the paper which I passed
So
on.
how
now.
much are you willing to pay as maintenance?
Lords, my fix 15-20,000, my lords, until
15-20,000 big
lords,
money.
because 17.5 lakh rupees, my lords, I've already paid.
Indian, what do you do?
Please,
What does your husband do and what
lords,
do you do?
agriculturist. Everyone, my lords, relies on this agricultural property of 1 acre 30 guntas. Nothing
So
else.
you don't have any other property.
Any other lords, I can put it on record, my lords, that I don't have any other.
So what have you been doing till now?
Lords, this has been in occupation, my lords, with the daughter itself, my lords, was the submission. My lords, even
What
before.
has your husband been doing to take care of it from the father-in-law's property?
Father, lords, that I can, my lords, I'll seek, my lords, may have it tomorrow.
That itself goes against you as bona fides.
Lords, my lords, may have it tomorrow only, my lords, I'll seek what.
Because there's no way you would have got 17.5 lakhs from anywhere else from this property.
Lords, because.
Where did you get 17.5
Lords,
lakhs?
the husband, my lords, has arranged, my lords, amount from his family and given it to, because, my lords, it is in occupation of them since their marriage. That is the.
Show us the records of where you got 17.5 lakh rupees. Tomorrow you show us the record, whenever you show us the record, that you had that money. By saying only I paid, getting them to sign will not help you.
Please, my lords, what some maintenance, my lords, I'll also ask, my lords, my client, what can be done.
Based on record, how do you go, what are the other properties in your name that you own? One.
Lords, and
Two.
other properties are also with the father. He has given it to the
That
son.
is their properties, not yours.
My lords, it is transferred to the son.
Yeah, it's their wish.
My lords, now, my lords, the daughter is being treated like this, my lords, on the instance of father. Lords, I have produced the MR entry of 1 acre 15 cents that is transferred.
It makes sense why the son-in-law has made party.
Lords, it is.
That was the first question we asked you. Now it
No,
makes sense.
it is not done by me. It is done by them, my lords, because.
Don't make us say things that,
My lords,
though true, we would not want to.
I will, my lords, endeavor, my lords,
Yes,
what
sir.
amount can be done, my lords, to be paid to them.
After arguing for some time, the counsel for the petitioner seeks for and is granted a week's time.
Lords, may I have it tomorrow only, my lords, I'll seek instruction and see what can be done, my lords.
Seeks for a day's time to indicate how much money do you need.
I would argue release wherein they see that money is not been received.
Executed so many documents.
I am an old man. I don't even know
So
how.
you'll go on executing.
I am not. The reason why I am at the verge of dying.
That is what is the maintenance that is required?
I will seek instruction.
Counsel for the petitioner seeks for days time to ascertain the amount of money that the petitioner is willing to make payment as maintenance to the respondent number 2. So also the counsel for respondent number 2 seeks for a day's time to ascertain the amount required as maintenance for respondent number 2. Shri Azhar Ali Faluki has entered affairs for respondent number 2. Delete the name of Shri Shravan Bharadwaj as that hearing for respondent number 2. We list
And
tomorrow.
top of the list.
Lords, may I have it Monday at 2:30 minutes?
Monday 2:30.
Please, grateful.
Yes.
46.
Much of it.
Lords, interim order, my lords, as to.
Interim order earlier granted is extended.
For the respondent number 2.
Hearing for petitioner lordship.
ಇಲ್ಲ ಇದು ಥ್ರೋಬಾಲ್ ಬಂತ
Global Federation, in fact, not the prayer now will not survive, not. They had challenged the renewal certificate issued to the respondent for the year 2025. Not after a detailed inquiry, not as per Annexure A.
Lordship, my main contention
Now-
is the registrar did not have the power to
Now
usurp
another-
the jurisdiction of civil court, your lordship, and to conduct an inquiry in the manner as suggested, your lordship.
ರೆಡಿ
Already now objection ಹಾಕಿದ್ದೀನಿ.
ರೆಡಿ ನಾ ಆರ್ಗ್ಯುಮೆಂಟ್
ರೆಡಿ.
ದೇ ಹ್ಯಾವ್ ಟು ಸ್ಟಾರ್ಟ್
ಆಯ್ತು. ಅಲ್ಲ ನಾನು ಜಸ್ಟ್ ಹೇಳಿದಂದ್ರೆ
ಜಸ್ಟ್ ಹೇಳಿ ಅಂತ ಹೇಳಿದ್ನಪ್ಪ. ಜಸ್ಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಮಾಡಕ್ಕಾಗತ್ತಾ? ಅವ್ರು ಕೇಳ್ಬೇಕು, ನಿಮ್ಗೆ ಕೇಳ್ಬೇಕು, ಇಬ್ಬರದೂನು.
ಅಲ್ಲ ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು ವರ್ಷದ ಎಲೆಕ್ಷನ್ ಆಯ್ತು, ಎಲ್ಲ ಆಯ್ತು. The prayer itself doesn't not it's infructuous now. Now we have submitted another. They have not filed any objection to that. Renewal certificate is granted to the respondent for the year 2026. Not I have produced along with my objection. The prayer itself has become connected.
Lordship, my limited-
Page 63, not annex. Page 63. This is the renewal certificate issued for the year 2026-27. Along with the office bearer list. ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಹಳೇದು. ಹಳೇದ್ರಲ್ಲಿ 2025 not a detailed inquiry was held, and it was held that not for the last 30 years the respondents are the original association.
That is what they have challenged.
Lordship, my
For the year
main,
2000, not every year elections are held. They had challenged for the year
Correct.
2000.
If that order which has been passed next time that you challenge earlier order is res judicata, tha na? That is what you would have said. So this order has to be challenged. For next time, it has to be challenged. How will it become infructuous?
Not even in the year 2022 also they did, 2022 also they did the same thing. Not then, they themselves withdrew the writ petition which I have filed here, because they subsequently there was the election. Not every year, not though there is a finding recorded even in the year 2020.
Okay, get a proper finding and close it so that it doesn't come back again for you. If they have a good case, they will succeed.
After a detailed, my next, let them start. Please.
Lordship, the fundamental question that is raised in this writ petition is whether the respondent number 1 has the jurisdiction pass the impugned order as.
What are the facts, madam?
Lordship,
Start with the facts.
I am a federation, Your Lordship. I am established in the year 1989, Your Lordship.
Hmm.
Since from the year T. Ramanna was occupying the office without elections. Initially, there were no elections conducted, though there were many representations made, Your Lordship.
Hmm.
Then, according to the annual general meeting on 21/5/2017, the list of elected candidates were sent to the registrar by Prahlad Joshi, which is his annexure D, page 32, Your Lordship.
Hmm.
Again, the representations were submitted for calling general body meeting from 28/12/2019 to 2/1/2020, which is at annexure E, Your Lordship, page 34. Now, acting upon the same notice, notice dated 16/1/2020, it was issued for conducting of general body meeting on 2/2/2020, and on the same day, a requisition was made for appointment of observer, which is at annexure F. The general body meeting was conducted on 2/2/2020, and the minutes of the meeting were recorded, wherein few members were suspended, and the said committee was dissolved. Now, K. Raman Kumar Sahani was appointed as the interim general secretary. The same is it is at annexure G. Now, several letters were issued to the suspended members by me, Your Lordship, for handing over the historical records, but the same was never handed over to me, which is at annexure H, H1 and H2, Your Lordship. Now, with the aim to conduct elections, the interim general secretary Raman Kumar Sahani on 25/1/2021 addressed all affiliated units of Throwball Federation of India to send 2 representatives for the next meeting, and the same is at annexure J. Now, the elections were accordingly notified while notification dated 25/2/2021, wherein Mr. Pawan Kumar was appointed as an observer by the registrar, which is at annexure K, page number 66, Your Lordship.
Yes.
Accordingly, on 2/3/2021, the governing body was duly elected for the next 4 years, which is at annexure L. Now, the amended rule specified that there shall be 22 elected members in the committee, which is at annexure N, page 77. Then, out of nowhere, Your Lordship, on 19/3/2022, the respondent number 1, by relying on the forged document submitted by Mr. Govindraj, who is the respondent number 2, passed an order for cancelling the acceptance certificate dated 2/7/2021, which is issued to the petitioner committee, which was challenged in WP 9404 of 2022, Lordship, which was later withdrawn by us, Your Lordship. Now, for the upcoming term, the general body meeting was held and notice was issued for scheduling elections, which is at annexure R, page number 94, Your Lordship. The elections were conducted and the petitioner committee was elected along with 22 members, which is at annexure S, page number 96. Now, Your Lordship, such being the case, what the respondent number 1 has done is, again relying on the document submitted by Mr. Govindraj, he has discarded the petitioners committee and he has given discarded the petitioners committee and he has recognized the committee of respondent number 2, Your Lordship. Now, this respondent number 2 always keeps coming out in picture, submitting certain documents. And Your Lordship, it is pertinent to note that certain documents which were not available with us, which were with the suspended members, we had repeatedly called for the records, Your Lordship, by annexure H, and thereby the same records were not available to us, Your Lordship. Now, the main crux of the matter is, Your Lordship, whether the respondent number 1 can, while exercising his jurisdiction, Your Lordship, can cancel my acceptance letter, Your Lordship. Now, for that, I may be permitted to read Section 25 of Karnataka Societies Act, Your Lordship. Inquiry by the registrar. The registrar may, on his own motion, and shall, on the application of majority of members of the governing body of not less than 1/3 of the members of the society, hold an inquiry and direct some person authorized by him by order in writing in accordance with the rules made in this behalf to hold an inquiry into the constitution, working and financial condition of a registered society. Now, from the above, Your Lordship, it is clear that respondent number 1 can hold an inquiry under Section 25 of the Act, either on his own motion or on the application of the majority of the members of the governing body, or on the application of not less than 1/3 members of the society. But in the instant case, Your Lordship, the complaint is only by respondent number 2, without there being any backing by the other members. And in the perusal of the impugned order also, it makes it clear that inquiry is not initiated by respondent number 1 by taking suo motu action. That being the case, the very basic ingredient for initiating the inquiry is absent in this case, Your Lordship. Secondly, Your Lordship, on perusal
The
of
case
section...
laws on that point, madam.
Lordship,
Have you seen the case laws on that point? All your arguments are contrary to the judgments which have been passed by this court.
Lordship, I'll furnish
Each and every
citations to that.
contention that you have raised is contrary to the judgments.
Milords, I will furnish citations to that effect, Your Lordship.
You have not seen the judgments on this.
Lordship, I'll just produce on the next occasion.
Just don't go by what pleadings are. You have to look at what the law is. Counsel, after arguing for some time, land counsel for the petitioner seeks for and is granted 2 weeks time to get ready and address arguments. Is there like a Secretary General, Indian Olympic Association Act party matter? Why have you made?
ಬೇಕಾಗಿಲ್ಲ ಅವ್ರನ್ನೆಲ್ಲ. I don't know why they have made Olympic association.
Lordship,
Purely-
respondent number 1 has not filed objection also.
I have filed.
1-1.
Olympic association ಬೇಕಾಗಿಲ್ಲ ಅದರಲ್ಲಿ.
Yeah, India.
ಅದೇನೋ tournament ಇತ್ತು ಕಾಣಿಸುತ್ತೆ.
Snail, so and so. The director, Snail Belani, is directed to accept notice for respondent number 3. Registry is directed to interest name as such. After arguing for some time, land counsel, so and so.
Date may be-
Released on 22nd September. Please read the judgments properly.
Yes, sir.
With your kind permission, my lords. With your kind permission, my lords. My lord, serial number 41. Due to technical glitch, I was unable to open the camera, my lords.
This 41 has been adjourned.
Yes, my lords. The respondents, all the notice have been served, my lords, but they have failed to file their objections. At least the
Not
direction.
now,
to the
madam. Not now. Nobody is there of that matter. Well, you can't pass any orders.
I shall inform them, my lords.
So, Kodi.
47.
At
Your
least a
lordship,
short interview, my lords.
The date has been given, madam.
Great.
Your lordship, this petition is filed seeking directions to the passport authority to renew the child's passport. The child is a minor currently residing in the US with the mother, whose passport is expired in January 2026. And the visa is valid till September 20th, which is like next 20 days. In the event the passport does not get renewed, the child may be deported back to India. The mother is a divorcee, your lordship. There is no responsibility taken from the husband, or no custody, no participation, no communication. The child resides with the mother in the US as of now. 11 years old, studying in 5th grade, resides at Arizona, your lordship. The mother is a working woman with Infosys, resides in the US. She has a valid passport till 2050 and on a H-1B, requesting
What
for the
happened
orders.
to
for
your
the-
service of notice on Rakesh K?
Your lordship, the opposite parties never appeared, neither in the lower courts.
What
neither-
happened? You were directed to serve intimation of this petition along with copies of the proceedings and this order to Shri Rajesh K on his last known email and file an acknowledgement.
It is done, your lordship. I'll just.
Where is it? When did you file it?
Your lordship, the email was sent on. 2025 November itself, the email was sent, Your Lordship. I'll just check for the records and have them submitted, Your Lordship.
So the order itself is dated 19th
To
February.
Your
Can
Lordship,
we-
I'll check for the records and have them
We
submitted,
have to
Your
comply
Lordship.
with this order of 19-2. Have you complied with it?
I'll have to check on that, Your Lordship. I'm really sorry for that.
My lords, one humble submission.
Yes.
My lord, the writ petition does not survive, my lord, because
Why?
the petitioner again approached the respondent authorities on 23rd of January 2026. Short validity passport has been given for a duration of 28/1/2026 to 27th of January 2027, my lords.
You already issued.
Yes, my lord. So far as this application.
Now why
also-
short validity? If they are divorced, then there should not be any problem.
But this application does not survive, my lord, because based on this application, I've already issued a short validity. So I cannot
Again, in another 3 months, they have to come back.
But is this on the request made by the petitioner here in my lords to issue a short validity, my lords? We
They
have
asked for a short validity.
Yes, my lord. She
We've asked for a
approached
short
the
validity.
That has been given then.
It's not received, Your Lordship. I'll follow up and collect it in that case.
no, my lord. She's already collected and she's taken the child to US.
When did you last
The
contact
child
your,
is taken to the US, Your Lordship.
when did you last contact your client?
She's been in constant touch, Your Lordship. Last week I had a discussion with her on this.
Counsel for respond number 1 submit that a short validity passport was issued on
My lord, she approached the office on 23rd of January 2026 and requested for a short validity, my lords. The validity is being issued, the passport is issued for a validity of 1 year from 28th of January 2026.
28/1/26 to
27th
to
January
27/1/27.
Please.
Counsel for the petitioner seeks for a week's time to obtain instruction, make a submission, relist on 10th September.
Thank you, Your
Already
Lordship.
issued, then nothing.
Much obliged, Your Lordship.
48. Ganapati CV.
My lordship, I am appearing for the
The
petition.
respondent number 3, madam.
Ready?
No, place time.
At the request of counsel for respond number 3, relist on 22nd September. End of the list.
And 430 matter.
430.
List number 2, serial number 22. PL Sanjeev.
22, my lord, lordship, recollect. This is the recognition of the schools, private schools.
ಇದ ಅವಾಗ್ಲೇ ಮೆನ್ಷನ್ ಮಾಡಿದ್ ನೀವು ಸರಿಯಾಗಿ ಹೇಳ್ಬೇಕಿತ್ತು. You are waiting for this from that time.
Literally.
ಅದೇನಾಯ್ತು?
Substantial complaints has been done. 22/7, my lord, the demo has given before lordships. Since there was 22/7/2026, that demo has been given before this honorable court. Substantial
Madam
complaints.
wanted to do something and
Yes.
again get.
And in the meantime, my lord, there was no particular, I mean, there was no minister some extent. And that 4 weeks we may able to do it completely, my lord.
22 land
22.
AG seeks for and is granted 4 weeks time.
Therefore, we comply.
Relist on 30th September.
Please, ma'am, before that we'll comply. Please.
Serial number 51, it may be, date may be given tomorrow. There, in spite of the cases has been closed, my lord. For rowdy shit, they are calling, my lord. The last.
It will be given.
Tomorrow, my lord.
Serial number 57.
Tomorrow.
We adjourn.
Serial number
because
96,
you are
my
not-
lord.
57 directions have been complied.
Serial number 96, my lord.
ನಂಗೆ ಇನ್ನೂ ಒಂದು ಕೊಡ್ಬೇಕು, 2 ಕೊಡ್ಬೇಕು ಅವರು. Page wise ಒಂದು
Tuesday,
ನಿಮಿಷ.
2:30. 2 times it's not reached, only for.
Page
orders
11,
and
serial number
employee.
50 to 55.